ನಂಬರ್ ಇಲ್ಲ, ನಂಬರ್ ಹಾಕಮ್ಮ ಸರ್.
ನೆನ್ನೆ ಹಾಕಿದ್ರೆ ಬಂದಿಲ್ಲ.
ಸರಿ ಇಲ್ಲ
ನಾಳೆಗೆ ಮೆನ್ಷನ್
ಬಂದಿಲ್ಲ, ಕೊಡ್ತೇವೆ. ನಾಳೆ ನಾಡಿದ್ದು 2 ದಿನ.
ನಾಳೆಗೆ ಸ್ಯಾಟರ್ಡೆ ಬರುತ್ತೆ
ಕೊಡಿ.
ಕೊಡಿ ಸರ್, ಕೊಡಿ ಕೊಡಿ.
ಆ ಕಡೆ ಹೋಗಿ ಕೊಡಿ. ಹಲೋ,
ಹಾಕಿರ್ತೀವಿ ನೋಡೋಣ. ನೀವು ಫಾಲೋ ಅಪ್ ಮಾಡ್ಬೇಕು ಸ್ಕೂಟ್ನಿ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ. ಬೇಡ
ಎಲ್ಲ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ, ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಅರ್ಜೆನ್ಸಿ ಇದೆ, ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕೊಂಡ್ಬಿಡ್ತಾರೆ ಅದಕ್ಕೆ. ಎಷ್ಟು ನಂಬರ್ ಇದೆ? ಅಲ್ಲ, ಇದಾದ್ಮೇಲೆ ಕೊಡೋದು, ಮೆಮೊ ಕೊಟ್ರೆ ಅವ್ರು ನಂಬರ್ ಮಾಡೋದು, ಅದಕ್ಕೋಸ್ಕರ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟವ್ರು. ಕೊಡಿ, ಹೇಗೆ
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಟ್ಟು
ನಾಳೆ ಥ್ಯಾಂಕ್ ಯು. File ಹೋಗ್ಬೇಕಲ್ಲ, you have to wait for next week.
It was listed yesterday. You tell me it was listed yesterday.
and the file and file not like
File is here only, not in the branch. It should be for-
Next week he's saying. You can give the memo, but next.
It's not the next week, I won't take.
what they are attending.
File
your
is still
file
here,
still
still
here.
in this,
That's
it
not
has to
wait
go to
for-
pending branch.
After 2 days you will.
After 2 days.
After 2 or 3 days. After 2 or 3 days you are supposed to go. Then it will list for the next week. Next week.
Thank you, sir.
What is fresh matters, premium matters? Please give.
My lord, there is an
This is
attachment
a
of bank account.
matter of 2023.
Fresh matters, preliminary matters, you can please give. You don't have to mention also. Please give.
My lord, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಟ್ಯಾಚ್ ಆಗಿದೆ, ನಿನ್ನೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು. ಇದರಿಂದ ಫಾರ್ಮಸಿಗೆಲ್ಲ ದುಡ್ಡು ಕೊಡ್ಬೇಕು ಮೈ ಲಾರ್ಡ್.
ಹಾ,
ಅದು ಅಟ್ಯಾಚ್ ಮಾಡಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿದ್ದಾರೆ, ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಟ್ಯಾಚ್ ಮಾಡಿ ಅಂತ.
ನೆನ್ನೆನು ಮೂವ್ ಮಾಡಿದ್ರಾ?
ಮೊನ್ನೆ ಮಾಡಿದ್ವಿ, ನಿನ್ನೆಗೆ ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಿತ್ತು, ಆಗಿಲ್ಲ.
ಹಾ.
ಹಂಗಾಗಿ ನಾಳೆಗೆ ಇಟ್ಕೊಂಡ್ರೆ.
Yes, ನೋಡಿ. Yes.
ಸರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ ಮೊನ್ನೆ.
You want to give the memo or you want to keep it with you?
Submission.
Please give it.
It's an old matter, my lordship, this
No,
23.
you will have to file application for early hearing.
Mine should be-
Otherwise it won't come.
The disposed matter.
It will come in the normal course. Yes,
Disposed matter, a small rectification
Yeah,
to be
needs
made in
to
the
be-
preamble of the order.
please give. Yes. Application ಹಾಕಿದ್ದೀರಾ? Early hearing, ಕೊಡಿ. Yes.
My lord, 2022, my lord, ನಂದು plaintiff age ತಪ್ಪಾಗಿದೆ ಅನ್ನೋದು ಬಿಟ್ಟು ಇನ್ನೇನು ಇಲ್ಲ. Just amendment for correction of age of plaintiff
Correction.
ಅಷ್ಟೇ.
ಕೊಡಿ, ಕೊಡಿ.
The suit has been, had to be withdrawn before the lower court, my lords, before the lower court, but due to the dispute between the counts,
Fresh matter,
please, my lord.
please give. Yes.
Trial court address listed for.
ಏನ್ ಮಾಡ್ಬೇಕ್ರಿ?
Two days only.
ಹಾ?
Today, end of the list.
Today, no.
And you list the matter tomorrow.
Tomorrow, yes.
Your Honor, 2024 fresh matter, there is illegal trespass and unauthorized.
Please give it. If it's a fresh matter, you please give it.
Yes.
Yes,
Your Honor, it was.
please call out.
List number 1, for preliminary serial number 1, Madhukar Nadi.
Rejection of application. For recall of the permission warrant issued under the proceedings. Then at least the petition of the but these the petition of purchase the suit item number 7.
Final decree proceedings.
This
Ah.
suit item number 7 during the pendants of the suit They
Huh?
are not made as a part in the suit. Suit has been decreed by granting 1/4 share.
You are a member of the family.
No, madam.
Then-
I'm a stranger, I have purchased the property from the out of the family members who have sold mallet. I am a bona fide purchaser. Without disclosing the pendants of the suit, but the suit came to be sold in my favor. But both petitioner has the petitioner.
You can't say without notice. You should have. Buyer beware is the provision. If you're a subsequent purchaser, you have no right. Yes.
At least my rights with respect to the property and possession has to be protected. In the FDP proceedings, if the total property is item number 1 to 9 property.
Ah.
But if I have only the property has been purchased in item number 7 only.
You filed an application for impleading.
Illa, including alla.
Huh?
But I have arrived in the FDP proceedings by the the petitioner.
ಅವರೇ ಮಾಡಿದಾರೆ.
ಅವರೇ ಮಾಡಿದ್ದಾರೆ.
ಸರಿ.
But then I have placed it in ex parte.
Ah.
Thereafter I filed to recall. The court has passed the recall. But I step I have also filed an objection. My objection has not been.
ಏನು objection?
Since I made all these the government that I have purchased the property.
Yes.
It has not been disclosed. Since I have no opportunity.
ಏನ್ objection? What is your objection?
I have purchased the property out of.
ಇರ್ಬೋದು.
the family.
You are only entitled to
My property has to be protected by while considering.
protected ಪ್ರಶ್ನೆ ಇಲ್ಲ.
ಅಲ್ಲ.
You only have to ensure that as far as possible, the share should be allotted to your vendor. ಅಷ್ಟೇ. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ ನೀವು?
ನಾನೇನಾಗಿದೆ ಅಂತಂದ್ರೆ ಇನ್ಫ್ಯಾಕ್ಟ್ I don't the application for recall of warrant.
Notice to the respondent.
Serial number 2,
Yes.
Martangadar GS, at least the direction may be given to the court.
Sir, you have a right to seek that. ಅದನ್ ಬಿಟ್ಟು ನೀವೇನೋ ಪ್ರೇಯರ್ ಕೇಳಿದ್ರೆ ಇನ್ನೇನಾಗುತ್ತೆ? Yes.
Balagangadhar GS.
A suit for partition, my lord, based on a will by the maternal uncle. My lord, that is the self-acquired property of maternal uncle of petitioner and first respondent, my lord. Second respondent, who is the natural sister, she says that she is a co-partner and she wants a share in the property, files an impleading application. My lord, my humble submission is, if the father's property or grandfather's property is involved, she is having a say. It is maternal uncle's property. And my lord, he executes a will in our favor. I have produced the will that exhibit annexure G. And now, my lord, this application II-8 is allowed, my lord, the trial court, my lord, completely.
To implead.
Please, my lord. The natural sister, my lord, she is not a necessary party for this. Will is in my favor and first defendant's favor. Page number 35, para 8, may kindly be produced.
Proposed dependent is younger sister of plaintiff.
Plaintiff and defendant. Well, the property is not plaintiff's father or grandfather's property. Maternal uncle's property. And my lord, Rangappa he says that it is self-acquired property, executes a will. How will annexure G nalliದೆ. ಅದನ್ನು ನನ್ನ 4ನೇ ಲೈನ್ ತಾವು ನೋಡ್ಬೋದು, ಪೇಜ್ 38. ನಾವುಗಳು ನನ್ನ ಪತ್ನಿ ಲೇಟ್ ರಂಗಮ್ಮನವರ ತಮ್ಮನಾದ ನರಸಿಂಹನ ಅವರ ಮಕ್ಕಳಾದ
38.
ಹೌದು, ಮರಣಶಾಸ್ತ್ರ. ಒಂದು 4 ಲೈನ್ ಕೆಳಗಡೆ, ನನ್ನ ಪತ್ನಿ ರಂಗಮ್ಮನವರು ಜೀವಂತರಾಗಿದ್ದಾಗಲೇ ನಮ್ಮಗಳಿಗೆ ಸಂತತಿ ಇಲ್ಲದೆ ಇರೋದ್ರಿಂದ ನಾವುಗಳು ನನ್ನ ಪತ್ನಿ ಲೇಟ್ ರಂಗಮ್ಮನವರ ತಮ್ಮನಾದ ನರಸಿಂಹಯ್ಯನವರ ಮಕ್ಕಳಾದ.
What is the who has filed the suit now?
No, my lord, petitioner has filed. Who is the legatee? And my lord, he says
Suit for
partition under this will. and it is self-acquired property of my maternal uncle Rangappa.
ಹಾ
My sister is not a necessary part.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಏನಂತ ಬರ್ದಿದ್ದಾರೆ ವಿಲ್ ಅಲ್ಲಿ?
Will ಅಲ್ಲಿ ಇಲ್ಲಿದೆ sir. ನಾನು page 38 ಅಲ್ಲಿ
ಎಸ್
fourth line ಆದ್ಮೇಲೆ ತಾವು ನನ್ನ ಪತ್ನಿ ರಂಗಮ್ಮನವರು ಜೀವಂತರಾಗಿದ್ದಾಗಲೇ ನಮ್ಮಗಳಿಗೆ ಸಂತತಿ ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ನಾವುಗಳು ನನ್ನ ಪತ್ನಿ ಲೇಟ್ ರಂಗಮ್ಮನವರ ತಮ್ಮನಾದ ನರಸಿಂಹಯ್ಯನವರ ಮಕ್ಕಳಾದ ಒಂದನೇ ಸುಮಾರು 44 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ನರಸಿಂಹಮೂರ್ತಿ ಮತ್ತು ಎರಡನೇ ಸುಮಾರು 35 ವರ್ಷ ವಯಸ್ಸುಳ್ಳ ನಾಗರಾಜ್ ಇವರುಗಳನ್ನ ಚಿಕ್ಕ ಮಕ್ಕಳಿಂದಲೂ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇಟ್ಟುಕೊಂಡು ಸಾಕಿ ದೊಡ್ಡವರನ್ನಾಗಿ ಮಾಡಿ ವಿದ್ಯಾಬುದ್ಧಿ ಕಲಿಸಿರುತ್ತೇವೆ. ಇವರಿಬ್ಬರಿಗಳು ಸಹ ನಮ್ಮ ಸಾಕು ಮಕ್ಕಳಾಗಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಇರುತ್ತಾರೆ. ಇವರುಗಳಲ್ಲಿ ಒಂದನೇ ಮಗನಿಗೆ ಲಗ್ನ ಮಾಡಿರ್ತೇನೆ, ರಂಗಮ್ಮ ಮರಣ ಹೊಂದಿರ್ತಾರೆ. ಈಗ ವಯಸ್ಸು ಆಗಿದ್ದು ವೃದ್ಧಾಪ್ಯದ ಕಾಲದಲ್ಲಿ ಪೋಷಣೆ ಮಾಡುತ್ತಿರುವುದರಿಂದ ನನ್ನ ಸ್ವಯಾರ್ಜಿತವಾದ ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತನ್ನ ಒಂದನೇ ನರಸಿಂಹಮೂರ್ತಿ ಎರಡನೇ KS ನಾಗರಾಜ್ ಅವರಿಗೆ ಬಿಲ್ ಮಾಡಿರುತ್ತೆ. It is his, if father or grandfather's property, my sister's participation is called for. This is squarely forgotten by the trial court. ಇಬ್ಬರಿಗೂ ಸಮಾಂತರವಾಗಿ ಬರಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿ
ಬರ್ಕೊಳ್ಳಿ. Issue notice to respond number 2. Respond number 1 ಇಲ್ಲ.
ಅವ್ರಿಗೂ ಬೇಕು ಸ್ವಾಮಿ. ಅವ್ರು he denies the will. ಅವ್ರಿಗೂ ಒಂದು ನೋಟಿಸ್ ಹೋಗಿ.
No. We are concerned only with the application.
Yes ma'am.
ಅವರೇನು ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್
He has not filed. He has not filed application. I filed my objection to impleading.
Issue notice to respond number 2.
Please.
Notice to respond number 1. Comma, according to the learned counsel for petitioner is not necessary, comma, since the petitioner is aggrieved of the impugned order
Please.
passed in favor of respond number 2,
Please.
permitting her to implead in the suit for partition.
Please.
Full stop. No relief is claimed against respond number 1. Full stop. At the risk of the petitioner, notice to respond number 1 is dispensed with.
Please.
The petitioner is also permitted to serve copy of the writ petition along with annexures on the learned counsel representing respondent number 2 before the trial court.
Please.
Next para. Learned counsel for the petitioner submits that the petitioner has filed the suit in OS number 163 of 2018 seeking partition and separate position between the plaintiff and the defendant, who is the brother of the plaintiff, and the suit schedule property was bequeathed in favor of the plaintiff and defendant under a will left behind by Shri
KS Rangappa.
KS Rangappa. Full stop. When an application was filed by respondent number 2 under order 1 rule 10 to implead herself in the suit for partition, comma, objections were raised by the petitioner stating that the suit schedule property is not ancestral property of the parties to the proceedings, and they have acquired rights under a will left behind by their uncle.
Please.
Full stop. That being the position, the trial court has committed an error in allowing the application, having regard to the nature of the dispute brought before the court and the fact that the suit schedule property is not ancestral property, but has been bequeathed in favor of the plaintiff and defendant under a will left behind by their uncle. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order.
Also further proceedings.
Further proceeding, you go ahead.
ಅಲ್ಲ ನಾಳೆ ಒಂದ್ ವೇಳೆ ನನ್ನ
ಮಾಡಕ್ ಬರೋದಿಲ್ವಲ್ಲ. See, if she is not permitted to participate
please
by virtue of the stay of this order,
please
You can go ahead. Alva,
But they may raise an objection that
ಯಾರು?
our
ಎಲ್ಲಿ?
proposed respondent further proceedings ನಡೆದ್ರೆ ನನಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. As your lordship directs.
Impugned order dated 19/6/2024 on IA number 8 of 2023 in OS number 163 of 2018 till the next date of hearing.
Please. Notice may also kindly be ordered for the first.
ಮಾಡಿದ್ದೀನಿ. I have ordered notice, I have permitted you to serve a copy also.
Three, Srinivas Manohar Kulkarni.
I represent for petition.
Yes, respondent.
ಇದರಲ್ಲಿ ನಾನ್ ಪಿಟಿಷನರ್.
ಕಡೆ ಬನ್ನಿ. Yes,
My lord, kindly pass over seniors appearing in quorum number 15, serial number 1, my lord.
ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಾ ಇದಾರೆ. ಪಾಸ್
Four, in Vishwanatha.
I'm for the petition.
ಬಂದ್ರಲ್ಲ. Please wait. Previous matter ತಗೊಳ್ಳಿ. Yes.
Number three.
In the trial court, I have filed a suit for recovery filed by the plaintiff before the trial court.
You are defendants.
Defendant, I have filed an application under section 8 of arbitration. There was a condition in an agreement, investment agreement, stating that section 8 of arbitration clause has to be invoked. Here, ಈ ಫಸ್ಟ್ ಒಬ್ಬರು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗ್ಬೇಕು ಆರ್ಬಿಟ್ರೇಟರ್ ಆಗಿ, ಅದ್ರಲ್ಲಿ ಏನಾದ್ರು ಸಾಲ್ವ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಈ ಎರಡು ಆರ್ಬಿಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಆಗ್ಬೇಕು. ನಂತರ ಅದು ಸಾಲ್ವ್ ಆಗಿಲ್ಲ ಅಂತ ಇಬ್ರು ಸೇರಿ ಮೂರು ಆರ್ಬಿಟ್ರೇಟರ್ ಅಪಾಯಿಂಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಹೇಳಿದೆ. ಅದಾದ ನಂತರ ಡೇಟೆಡ್ 15/5/2021 ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಆಗಿದೆ. ಆ ಸೆಟಲ್ಮೆಂಟ್ ಡೀಡ್ ಅಲ್ಲಿ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಓನ್ಲಿ ಫಸ್ಟ್ ಡಿಪೆಂಡೆಂಟ್ ಇಸ್ ಪಾರ್ಟ್. Two other dependents are not the part. Hence, have filed an application under section 8 of Arbitration Act to refer the matter to court. Matter may be civil suit ಬರೋದಿಲ್ಲ ಅಂತ.
Commercial suit was filed for what?
For recovery of money.
ಅಲ್ರಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತು ಅಂತ ಹೇಳ್ತಾ ಇದೀರ ನೀವು.
ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಸೆಟಲ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಆಗಿದೆ. ಬೇಸ್ಡ್ ಆನ್ ದಟ್ ನಾನು ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದೀನಿ 4,75,00,000 ಪ್ಲಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ.
ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಏನ್ ಕ್ಲೈಮ್?
ಅದು ನಾವು ಸೈನ್ ಮಾಡಿರೋದು ಒಬ್ರೇ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. ಇಬ್ರು 4 ಜನ 3 ಜನ ಇದ್ದಾರೆ ಪಾರ್ಟ್ನರ್ಸ್.
It's not a party, it's a company.
I have denied that.
You were all directors of the company, is it?
Yes. First,
All of you.
first petitioner is the company, second and third defendant, they are the director of the company.
What about the plaintiff?
The plaintiff is individual. Individual,
He is not connected with the company.
no,
There was a contract between you and the company.
yes, ma'am.
So you have filed a suit.
Yes, I have filed this.
But is it a fact that in terms of the arbitration clause, there was a settlement?
The settlement has taken place, thereafter the settlement agreement came into existence, there is no clause, it's an arbitration clause in the settlement agreement. Then what that agreement, whatever the business agreement is there, that is seized, as almost the clause was there, they just seized it. Once the subsequent document came into existence, waiver settlement, that clear wording is there in the said document. Finally, it is settled. Then that's what was observed by the trial court, para number 9 and 10. Even subsequent document ಬಂದಾದೂನುವೆ ಹಳೆ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಎಫೆಕ್ಟ್ ಇರುತ್ತೆ ಅಂತ ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್.
ಅವರು ಪ್ರಯರ್ ದಯವಿಟ್ಟು ಅವರು ನೀನ್ ಪ್ರಯರ್ ನೋಡ್ಬೋದು ಸೂಟಲ್ಲಿ. Even they are relying on the investment agreement dated 25/1/2019.
Para 9 and 10.
9 and 10. Shall I learn?
Yes.
The plaintiff along with the plaintiff has produced the investment agreement dated 25/1/2019, in which clause number 8.2 provides that in case any dispute between the parties, it can be settled by your arbitration. Subsequent to this agreement, this is a settlement agreement dated 15/5/2000, to which the defendant also party, wherein it was been specifically mentioned that irrespective of existence of clause number 8 in the investment agreement, upon advice made by the friends and elders, both plaintiff and defendant have come to the mutual understanding for amicable settlement, and it has been agreed that the defendant shall pay a sum of rupees 4,75,50,000 as full and final settlement. Relying upon the recital of settlement agreement dated 15/5/2021, Learned Counsel for the plaintiff would vehemently submit that by virtue of the subsequent contract, there is no requirement referring to dispute for settlement by arbitration, and therefore the present suit is maintainable. Opposing the argument of the Learned Counsel for the plaintiff, Learned Counsel for the defendant too would submit that the settlement agreement has not done away with the clause number 8 of the investment agreement. It is still basis for the present suit, and clause number 8.2 provide for settlement dispute by arbitration. Therefore, the plaintiff shall be directed to take the recourse of arbitration. That I relate this to latest Supreme Court judgment. Where it says that unless and until the specific clause inserted subsequent the agreement, the arbitration act will not apply. That is extracted by that is 2020 SC online, SC 232 in case of NBCC versus Julian Infra Project Private Limited.
But his contention is that I was not a party to that subsequent settlement agreement.
How they can?
That is the contention.
That is there as the signatory.
Huh?
They are the signatory to the document.
Even I stand now, one of the directors.
That is the-
sign, not all the.
That is subject matter trial.
Direct sign ಮಾಡಿರೋದು ಅದು ಕಂಪನಿ ಪರವಾಗಿ ಒಬ್ಬರೇ ಮಾಡಿರೋದು ಇಬ್ರು ಇದ್ದಾರೆ ಡೈರೆಕ್ಟರ್ಸ್
Company is represented by one director.
ಇಬ್ರು ಇದ್ದಾರೆ ಗಂಡ ಹೆಂಡತಿ ಇಬ್ರು ಕಂಪನಿ
Huh?
ಬಟ್ ಸಿಗ್ನೇಚರ್ ತಗೊಳ್ಳೋದು ಒಬ್ಬರದ್ದೇ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್
Your lordship information.
Where is the need for each and every director to sign the document?
ಅಲ್ಲ ತಮ್ಗೆ ತಮ್ ಗಮನಕ್ಕೆ ತರ್ತಾ ಇರೋದು ಅಂದ್ರೆ ಕಂಪನಿ ಒಂದೇ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರು ಸೂಟ್ ಅಲ್ಲಿ ಅದರ್ ಡೈರೆಕ್ಟರ್ ನಾಟ್ ಫೈಲ್ಡ್ ವಕಾಲ. Suppressing that, they are claiming here that there is no signature. If that is that is a subject matter trial.
Even in the plaint, only the company is arrayed as a defendant.
No.
Yes.
Both the director also I
And others. And others.
Before that,
Directors in the
kindly
company
peruse
will be
section
quite
13 of the
clear.
Commercial Court Act. Before that, he has to satisfy to this honorable court how this writ petition is maintainable. The consistent view of this honorable court, writ petition is not maintained when the appeal is provided. Section 13 is mandatory. Shall I read, madam?
Yes.
Section 13, appeal from the decree of the commercial court and commercial divisions. Any person aggrieved by the judgment or order of the commercial court below the level of the district judge may appeal to the commercial court, appellate court within a period of 60 days from the date of judgment or order. Any person aggrieved by the judgment or order of the commercial court at the level of the district judge exercising the original civil jurisdiction, or as the case may be, commercial division of the High Court may appeal to the commercial appellate division of the High Court within the period of 60 days from the date of the judgment of or order, provided that an appeal shall arise from the such order passed by the commercial divisions or the commercial code that are specifically enumerated under order 43 of the Code of Civil Procedure 1908, as amended by this act. And section 37 of Arbitration Act, Conciliation Act 1996. Now, notwithstanding anything contained in any other law for time being in force or later patent of High Court, no appeal shall lie from any other or decree of the commercial division of court other than the accordance with the provisions of this act.
The order will be only that order passed under order order 53.
Yes, ma'am.
ಅಷ್ಟೇ ಅದೊಂದು ಬಿಟ್ರೆ ಬೇರೆ ಯಾವುದೂ ಇಲ್ಲ.
No, any person aggrieved by the judgment or orders.
Sir, please read the proviso you read out now.
Yes, my lord.
Provided that an appeal shall lie from such orders passed by the commercial division or a commercial court that are specifically enumerated under order 43.
That is appeal, MFA.
43 only.
Yes, ma'am.
Not otherwise.
Yes, ma'am.
This is not an order arising out of 43.
No. specifically enumerated order under so 43. That is
43 of
43 MFA. MFA comes
Only
against the
43.
interim order.
Huh?
The MFA comes with the interim order.
Order 43.
Yes, ma'am.
An appeal shall lie from the following orders under the provision of section 104, namely an order under rule 10 of order 7, an order under rule 9 of order 9, rejecting an application for an order to set aside the dismissal of a suit, an order under rule 13 rule 13 of order 9, an order under rule 21 of order 11. ನಿಮ್ದು ಯಾವ್ದು application?
Section 8 of arbitration.
8.
Arbitration Act.
It is not, is it part of this rule 1?
Rule 1 ಬರೋದಿಲ್ಲ.
So therefore, only appeal would lie only under these circumstances,
ಅಲ್ಲ,
not under any other application.
ಅಲ್ಲ 13(1) ನಾವು ನೋಡಿದ್ರೆ any order, any person aggrieved by the judgment or order. 13(1).
ಹೌದ್ರಿ, that has been clarified in the proviso.
ಆಯ್ತು, ಮೆರಿಟ್ ಮೇಲೆ.
Yes.
Kindly look into the in page number 48. The plaintiff has filed a memo contending that they shall not claim. The plaintiff has also filed a memo giving up their his claim under the
ಏನಂತ ಏನು what was the
investment agreement.
what was the prayer in your application? IA number 3. Where is IA number 3?
In page number
30.
3.
Please to pass necessary orders on arbitration clause mentioned in the investment agreement, para 8.2 in the above case, in the interest of justice and equity. Now, having regard to the judgment cited by the other side, Supreme Court judgment, what do you say?
In that agreement.
It has been extracted in ink page number 44.
Judgment student.
Copy ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ?
ಇದೆ.
ಕೊಡಿ.
General agreement ಇದ್ದಂತ ಸಂದರ್ಭದಲ್ಲಿ
ತಗೊಳ್ಳಿ.
file ಕೊಟ್ಟು ಸರಿ.
ತಗೊಳ್ಳಿ.
When the parties enter into a contract, making a general reference to another contract,
Yes.
such general reference would not have the effect of incorporating the arbitration clause from the referred document into the contract between the parties. The arbitration clause from another contract can be incorporated into the contract only by a specific reference to arbitration clause. So according to you, this is not another contract.
No.
It is a settlement
Also,
in terms of the arbitration clause. So it cannot be termed as a separate contract. That is the contention.
That can I remember, let's see the very word
Because-
used in the.
The Supreme Court has held otherwise.
Yeah.
That merely because there is a termination of the contract, it will not put an end to the arbitration clause. Arbitration clause will continue. And the disputes arising in the contract
That is
has
not-
to be settled only in terms of the arbitration clause.
That is not the scope.
That is the law laid down by the Honorable Supreme Court.
They kindly peruse the para number 17 of that judgment and earlier judgment, what the Supreme Court relied.
All right, we'll consider. Purple.
ಅಲ್ಲಿ ನಾಳೆನೇ cross
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ
examination
ಏನಾಗಿದೆ?
post ಮಾಡಿ.
Learned Counsel Sri M. Veerabhadraya has entered appearance for the respondent, plaintiff. Next para. You have received a copy of the writ petition?
Yes, ma'am.
Learned Counsel for the petitioners submits that the application filed by the petitioners who are dependents in the commercial suit filed at the hands of the respondent herein. ಏನಂತ ಹೇಳಿದ್ರಿ? In IA number 3,
Sorry for
under
interrupting.
section 8 of the Arbitration and Conciliation Act, 1996, has been rejected by the commercial court. ಹೇಳಿ.
I kindly peruse the para 17 of the judgment, ma'am. It clarifies position. That is accepted by the, of course, para number ತಪ್ಪಾಗಿದೆ.
ಅದೇ.
It could thus been seen the court held that when the parties enter into a contract making a general reference to another.
That is what I read out now.
No, last paraದಲ್ಲಿ, last 4 lines. It has further held that where the contract between the parties provided that the execution of or performance of that contract shall be in the terms of another contract. So on so, then the terms of referred contract in regard to the execution performance alone will apply and not the arbitration agreement in the referred contract unless there is a special reference to the arbitration clause also. The subsequent contract nalli there should be a arbitration clause because it ceases effect of the earlier contract. There is no question of settlement ಆgo ಪ್ರಶ್ನೆ ಇಲ್ಲ because arbitration ಬರೋದೇ settlement ಗೆ.
ನೀವು ಓದಿದ್ದು
So last 17 last 4 lines.
referring to another judgment.
ಇದು ಅದರಲ್ಲಿ ಕರೆ ಆಗಿದೆ ಇದ್ರದ್ದೇನೆ ಇದ್ರಲ್ಲಿ ರೆಫರ್ ಆಗಿದೆ ದಟ್ ಇಸ್ NBCC ನಲ್ಲಿ ಫಾರ 17.
ಇವಾಗ ಓದಿದ್ರಲ್ಲ ನೀವು.
ಹೌದು.
It says it has been further held.
Yes, madam.
ಅಂದ್ರೆ it is referring to another judgment.
Yes, madam. That is para 22.
So what was held in this?
Yes, I given another judgment, madam. ಇದು ಕೊಟ್ಟಿದ್ದೇನೆ.
ಅಲ್ಲಲ್ಲ.
Inox.
This is
ಇದರಲ್ಲಿ
only.
their arbitrations ಒಂದ್ಸತಿ acted upon ಆದ್ಮೇಲೆ unless the subsequent contract specify the specific clause of arbitration.
17 ಅಲ್ಲಿ.
Yes, madam.
It is recording the submissions.
Yes, madam.
And referring to the previous judgment.
Yes, madam.
What is the law laid down?
You can kindly see the Inox Wine Limited, madam. Inox
So
another
ಇದ್ರಲ್ಲೇ
judgment
ಈ
where it is
judgment ಅಲ್ಲಿ
relied.
finally what was it held?
Madam, that is ಇದರಲ್ಲಿ
Para 17 is not the conclusion.
Yes, madam. Conclusion 22
Conclusion
again, relying
ಏನಿದೆ?
on Inox Wine Limited, that is under 2018 2 SCC 519. Then it was held by the Supreme Court.
ಒಂದ್
In
ನಿಮಿಷ,
the said case.
ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದಾರೆ ನೋಡೋಣ, because this is latest judgment.
Yes, ma'am.
2024 judgment ಇದು.
ಹೌದು sir. ಅದು ರಿಲೇ ಆಗಿ 2018 ಇಲ್ಲಿ ರಿಲೇ ಆಗಿ ಬರ್ದಿದೆ.
So let us see what is the law laid down now.
Yes, ma'am. They heard they were provision ಇಲ್ಲ apply ಆಗುತ್ತೆ. That's-
ಏನ್ ಹೇಳಿದೆ?
Before that, kindly peruse 37 of the Arbitration Act, my lord. My lord, Section 37 of the Arbitration Act. Section 37 of the Arbitration.
ಕೊಡ್ರಿ.
One A. An appeal shall rise from the following orders. The court authorized by law to hear the appeal from the original decree of the court, passing the order, namely refusing to refer the parties to arbitration under Section 8.
Notwithstanding anything contained in any other law for the time being in force.
Yes.
An appeal shall lie from the following orders and from no orders
Alla, idu
to the court.
Arbitration Act 37. Appealable orders.
ಅದೇ ಓದ್ತಾ ಇರೋದು. Notwithstanding anything contained in any other law for the time being in force. ಅದೇ ತಾನೆ? ನೀವು ಕಮರ್ಷಿಯಲ್ ಕೋರ್ಟ್ಸ್ ಆಕ್ಟ್ ಹೋಗ್ತಾ ಇದೀರೋ?
Arbitration Act.
ಹಾ. Notwithstanding
appeal-
anything contained in any other law for the time being in force, an appeal shall lie from the following orders.
2019, 1990 scooty.
ಅದು 2019 ಅಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ.
ಹೌದು, ಒಂದ್ ನಿಮಿಷ ನೋಡ್ಬಿಡ್ತೀನಿ. ಹೌದು, ಹೊಸ ಅಮೆಂಡ್ ಆಗಿದೆ.
Refusing
ಈ
to
book
refer
ಅಲ್ಲಿ-
the parties to arbitration.
Yes, please. The A ತಗೊಂಡ್ರೆ ಸೇಮ್ it was the language and
You will have to file an appeal. Notwithstanding anything contained in any other law for the time being in force, an appeal shall lie to the court authorized by law to hear appeals from original decrees of the court passing the order, namely refusing to refer the parties to arbitration under Section 8.
this is the application on 8.
You'll have to file an appeal. ಬರ್ಕೊಳ್ಳಿ. ಇದು paragraph ಎಲ್ಲ ತೆಗೆದ್ಬಿಟ್ಟು a preliminary objection is raised by the learned counsel for the respondent plaintiff while referring to clause A of subsection 1 of section 37 of the Arbitration and Conciliation Act, 1996, which provides for an appeal from an order of the commercial court to the court authorized by law to hear appeals in respect of an order of refusal to refer the parties to arbitration under Section 8. Full stop. Admittedly, the application in IA number 3 filed by the defendants under Section 8 has been rejected by the commercial court. Full stop. Therefore, an appeal would lie. Full stop. Next part. Upholding the preliminary objections raised by the respondent plaintiff, the writ petition stands dismissed while reserving liberty to the petitioners to file an appeal in accordance with law.
ಮುಚ್ಚು.
Before, Jane Vishwanatha,
The petitioner is the wife of deceased Shampi Virupaksha, who passed away during the course of the employment. And she had filed an claim petition under Employees Compensation Act. The employer, she has made employer and her insurance company liable. She has filed a claim petition against them. When the matter was set down for evidence, respondent's evidence, the respondent number 2, the employer's insurer, filed an application under order 1 Rule 10.2 to implead Shriram General Insurance, which is the insurance of the colluding vehicle, my lords. The trial court, without appreciating the same, I have filed my objection. The trial court, without appreciating the same, has allowed the application filed by the respondent number 2.
IA number 4,
Yes.
under order 1 Rule 10.2, to implead the proposed respondent number 3 and proceed with the case. Who is proposed respondent?
The Shriram General Insurance. The trial court is treating this as an MVC petition rather than treating it as an employee's compensation.
Insurance company.
Insurance company has filed an application under 1 Rule 10.2 to implead Shriram General Insurance.
The respondent, owner of the vehicle, filed the application to implead the insurer.
Not the owner of the vehicle. The respondent number 2 is Tata AIG Insurance. They have filed an application to implead Shriram General Insurance.
You have filed the claim petition.
Yes.
Huh?
Yes.
Respondent number 1 is the owner of the vehicle.
She is my employer.
Employer. Owner of the vehicle and employer.
Yes.
Respondent number 2 is?
They are the insurance of the employer's vehicle.
But it says, no, it's insurer is Shriram, the proposed respondent.
The proposed respondent is Shriram, my lords.
Ah,
But the employer's vehicle was
But has taken a
insured by
contention
Tata AIG.
that the vehicle was insured with respondent number 2.
Please, my lords.
Policy bearing number so and so. Even though respondent number 1 has contended that respondent number 2 is the insurer of her vehicle, but she has not produced insurance policy. Respondent number 2, against whom petition is filed, stating that respondent number 2, the insurer of the offending vehicle, has filed written statement and inter alia contended that offending vehicle is insured with Shriram General Insurance Company and not with the second respondent.
They have not led evidence in order to prove the same, my lords. He has just contended it.
Huh?
He has just contended it. That
Yes, they have taken a stand that I am not the insurer of that vehicle. And they are saying it's Shriram General Insurance, which is the insurer of the vehicle.
My lords, but they have not led any evidence with regard to the same, my lords.
What is the use of leading evidence, and thereafter your petition will be dismissed then? How are you aggrieved, madam? See, if not this insurance company, other insurance company will step into the shoes of respondent number 2.
My lords,
In fact, you should be happy.
my lords,
At least you, either by this insurance company or that insurance company, your claim will be satisfied. Why are you objecting to this?
the Tata Shriram.
Why are you objecting to it?
It is offending.
Your interest is in getting the claim. The liability will be fastened on the owner of the vehicle and the insurer jointly. Whether it is this insurance company or that insurance company, how are you worried?
He is just shifting his liability, my lords. He is
No,
the
that insurance company is saying, no, I have not insured this vehicle. It is Shriram General Insurance that is that has insured the vehicle. And if they come in and say, yes, I have insured the vehicle, is it not good for you? Why are you raising objections to this? There was no need for you to file this writ petition itself.
A date may be given, my lords. I shall satisfy the same.
What do you want to satisfy, madam?
My lords, they're shifting the.
I said
liability.
your interest is in getting the claim. Now, if Tata Insurance is not the insurer of the vehicle, then if the Shriram Insurance Company is not impleaded, you will suffer. Why do you want to take that risk? Please think over. At the request of learned counsel for petitioner, release this matter on 21st of September, this Saturday. Yes.
Fine.
Appear for the petitioner. This is petition arising out of an order that was passed by the FDP court. On the previous occasion, my lords had passed an order directing for records to be secured from the trial court. I'm not sure. my
If
lords-
the records have come, my lord, then I would like to, please have it tomorrow, my lord. I would like to argue personally, my lord.
ಬಂದಿದ್ಯಂತೆ?
On second, my lord was pleased to direct me.
Court officer, ರೆಕಾರ್ಡ್ಸ್ ತೋರ್ಸಕ್ ಹೇಳಿದ್ವಿ, ಬಂದಿದ್ಯಾ?
ಎರಡನೇ ತಾರೀಕು ತಾವು ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ರಿ.
Although there was a directive by this court to the second additional civil and session judge, Bengaluru, to forward the entire papers. More particularly, the reports submitted by the court commissioner. The records have not been furnished. Next para. The learned registrar judicial is directed to secure the records in an FDP number
5 of
2006. On the file of the second additional city civil and session judge, Bengaluru, more particularly the reports filed by the court commissioners. Full stop. Release this matter on 25th of September.
Great.
Grateful.
Number 6, Shiv Shankar K.
Petition.
Yes.
I have filed a wakalat for respondent number, NOC wakalat for 2, 3 and 4, my lord, today morning. I request some time, my lord.
Learned counsel Shri
VR. VR.
Purti Yesrelri
Venkatesh R.
Venkatesh R undertakes to appear for
Already wakalat filed morning.
Submits that he has filed wakalat for
2, 4 and 2, 3, 4.
for 2,
3 and 4.
2, 3 and 4.
Yes.
Already filed KVA. It's the last.
Yeah,
two
NOC
occasions
wakalat I have
that
filed.
have taken time. Last.
NOC
occasion,
wakalat
party is
filed.
present before the court and.
ಇವ್ರು ಯಾರು DA ಶಿವಕುಮಾರ್ ಅಂತ ಫೈಲ್ ಮಾಡಿದ್ರು.
Yes, NOC wakalat I have
Last occasion, party has.
Has filed NOC ವಕಾಲತ್ ಅಂತ. You have a copy of the writ petition?
Yes.
Office to verify and show the name of the learned counsel in the cause list. Why are you asking for time?
Yesterday morning I received the file, Mama. Yesterday I received the file, Mama. That's why. Kindly have it.
If there is any urgency, if they
weeks,
require
maybe.
interim
Morning I
orders,
have filed.
this court is required to consider.
Yes.
ಹಿಂಗೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಇಲ್ಲ sir.
KVA task
ಎರಡು week,
ಹಿಂಗೆಲ್ಲ
2 week,
ಮಾಡ್ಬೇಕು.
at least 1 week time may be granted.
No.
ಅಲ್ಲ ನಾನು at least file ಏನಾಗಿದೆ go through it.
Yes.
Yesterday I
Specific
received.
urgency.
Yes, minutes.
ಹೇಳಿ.
Final decree, petitioner has filed the suit for partition and separate possession.
ಹಾ.
But it's in the year 1994. against his father and brothers, one-third share has been granted.
Hmm.
Subsequently, the final decree proceedings has been initiated by the very same petitioner area.
Ah.
During the pendency of the final decree proceedings, one of the purchaser has filed the impleading application. That application was rejected. Subsequently, writ petition has been filed. Writ petition, the impleading application, permitted to come on record. Then, he came on record. Subsequently, has challenged the judgment and decree, only in respect of item number 13 of the suit property is concerned. Only in respect of that property, the matter has been remanded to lead further evidence with regard to that item is concerned. Subsequently, the suit came to be decreed and that property has been deleted. In respect of 12 items, the partition has been granted, one-third share is concerned. Then, during the pendency of the final decree proceedings, the daughters, the respondent number 2 to 4, they have filed the suit for the partition and separate possession in respect of all the properties. In the year 2019, Annexure E.
They were not parties to these proceedings?
No, only against 1994 suit came to be filed. Against father and brother. Daughters have no right over the property. Then, subsequently, father was expelled. Then, in the year 2019, daughters have filed a separate suit against all the purchasers, and that suit is pending, and now the matter is set down for evidence. Now, my final decree proceedings are going on. Now, at this stage, recently, they have filed the application in the final decree proceedings. Seeking to allot 1/6 share in all the suit scheduled properties. That application came to be allowed by the trial court. Annexure E, their suit, 2019.
Their father was not a party to the proceedings?
Yes, father was alive. So
then
earlier, father was alive. Subsequently,
so during his lifetime,
yes, daughters are not parties.
their father was a party.
Father was a party.
Alva.
Yes,
Then
father was a party. Then
share has been allotted to him.
Yes, one-third share. Father and two brothers. Two sons. One-third share has been allotted.
Pleading applicants idharalla.
Yes,
Your father ge share allot agita.
yes, one-third share.
They are entitled to seek further share in that share allotted to the father.
Just morning I received the file. One
Ah.
week time may be granted. Morning I have received the file. NOC Okala.
Adrallu,
1 week time may be
purchasers
granted.
are-
I'll go through the file.
Purchasers are 7 to 14, they're all purchasers. They have filed their objections in the final decree proceedings. Their suit separately, they are prosecuting, the daughters are concerned. That suit set down for evidence. Now in my final decree proceedings, allotted 1/6 share.
Respond number 1, B to D. Have filed this application.
Yes, yes.
Respond number 1, B to D.
B to D.
Huh?
Yes,
Respond number 1 was allotted a share.
yes, allotted share, one-third share.
They are entitled for further
Further
share
share,
only
yes,
in that one.
Yes, that
How
decree,
can they claim separate share? Next para. However, at the request of learned counsel, Shri
VR.
Venkatesh,
Yes, sir.
Venkatesh
R. sir.
R. Release this matter on, shall we take it on Saturday,
Monday is 20.
23rd of September?
Much obliged.
Number 7. Leeladhar HP.
The plaintiff's writ petition. He filed a suit for permanent injunction and other relief, claiming that his father executed a registered gift deed and put me in possession of the property. I am in possession of the property. I am cultivating the land, Your Lordship.
You are the plaintiff.
Yes, Your. I produced the photos also, Your Lordship.
Suit for?
Pardon? Suit for injunction.
Ah.
On the basis of the registered gift deed executed by his father.
Ah.
Then I filed an application before the competent authorities, revenue authorities, that application is pending. In the meanwhile, your defendants are attempted to interfere. So that I filed a suit
Ah.
for injunction.
Yes.
And the other things you were asking, what I am saying, that application has been rejected. That application was rejected.
ಯಾವ application?
At 39 rule 1 and 2, I have filed it.
Before the trial court, it was
Trial
rejected.
court.
Yes.
That application.
Appellate court also, it is rejected.
I rejected it.
Ah.
My submission before.
Concurrent findings.
Yes.
Yes.
My concurrent finding and your lordship,
Ah.
the odds of the appellate court, the trial court, your honor. There is a presumption by the trial court, your honor. Your lordship, that I produce the impugned order. It starts from inquiry number 31.
Hmm.
Your lordship's reasoning, your lordship, it is in page number 36 yours, 36 yours.
Hmm.
On perusal of the materials on record and also pleading, there is no clear that whether the suit scheduled properties are the self-acquired property of the father of the plaintiff and defendants or ancestral or joint family properties. Without ascertaining the said fact, under the Hindu law, it may be presumed that the suit scheduled properties are ancestral and joint family property. In the ancestral joint family properties, the father of the plaintiff and the defendant have no exclusive right to exclude the gift deed in favor of the plaintiff. In this prima facie stage, he cannot be decided the prima facie title. We have to consider the prima facie possession, but document produced by the plaintiff.
So the parties, the defendants are also your relatives,
Brothers.
brothers.
It is self-acquired.
And your contention that your father has
in the year
executed a gift deed in your favor.
Yes, he has acquired the property in the year 1959 while he was working. Thereafter, your lordship, that father was executed a gift deed in my favor.
Yavaga?
2050. I produced that document also.
Why only in your favor?
Pardon me?
Why only in your favor?
The other brothers are in government employments. So that they have been given. He is not an employee in the government employment, so that he has been given. And I am in possession of the property, producing your large photographs.
What property? What is the nature of the
agriculture?
Agricultural land.
I produce the photos, you are also in page 50, 70 and onwards, 77 onwards. I am in possession of the property. And your lordship, my sister has been filed a suit for partition, it is pending. My sisters has filed a suit for partition, it is pending. And the brothers also filed a declaratory suit, it is also pending. Now, what I am submitting, your Raj, I am in possession of the property. If they succeeded in the suit, they will certainly will get the property.
Why when earlier suits have been filed for declaration?
No.
Why did you file a suit for permanent injunction?
I filed a suit in year 2018, your Raj. 2018. And my brothers has been filed in the year 2016, we were OS number 1462 or 16 for declaration.
Yes.
There is a no injunction order has been granted. So far, my sister has filed a suit in OS number 683 by 18. A status quo order has been granted. Status quo order. Not to alienate the property. So that if that being the case, cultivation of the property, if at all, if they succeeded, then they are entitled to your asset. So that I want to cultivate the land. If there are requests, that we will account it for.
Issue notice to the respondents. The petitioner is also permitted to serve copy of the writ petition along with annexures on the learned counsels representing the respondent before the trial court. Release this matter on 1st of October.
In the meanwhile, status interfere one day sufficient. With the police protection, they are attempting.
No.
Petition by the plaintiff. Plaintiff suit is for the partition. The defendant number, when the evidence of the plaintiff side was completed, case was posted for cross-exam, defense evidence. At that stage, the defendant number 2, 4A, C to F.
To recall cross-examination of PW3.
They have not filed a written statement also. Thereafter, the application is for only to drag on the suit proceedings at the instance of the defendants. They have not at all filed the.
Sir, it's a suit for partition.
Yes, my lord.
Then issue notice to the respondents. The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsel representing the respondent before the trial.
Impugned order astem.
Number 9.
Yes.
Suna Taragade. Number 9. Vishwanath Aragade.
Matter is called out. There is no representation for the petitioner. Release this matter. On 25th of September. Yes.
plaintiff, not petition, my lord. Application for amendment of plaint has been rejected. Suit for declaration that the gift deed is not binding and illegal and void. Lord, as on the date of the filing of the suit, the plaintiff is the mother and defendant number one is the daughter, eldest daughter. Lord, kindly turn to annexure A, page 18, my lord.
And dependent number two.
Lord,
is
defendant number two.
Apex Cooperative Bank Limited.
Lord, it appears, my lord, this defendant number one had borrowed certain money by mortgaging this property. Lord, in fact, for this writ petition, my lord, I am filing a memo to delete the second respondent. The issue, my lord, dispute is between the plaintiff and the defendant number one only. I'm sorry, Lord, I came running over the staircase.
Sir, but defendant number one has borrowed a loan.
Yes, my lord.
From second defendant.
It appears, my lord, subsequently it has been discharged also. Lord, because of that, my lord, the second defendant is not a necessary party so far as the suit is concerned, as well as this petition is also concerned. Lord, my application is to amend the plaint to add two reliefs, my lord. Page, my lord, IA number 10 may kindly be seen, my lord, page 39, annexure C. In fact, it is extracted in the impugned order also. Kindly turn to page 56, my lord. Lord, as on the date of filing the suit, my lord, the defendant number one was somewhere else, my lord. She was occupying some other property along with her husband. After the suit was filed, she forcibly entered into the suit schedule property and is occupying first floor of the property. Lord, at the time of filing the suit, I did not have the opportunity to seek for possession of this first floor property from the defendant number one. Lord, in case, my lord, the gift deed is set aside, Lord, I am entitled for possession. The defendant number one, during the pendency of the suit, after the filing of the suit, she forcibly occupied this first floor property, and my lord, she started collecting the rents from the other tenants. Lord, so far as these tenants are concerned, my lord, I am seeking the amendment to add a relief, my lord, for mean profits, because after the suit, my lord, if I succeed, I am entitled for the mean profits also. The trial court has rejected the application, Lord, on very, Lord, page 60, my lord, para 12. Lord, para 12, my lord. This is a suit for declaration to declare that the gift deed dated 30 to.
Let us see your application.
Yes.
Your application only, what is it that you are
Yes. Lord,
seeking to bring on record?
page 39, my lord, annexure C.
Yes.
Proposed amendment sought for. Lord, add para 7A after para 7 of the plaint. The plaintiff is filed the present suit seeking the relief of declaration and cancellation of alleged gift deed.
These are all facts that there are three floors.
Yes, my lord.
You are occupying one floor. The other properties, other portions are let out to tenants.
Yeah, and
that you are collecting rents.
Defendant number one is collecting the rents.
Neevu.
Illa,
Earlier, in your
earlier I was.
What have you said?
Please, Lord, I was earlier collecting the rents.
Yes.
Subsequently, defendant number one forcefully entered into property and forcibly started collecting the rents. Lord, in case I succeed, my lord, I am entitled for all these.
Have you stated, sir?
Lord, in para next, my lord, page 41 is the relief sought for, my lord.
Sir, in the paragraph that you want to add, where have you stated these facts?
My lord, I have said, my lord, the reasons in the affidavit, my lord. Page 44, my lord. Para 6.
Yes.
I submit that during the pendency of the suit, the first defendant is illegally occupied the first floor of the scheduled premises by violating the order of
Statement.
Yes.
Should also be found in the paragraph, isn't it?
Yes, my lord. Yes, my lord.
But you have not said so.
My lord, page 40, my lord. It commences from the previous page. In the application itself, in the proposed amendment which I have sought for, my lord, by way of including the facts, my lord.
Yes.
Last 3 lines on page 39, the first floor illegally using by the first defendant by violating the order of this honorable court and rent of rupees 25,000 per month. The second floor consists two portions, each portion 1 BHK and rent of rupees 8,000 per month for each house. And the same is collected by the first defendant, including advance amount. The third floor consists of two rooms along with attached bathroom and rent of rupees 5,000 each house. The total rent of rupees 57,000 is illegally collecting by the first defendant from 2014 without giving any portion of the amount to the plaintiff.
2014,
Please, my lord.
then your statement is wrong then.
My lord, from 2014, my lord, she occupied the property and she started.
And you are
collecting
filing
rents.
application in the year 2024,
Please,
10
my lord.
years after that.
Lord, what happened was there were several other applications, my lord, and my lord, this honorable court,
Notice.
my lord, this honorable court, while considering my earlier application, my lord, I sought for depositing these rents before this
Let us see, let us
before the trial court.
Issue notice to the respondents. The petitioner is also permitted to serve copy of the petition along with annexures on the learned counsel representing the respondent before the trial court.
My lord, trial court is
Yes.
pressurizing to lead evidence, my lord.
Mr.
Without
Bhatt.
these reliefs, my lord, I cannot lead evidence, my lord. My
Probably this is the reason why it is, application is rejected, sir. Yes.
Mr. Button,
Please.
Abhinav Ramanand,
could a date be given, my lord? I serve the notice, my lord, to the learned counsel who appears.
ಏನ್ 2 ವಾರ ಪೂರ್ತಿ ಇಲ್ಲ. It should be only after vacation.
At least on the reopening day or a second day after that,
Release this matter
14th or 15th.
on 15th of October.
Serial number 10.
Three matters are there. Lord, order of temporary injunction granted by the trial court, Lord, is reversed by the first appellate court. That is what is challenged before my lords. Lord, 3 writ petitions are there.
Hmm.
My lord, the petitioners, my lord, who are the plaintiffs, my lord, claim to be the owners of the property. They have purchased the property, my lord, under registered sale deeds. Subsequently, my lord, there is an acquisition at the hands of the KIDB. My lord, our lands are denotified by the KIDB after, my lord, we have purchased it. We have also secured, my lord, change of land use from industrial to residential purposes. We are in possession. Now, my lord, the respondents were trying to interfere with my possession. So therefore, I filed a suit in the year 2015, not to interfere with my possession. Ex parte order is granted. From 2015 to 2022, my lord, that order was in force. That was confirmed by the trial court. The appeal is filed before the appellate court, saying that I have got an easementary right to go through the land. And for that easementary right, my lord, separate suit is pending by the respondents. My lord, they claim that they have got an easementary right because they have retained portions adjoining my property. My lord, all that is incorrect because, my lord, we have purchased majority of the extent. 1 acre, my lord, is the subject matter of acquisition. The landowners, my lord, had challenged it. Acquisition was struck down. Now, my lord, KDPA has filed an appeal. It is pending before the appellate court. Acquisition proceedings have not come to an end. So question of using some road, alleged road to access their property is not available because there is no property at all. In any event, my lord, they have filed a suit to establish that so-called right of easement, my lord, which is still pending. In my suit for injunction, my lord, where temporary injunction is granted, there's, my lord, Pani standing in mind, conversion is there, my lord, Khata is made out by the local authority. The appellate court says, no, there's a right of easement, therefore the injunction order is dissolved. That is what is challenged before my lords. I'll show the documents to my lords.
Their property has been acquired.
Acquired, my lord, and I have purchased it subsequently. And my lord, that purchase by me is challenged by them by filing a suit.
Defendants are the previous owners.
Previous owners, I have purchased it. And my lord,
You purchased
three branches are there, my lord. More branch in the my lord, I purchased.
The entire extent of land.
The entire extent. This is the subject matter of acquisition.
Is there anything left?
Nothing is left. According to me, nothing
They are
is left.
asking for access to which property?
So that is entirely our case, my lord. That is entirely our case.
Is it so?
No, my lord. Suit pending, challenging the same deed, and in the said suit, the trial court has directed the party.
Sir, you need access now to go where?
We are in the property, we are in the property.
We are in
You
possession.
are asking for easementary rights.
No.
Because an order of temporary injunction was there in favor of the plaintiff.
One thing, my lord, the entire sale dates and conversion order are under challenge. We are in possession in a suit filed by them. They have admitted that we have not handed over the possession. Kindly see my counterman.
Sir, there was admittedly an order of temporary injunction against you.
Status
it?
quo modified to status quo in 2022. Status quo was there.
2015 injunction ittu.
ಅಲ್ಲಿ ತನಕ ಇತ್ತು.
From 2018,
2015.
15
Yes,
to
my lord.
2022.
Sorry, 2016, 11/4/2016. There was an order of temporary.
Which is that order?
But that order is not produced. But my lord, there was an order of temporary injunction. With effect from my lord, 11/4/2016. In this very same suit, this order, my lord, subsisted till 23/8/2023. When the order fructified into an order of, my lord, temporary injunction.
Annexure E.
Yes, my lord. Annexure E, my lord, is the
39
order
182.
based on. My application is allowed as per Annexure E, my lord, page number 82.
Idena, this is the order.
Yes, my lord.
2016.
Yes, my lord. Ex parte order was given in the year 2016. From there, my lord, there was an injunction operating against them. And my lord, this is confirmed, my lord, in the year 2023. For my lord, 7 years, my lord, there was no easementary right. There was an order of injunction operating in my favor from 2016.
Now, which is the impugned order?
Impugned order, my lord, is at page number, my lord, 131, my lord. Annexure K, my lord.
MA nalla.
MA, howದು.
Not by the trial court.
By the first appellate court.
By, where is the order of the trial court?
That is what my lord said, page 82, my lord.
82.
Yes, my lord.
This is dismissed. But it says,
my lord, injunction is granted in my favor, my lord. Page 82, injunction is granted in my favor.
this order has been set aside.
This order.
The MA ಅಲ್ಲಿ.
Yes, this order has been set aside. My lords are seeing, my lord, 23573.
ಹೌದು.
Yes, yes. Now this order, my lord, which was granted by the trial court, my lord, is now set aside by the.
But this order is passed in 2023.
Howದು, my lord, ex parte injunction order was operating from 2016. Moment I filed the suit, my lord, I sought for ex parte order of injunction. Granted. And that was pending, my lord, till this order was passed. And
thereafter, the application was taken up for consideration only.
Yes, my lord, after 7 years, my lord.
23.
Yes, my lord. In 23, my lord, that ex parte order is confirmed, my lord, and full-fledged, my lord, temporary injunction is granted.
All right.
Annexure E.
Yes.
Now that is sought to be, my lord, set aside.
Yes.
By means of the impugned order.
Yes.
Page number 169 is the operative portion by the first appellate court.
But where is the reasoning?
Reasoning, my lords will kindly get. My lord, page number 167.
Yes.
They deny my ownership, and this is what, my lord, the learned first appellate court has to say. Moreover, the photographs produced by the appellants, my lord, page number 167, my lord, first line.
Yes.
In MA 21/2023, also prima facie shows existence of 10 feet road in the suit schedule property. It is made clear in order to claim easementary right over the said road, defendant shall admit the ownership of the plaintiffs with respect to the suit schedule property. My lord, now they are claiming easementary right. Easementary right means, my lord, they must admit my ownership. Because, my lord, easement is claimed over somebody else's land. They don't admit my ownership because they say whatever sale deed is executed in my favor is the subject matter of another suit. They say I am not the owner. In that context, we said, my lord, easementary right as a defense in a suit for injunction cannot be considered by the court.
Even otherwise, easementary rights andre to use that path to go to another property.
Yes.
It cannot be in existence without there being another property.
That is exactly our case, my lord. That is
Yes, my lord,
exactly
my
our case.
property is there. 3/1
Unless
is I am the owner. Still I am in the possession. Kindly see the photographs I have produced along with.
Sir, with photographs, you can't make out all that.
No. We have filed
possible.
3 suits, my lord.
Where have you stated? You are asking for easementary rights from going from passing this to going to which property?
In a part.
Please show.
Yes, my lord, partition deed I have produced. My lord.
Sir, in your application, what have you said?
Which
You are
one?
asking for easementary rights to approach which property?
My property,
Which is that property?
3/1.
Please show.
Kindly
Please
see
show in
the-
your application. Sir. Objection, your objections.
Yeah.
The application was filed by them.
Yes,
You would have filed objections.
Yes, my lord.
Please show.
Objections are, my lord, at exhibit D. Annexure D, my lord. 67.
Admittedly, there is a sale deed executed.
not executed, it, my lord.
Hmm?
It is obtained by them on the basis of the cancelled power of attorney and cancelled agreement. I have filed a complaint before the Lokayukta. Lokayukta held, my lord, the sub-register officials of the sub-register are at fault, and all the promotions are withheld. Those things are there, and
Ah.
I have filed a suit, and it is pending, challenging I am in possession. To show the possession, I have produced the
Annexure
photographs.
D2 is the objection
Yes.
filed by dependents number 9 to 12. Idena?
My lord, annexure D1, page 67.
D1 na?
D1, my lord.
D1.
Yes, my lord, page 67
Ah,
is filed by the seventh defendant, my
Yes.
lord. Then, my lord, D2 is filed by defendants 4 to 12.
four to 12 or 9 to 12 ಆತು?
9 to 12.
9 to 12.
9 to 12.
Ah, your defendants
My lord,
number?
defendant number 13, 1-3. Defendant number 13.
ಅವ್ರದ್ದು objections ಇಲ್ವಾ?
D3 ಇದೆ, my lord, page number 76.
Two ಒಳಗೆ written.
D3,
Your defendant number 13.
13.
Yes, ma'am.
Defendant number 13. Their statement of objections is, my lord, page 76.
They are all not members of the same family?
Same
Same
family.
family.
All sale deeds are executed, my lord, from 1995 to 2015, sale deeds are executed. My lord, those sale deeds, my lord, they have challenged it. But fact remains, it is registered, I have obtained change of land use, I have successfully challenged, my lord, the acquisition of those lands. My lord, now I am in possession. All this, my lord, is tactics to just, my lord,
6 portions of land, my lord, 6 portions of land. The challenge is regarding to 2 portions of land which is pending before the court, and the trial court has granted status quo in respect of possession as well. It is these 2 properties which are saying there is an access to this place. The very sale deed of the plaintiffs themselves say that towards the north, there's a 10 feet patch.
Any sketch?
No, in the sale deed
No, no,
itself.
first of all, please point out from the objections. What you are trying to say now.
Just take a lot to page number 45.
Paragraph number 4, page 77.
yes.
As stated in that paragraph. Three bar one, I have stated it.
What is the action that you took after the lands were notified and acquired?
We filed a writ petition allowed, appeal is pending, filed by the KADP.
KIDB is filed appeal.
You filed writ petition?
Yes.
Yes, we filed, landowners filed writ petition.
It is allowed, but the past the
The
proceedings.
notifications were
And
caused.
the appeal filed by the KADB is still pending.
You said you succeeded in getting the order.
Oh, I succeeded, and my lord, this portion of Govinda Pass, my lord, please turn to page number 212. It is also converted, my lord, at my instance, page number 212, please have a look, my lord. Page number 212. 30 guntas of land. Annexure N1. N2.
Survey number 2.
Alla.
Survey number 2.
Alla, next alla 3 ide. The entire parcel is converted. That is what I want to throw to my lords. All successive, my lord, conversion orders are there. Then, my lord, sale deed is there. Where, my lord, this 30 guntas of land is purchased. Please turn to page number 182.
Survey number 3, 30 guntas.
This entire land, my lord, is purchased, then converted, my lord. And it forms one parcel. And I have produced the sketch, my lord, where there is no indication.
Where is that sketch?
Copy. Good. All the existence of the lands, my lord, sketch is there. Survey number 2, which is purchased by me, survey number 3/3, page number 2, 3/4. Lord, what I will do is, my lord, I should have done it. I will, my lord, prepare one sketch with boundaries and, my lord, produce it before my lords. Now,
This,
these conversion orders don't indicate, my lord, any kind of any easement or pathway. And, my lord, once, my lord, I have purchased the property. Question of they are claiming any easementary right over a property which I have purchased will not arise. They have challenged my sale deed, my lord, that is a different matter. My lord, the very existence of the easementary right, my lord, is in dispute because they have filed a suit for declaration. Please declare that there exists such an easementary right. Now, my lord, this trial court, my lord, presumes that there is an easementary right even before the competent court can declare it. And my injunction is resolved. My lord, they themselves have filed a suit, admittedly.
Only for easements.
Easement. Declare that I have got a right of easement ಅಂತ ಹೇಳಿ ದಾವ ಹಾಕಿದ್ದಾರೆ.
To pass through your property.
To pass through my property.
And go where?
To their property ಅಂತ
Is
ಹೇಳ್ತಾರೆ.
that their property?
Lord,
3/1 and 3/2, my lord. It is not in this sketch.
In the subject matter of suit, there are only 3 schedules, my lord. There are 3 more properties which are existing in that. Totally 6 properties.
Is schedule? Is sketch?
My lord, may I kindly take your, page 234, their own sale deed, my lord. Page 234.
Do you have a sketch?
Lord, we'll prepare that sketch, my lord, and bring it. My lord,
234, in the schedule, it is stated that there is a pathway. Page 234.
Learned counsel. ಇದಾಯ್ತಾ? ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
notice ಆಗಿದೆ. They have all filed objections.
I have filed a counter also, my lord. I have filed a counter also.
Now, if you have filed a suit for seeking easementary rights.
Kindly
Declaration
see,
of
my lord.
easementary rights.
Declaration of
see.
easementary rights only.
No, my lord.
Then?
Order of declaration declaring the plaintiff is the absolute owner of lawful possession and enjoyment of the property and cancelling the sale deed so and so and permanent injunction.
Which property is that?
Same 3/1, my lord.
3/1.
I am the owner of the
Measuring 30 guntas.
30 guntas.
30 guntas.
Please take page number 147, my lord.
Subject matter of suit.
In this suit, this property is not included at all. 124 injunction suit, they have not included my property.
Yes, my lord. Therefore, my lord, where is the question of easement? That is.
I have filed a suit. Kindly see page number 50 of my counter.
So therefore, whatever orders you have to obtain, you have to obtain in your suit.
Obtain status quo is there.
Here, if it is only a question of easements,
No.
can can the order of temporary
In this
injunction
suit, my lord,
granted
they have filed
in
suit
the
for
year 2016?
Please
Please have a look at the schedule, my lord.
1990.
Page number 62, if my lord sees, my lord, he is claiming rights over 3/1 and 3/2. Please have a look at the schedule, my lord, at page 62. My lord, his land is not even there. Page number 62, my lord, survey number 2 is there. Now please turn over, my lord, page number 63. 3/3 is there, 3/4 is there.
Hmm.
My lord, he is claiming 3/1 and 3/2.
Therefore, the order of temporary injunction was in respect of these
These
properties.
Yes, my lord, if it is allowed, my lord, they will block the passage. Kindly see the photographs. my lord.
Therefore, can that be a ground to vacate an order of temporary injunction that was
Wait a minute.
granted in the year 2016?
Here, my lord, the facts is 1995 agreement and 1995 power of attorney. Sale deed is 2015, after 20 years. That was challenged, my lord. It was cancelled. On the basis of the cancelled power of attorney and agreement, they have obtained sale deed. Power of,
Sir,
my right is
you are
there.
talking of your property.
Yes, my lord.
Which is not the suit item.
But passage.
Therefore,
If
on that basis, can the order of temporary injunction that was granted in the year 2016 be vacated?
No, if it is vacated, may not they black the passage. Kindly see the
You
photograph.
have to obtain appropriate orders in your suit.
Status quo is there. Status quo, order of status quo regarding the property.
See, passing
Chairman.
through these properties
Yes, my lord.
and having access to your property,
Yes.
any order you have to obtain, you please obtain in your suit. That cannot be a ground to vacate an order of temporary injunction granted in favor of the plaintiff in respect of these properties.
Kindly see the partition deed, my lord. It
Perfect.
clarifies.
Right. This 10 feet passage is an access to the property belonging to the
Appropriate orders you will please obtain in your suit, sir. Insofar as these items of properties are concerned, the order of temporary injunction that was granted in the year 2016 would not have been vacated like this in the year 2020, 23 or 24.
If it operates only with those lands, we have no problem at all.
but passage.
Injunction.
So therefore, you will have to obtain appropriate orders in your suit insofar as access is concerned.
Whatever the land.
In this suit, he is concerned about the 3 items of property in the schedule. An order of temporary injunction
Have
is
I-
granted in respect of that property.
These properties, my lord.
Therefore, even now, if you have to obtain an order for passage to your property, you should obtain it in your suit.
As far as their scheduled property is concerned, we are not concerned. But the 10 feet passage which he himself admitted in this sale deed, my lord. Kindly take page 234.
Kindly see
Page
one,
90.
my lord.
Page 234.
Page 92
Which is
injunction,
which is the impugned order?
impugned order.
For page 131.
Yes,
Kindly see
operative portion
my
is
counter,
at
my lord.
169.
In a suit, 510 of 97, injunction suit decreed, my lord, in my favor. I have produced the decree also.
Sir, that is why I am saying, if you are seeking easementary rights,
No.
you please obtain appropriate orders to
In-
pass through this property to reach your property. That's all right.
My lord, they have
We are not concerned about your property in
Only,
this
my
suit.
lord, in the schedule, in those property, they were included, my passage also. That's the problem.
Sir, they cannot remove that passage and say, no, I'm asking a declaration only in respect of this.
Rectification deed,
my
they
lord,
have included.
kind submission.
The
They
petitioners
have left over the passage and purchased the property.
who are plaintiffs in OS number
124 of 2016.
124 of
2016.
are aggrieved of the impugned order
The passage throughout ಇದೆ, ಒಂದು black ಮಾಡ್ಬಿಟ್ರೆ ಆಗೋಯ್ತು.
dated 25th of June 2024, passed by the learned principal senior civil judge and JMFC at Anekal. Who
Page 169, my lord.
has set aside the order of the trial court. As regards IA number 1, filed by the plaintiffs under Order 39, Rule 1 and 2 of CPC, and has consequently rejected the application. Full stop. Next paragraph. Learned counsel for the petitioners, plaintiffs submits that the suit was filed in the year 2015, 16, and an order of temporary injunction, a ex parte temporary injunction was passed by the trial court on
On my lord, 11/4/2016.
11/4/2016. Full stop.
That was confirmed, my lord, by the order at page 92, my lord. On till 23rd August 2023. That order subsisted.
Huh?
Page 92 ali, ex parte order, my lord, is confirmed and injunction is granted. Page 92, my lord.
Yeah, 92 ಎಲ್ಲಿದೆ?
Page 92, my lord, IA number 1 filed by the plaintiffs under Order 39, Rule 1 and 2. Is allowed, defendants, their agents, servants.
ಅದೇ.
Yes, my lord, that is the injunction order.
But the application was taken up
Taken up and
for
decided
consideration
and
and
decided.
allowed
Allowed,
by
allowed.
this order.
Yes.
Just make one second. The entire persons are not one for each of each entity, each entity is with respect of the particular for share. Can I just take your option to my page number 46 I have given. They have not sold the entire extent. They share undivided share they have sold. All the other share portfolio granted to and they have retained that now. This we will also kindly are given the details also at page 42 of my sorry.
42 of
10.1, sir.
10,089.
10.1, writ petition.
Sir, ಕೇಳಿಸ್ಕೊಳ್ರಿ.
10.1, writ petition. 23,099.
Page
42, madam.
42.
Yes. These are the affiliates under which the respondents are purchased. So now we kindly see that I have given in survey number 2, Madeline 30 costs, item number 1 is the food schedule. And purchases, approximately lost purchases are just lost in the last column now. All these vendors, they are not told the entire extent of one for their own share, undivided share. In all the other remaining share, what extent of stay stamped in the name that is in our position. Three other two branches are there. Only one branch, what's called the family, they have sold undivided share only. They do not know where it is. Now the other two branches, they have been in position. And for them, there is a pathway. They are also again, just take one on next sheet, next page 43. I have given what things exist in our what's called share. And I just take one on shift to page number 43.
Sir, Munishamappa has sold 30 guntas. Muni Venkata Swami has sold 1 acre 5 guntas. Krishnappa has sold 30 guntas.
30 guntas.
4 acres.
These are the suit schedule property.
Yes.
Extent of with 31 undivided share.
Sir, they have sold that portion of the property under the sale deed.
No days measured and now. Simply the schedule was only given the extent, sorry, what is the extent now? Where nice, nobody knows about it. It is not been surveyed.
Sketch check
So
is
we
in
are not in position to entire extent was unsold extent now. And supposing not what the what's called easement.
And how is it that you have filed a suit only for easement rights?
No, we have filed declaration.
Declaration for sale deed
Also, my lord.
Sale deed also
Not
declared.
for easementary. Easementary is quite different.
My lord, they have purchased, plaintiffs have purchased the property, leaving the 10 feet passage as per their own sale deed. Kindly page 234. Their sale deed schedule. There's a 10 feet passage Even in the conversion order, there is a passage. Even in the conversion orders, both the,
Therefore.
page 34.
If that is what, if that
Let
was
the
your
10 feet
contention-
passage be maintained intact.
That was your contention.
That is,
The appellate court should have passed appropriate orders only in respect of that 10 feet road.
that is what it,
How can the application itself be rejected?
that is the
39
discussion, that is the discussion made in the appellant court's order.
So if you say, I will clarify it and say, it will
That
be
10 feet passage.
only in respect of the 10 feet passage, even in accordance the sale deed.
Sale deed, my lord, subsequently has been, my lord, amended and my lord rectified. The 10 feet passage is not there. Please see the schedule, my lord.
Only one
In the
party has to,
page number 39.
ಯಾವ್ದ್ರಲ್ಲಿ?
page 234.
ಸುತ್ತಲ್ ಹಾಕಿರೋ
ಅಲ್ಲ,
schedule.
ಯಾವ ರಿಟ್ ಪಿಟಿಷನ್?
Yes, my lord.
ನೀವು ಮುಂಚೆ ಹೇಳ್ತಿದ್ರ ಅದೇ?
Yes, my lord. 23099. My lords were looking at 23099.
ಆಯ್ತು.
ಅದ್ರಲ್ಲೇ ಈಗ my learned friend was reading from that writ petition.
Yes.
ಅದ್ರಲ್ಲೇ ತಾವು ನೋಡ್ಬೋದು. Page 39, my lord, is the schedule. It is a common schedule, my lord, in only one suit. My lord, 3 sets of defendants have challenged it. That is why, my lord, 3 appeals and 3 writ petitions before my lords. Please see page 39.
30 guntas.
30 guntas, please see the boundaries, my lord. Survey number 3, 3/1, 3/3, land belonging to Patel Timmaya. Then, my lord, east by road.
No, but he was pointing out to some sale.
Tell it to page 234.
234.
234.
Now writ petition.
Same writ petition. Rajendra.
But ಅದಾದ್ಮೇಲೆ rectification deed
Rectification
ಇದೆಯಲ್ಲ?
deed ಆಗಿದೆ.
Rectification.
235
But
ಅಲ್ಲಿ.
conversion order, the ONI has been intact maintained. Kindly see the conversion order schedule also.
Page number 234.
Yes, sir. North by common pathway of
Common
10 feet.
pathway of 10 feet.
And thereafter Muniswamy stand.
Rectification deed ಅಲ್ಲಿ ಏನಾಗಿದೆ?
Rectification deed ಅಲ್ಲಿ.
Passage ತೆಗ್ದ್ಬಿಟ್ಟಿದ್ದಾರೆ. After 20 years.
It's a common passage for all
After 20
the
years, they have rectified.
owners of the land.
Not all the owners have executed that.
They cannot sell the easement right in respect of the passage. Even they cannot purchase it. In a partition deed is clearly mentioned.
Please see the, that is why, my lord, I produced the conversion sketch. Survey number 2. Please have a look at, my lord, the sketch, survey number 2 though.
Even that order is also under challenge.
Page number 1.
Conversion is also under challenge.
In the, my lord, I just gave a sketch, my lord, conversion sketch. Adರಲ್ಲಿ, all these lands are, my lord, separately identified at an undisputed point in time when conversions took place, my lord, in the year 2003 onwards. Please see the first one, my lord.
Yes.
Survey number 2. There is no existence of any road. And then, my lord, the conversion order my lords will get corresponding to this. If my lord has the writ petition 23099. My lords will get it at page number 239. 239 ಅಲ್ಲಿ.
This sketch.
ಹೌದು, sketch ಅಲ್ಲಿ, please.
First page, it is survey number 2, na?
Yes, survey number 2.
This is what you have purchased.
This is what I have purchased.
Second page is 3/3.
Yes, my lord.
ಮೇಲ್ಗಡೆ ಇರೋದೆ. ಮೇಲ್ಗಡೆ ಇರೋದೆ ಅದು.
2 ಮೇಲ್ಗಡೆ ಇರೋದೆ 3/3.
ಇದೆ ಅಲ್ವಾ? You have purchased that portion also.
Oh, that portion also, and I have purchased 3/4 also.
So this forms a compact
yes,
block.
That's what I am saying, my lords. And my lords will kindly see, compare this with the.
So if have you seen this?
Yes, service conversion order, one more page 240.
Even if there is anything left, it will be this portion.
No, my lord.
That is on the western side.
Kindly see,
He has purchased all these properties, 3 portions.
Not the entire extent to one.
Not extent.
But share of ownership is one vendor.
vendor.
But can the entire-
Only 30 guntas each in 3
Sir, in terms of that sale deed, this is the property that he has purchased.
But they say, when measure that property, it is a-
245 conversion order.
Yes, all right, I understood.
There is a mention of
May I
Warning.
submit, my lord, status quo regarding the passage can be passed and direct the trial court to dispose of the
I've
matter.
shown to the
within
court that
6 months.
there exists a 10 feet passage
Passage to go where, sir?
to my property.
property,
Which is
ma'am.
that property? You please see
3
this
bar one, it is
sketch
not
and
it is
tell
not-
me which is your
it is not
property that
mentioned,
you
It is
have
not
written.
mentioned here, my lord. 3 bar 1 and 3 bar 2 is not
Sir, this
mentioned.
is the remaining portion of survey number
3
3.
bar 3 and 3 bar 4
Yes,
bar 3. that's
whatever
right.
remains is this side.
No, this side.
On the western side.
Continue
This
passage.
entire property, 3 pieces he has purchased.
One thing, my lord, I have produced the photographs. Clearly shows the passage. my lord. Along with
Regarding
the-
to 10.1, my lord, this suit is
It's insofar as that passage is concerned, if you have already filed a suit, please obtain appropriate orders there in that suit.
It affects, my lord, because this injunction order, they will produce there.
I will also say that since you have filed a separate suit seeking easementary rights, appropriate directions can be obtained in that suit.
Not only
It will be kept
easement,
open.
even declaration suit, my
Yes.
lord, declaration.
Yes.
my lord, suit
injunction.
for partition is pending, my lord. Suit for partition is
3
pending.
suits are pending.
Only a portion has been purchased from the co-owners. my lord.
2001, sir. The sale deed is of year 2001.
2015, my lord.
A portion was purchased from the, one of the co-sharer,
Yes.
not with all the co-sharer, my lord.
Sale deed
Intention
is,
cannot be given against the,
sale deed
first
is
para
dated, my
ಇಲ್ಲಿದ್ದೀನಿ.
lord, 2015, not 1.
my lord, the partition
Then
case is
counsel.
pending, my lord.
For the petitioners submits
Sale deed is 2015.
that submits while drawing the attention of this court to the order passed by the trial court. That the trial court rightly considered the prima facie case made out by the plaintiffs who had produced the copies of the sale deeds, RTC extracts, taxpayer receipts, 4D records, etc., and came to a conclusion that having regard to the fact that the plaintiffs purchased the properties, suit schedule properties commencing from sale deed dated 13/11/1996 and the land revenue records have been mutated in the name of the plaintiffs, the plaintiffs are entitled for an order of temporary injunction. Full stop. On the other hand, it was pointed out from the impugned order passed by the First Appellate Court that the First Appellate Court was strayed away at the submissions made by the defendants that there exists a 10 feet width road in the suit schedule property. Full stop. It was also pointed out that in the impugned order itself, it was made clear that in order to claim the easementary right over the said road, the defendants shall admit the ownership of the plaintiffs with respect to suit schedule property. Full stop. It was further held that unless the defendants admit the ownership of plaintiffs over the suit schedule property, they cannot claim the easementary right over the suit schedule property. Full stop. It was also noticed that a comprehensive suit in OS number 621 of 2013 is pending consideration. And in the said comprehensive suit, all issues with respect to the alleged 10 feet width road shall be adjudicated in accordance with law. Full stop. Nevertheless, the first appellate court proceeded to set aside the order of the trial court and further rejected the application in IA number 1 filed by the plaintiffs. Full stop. The learned counsel for the petitioners has also filed a memo dated 4/9/2024 along with copies of the sketches pertaining to the 3 items of the suit schedule property, orders of conversion passed by the competent authority, and submits that the 3 items of the suit schedule property form a compact block, and therefore there cannot be a contention that there is a pathway passing through the suit schedule properties. Full stop. Since learned counsel for the respondent defendants pointed out to a sale deed where admittedly the 10 feet passage is shown in the boundary, learned counsel for the petitioner submitted that subsequently there was a rectification deed insofar as the said 10 feet passage is concerned, and the same has been replaced by a survey number.
Land belonging to Muni Venkat Swami.
Land belonging to Muni Venkat Swami, while deleting the earlier words which shows 10 feet passage.
That is that is 3/4 which is purchased by us. Eastige road and Tittala, that is survey number 3/4 which is purchased by us.
Full stop. It was further clarified by the learned counsel for the petitioner that the property lying on the eastern side of survey number 3 bar.
Survey number 2, my lord.
Survey number 2.
In relation to which that sale deed was pointed out.
Where passage was shown on the eastern side.
Yes, ma'am.
Was thereafter purchased by the petitioners, and therefore northern side. There was no need for them to retain the 10 feet passage, which was earlier shown in the sale deed. Full stop. At any rate, it is submitted that the first appellate court has erred in rejecting the application without noticing the fact that the order of temporary injunction was granted in the year 2016, and the parties have maintained the said position till the impugned order was passed. Yavaga? On
my lord. On 25/6/2024.
25/6/2024. Full stop. The learned counsel has also clarified that if at all there is any remaining portion in survey number 3 retained by the defendants, it is towards the western portion of the suit schedule properties, and therefore there cannot be any claim of a passage passing through the suit schedule property to have access to the remaining portion of survey number 3. Full stop. Next para. Per contra, learned counsels for the respondents, defendants, seek to support the impugned order. Full stop. It is contended that the respondent defendants have not only sought for easementary rights, but they have also sought for a declaration in respect of the sale deed.
Declaration and cancellation of sale deed. Declaration.
And they have sought for cancellation of the sale
Sale
deeds.
deed and declaration of ownership. Both.
Full stop.
And the suit for partition also is pending, madam.
In another writ petition suit for.
It is
partition.
also submitted that there is another suit for partition
In the same.
and separate position insofar as the family
Entire
members are
all the-
concerned. Are as between the family members.
Family members.
Family members and these petitioners also, madam.
Purchasers.
Only few members have been executed.
Claim
sale
ಮಾಡ್-
deed in this
Claim
particular
ಮಾಡ್ತಾರೆ
case,
title
madam.
under a partition deed. A partition deed ಅಲ್ಲಿ 10 feet passage it is mentioned.
Suit property is
A
originally
partition
belongs
deed.
to Union
They have to
Tapa,
take over that.
All right, all right.
They have to carry with that.
Yes. Next. Having heard the learned counsel for the petitioners, the respondents, and on perusing the petition papers, this court finds that the order passed by the trial court on 23rd of August 2023, confirming the order of ex parte temporary injunction and thereby allowing IA number 1 was well reasoned. Full stop. The trial court had also taken note of the contentions of the defendants that there existed a pathway in the suit schedule properties and therefore appropriate directions was sought by the defendants having regard to the existence of the pathway. Full stop.
Page 91, there is no existence of that is a categorical finding. But the documents and other material.
Insofar as that submission is concerned, the trial court has held that for the sake of arguments, if any such pathway is existing and if the defendants are having any easementary right over it and the plaintiffs have no right over it, there would be questions subject to be determined in the full-fledged trial at the time of recording of the evidence. Full stop. On the other hand, the first appellate court seems to have been carried away by the said contention raised at the hands of the defendants. Full stop. Nevertheless, on going through the survey sketches that are produced along with the memo at the hands of the learned counsel for petitioners, this court finds that the 3 items of suitable property form a compact block, and even if one of the sale deeds, more particularly in respect of survey number 2, showed a pathway existing on the eastern portion, on the eastern boundary, nevertheless, since subsequently the eastern portion of the property was also purchased by the plaintiffs under a separate sale deed, there was no need to maintain the 10 feet passage, according to the plaintiffs. Full stop. At any rate, this court is of the considered opinion that if at all the defendants seek any orders insofar as the passage is concerned, they should file necessary application in the suit where they have also sought for easementary rights. Full stop.
Both these suits will not order of status quo, now it is there, man.
insofar as the three items of the three items of the suit scheduled property is concerned, comma, in the suit filed at the hands of the petitioners herein, comma, such contention regarding the existence of the pathway cannot be considered at this stage. Full stop. This court, comma, having seen the sketches that are produced by the learned counsel for petitioners, comma, is prima facie satisfied that if at all there are any other portion of property left behind after the sales that were made in favor of the plaintiffs, comma, it would be on the western portion of the property, and the pathway that was shown in one of the sale deeds pertaining to survey number 2 will not in any way have access to the western portion of the property. Full stop. In that view of the matter, comma, this court is of the considered opinion that the impugned order passed by the first appellate court cannot be sustained. Full stop. Next para. Accordingly, the writ petition is allowed. The impugned order passed by the principal senior civil judge and JMHC at Anekal in MA 21, 23 and 26 of 2023 are hereby washed and set aside.
Trial
Full
court
stop.
order is restored.
The order of the trial court passed on 23rd of August 2023. Insofar as IA number 1 and 2 are concerned, is confirmed. Yes.
Grateful. Three matters can be dispersed.
Common order.
Yes.
It
Grateful.
will be confined only to the land, therefore we will have no problem.
That's what I said.
Suit scheduled
We are,
property.
we are concerned only with the suit
Suit
scheduled
scheduled
property. Yes, I have said so.
Srimata 11. PC Sunita.
Petitioner, my lord, is the defendants before the trial court, my lord. Plaintiff has filed a suit for declaration of the social property.
Hmm.
Also mandatory injunction against the defendants, directing the defendant to remove the structure situated in the scheduled property and hand over the physical possession, and also for permanent injunctions, my lord. I have filed a written statement, my lord, stating that the property is not an agricultural property. It is a non-agricultural property since, my lord, PID number and it was situated in the heart of the city of Kolega. So it has to be treated as preliminary issue in regarding to the value of the property
Court
and
fee.
the court fee, my lord.
Uh-huh.
The issue has already framed as a preliminary issue, my lord. Thereafter, trial judge had not considered, my lord. I had filed a memo stating that the preliminary issue has to be considered, my lord. In that, my lord, trial judge, my lord, without evidence on the preliminary issue, my lord, order has been passed and my memo itself, my lord, has rejected, holding that the Kanishmari number has not been not the sought for relief on Kanishmari number. They have sought the relief on survey number, and even then you are not produced the sub-register value of the property. I have produced the value of the property, photographs, everything, CD and everything I have produced, my lord, without considering any of the material which I have produced, my lord.
So what are the legal grounds that you have raised?
My lord, legal grounds, my lord, issues, my lord, kindly say annexures C, my lord. Annexure C, my lord, fourth issue, my lord, whether the
This
plaintiff.
Kollegal Scanning Diagnostic Center
Please, my lord.
is established by you.
Oh, yeah, please, my lord. That property they are claiming, my lord.
Hmm.
They stated that it is an agricultural property, 52 cents, my
So
lord.
that is why I am asking you, what is the legal ground that you have raised?
My lord, legal ground, my lord, I have paid tax and PID number is given, my lord.
Hmm.
And my lord, till today, my lord, we are running a nursing home and diagnostic centers, my lord. And also, my lord, it was in the jurisdictions of city municipal council, my lord. So they have to pay the court fee, my lord, as
With
per the
judgment.
market value, my lord.
With judgment.
Judgment I have not been. And also,
ಏನಮ್ಮ, you know, this is the contention. This is what has to be stated by you.
please, my lord.
In
please,
spite of that, you don't come with the judgment.
I'll produce, my
Huh?
lord. There is so many judgments regarding the pin money issue.
Then why didn't you bring it?
Lordship has.
ಅದು ಇದೇನ್ರಿ ಕಾಪಿ ಇಟ್ಕೊಂಡಿಲ್ವಾ? ಆ ಡಿವಿಷನ್ ಬೆಂಚ್ ನೆನ್ನೆ ಒಂದ್ ಹೇಳಿದ್ರಲ್ಲ ಜಸ್ಟಿಸ್ ಠಾಕೂರ್ ಅವ್ರದ್ದು. Issue notice to the respondents. The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsel representing the respondents before the trial court. Stop, next para. Learned counsel for the petitioner submits that the impugned order passed by
Principal civil judge.
the
and
learned
JMFC.
principal civil judge and JMFC, Kollegal, is contrary to the judgments of this court, more particularly in the case of so and so. Where the honorable division bench has held that even if a land continues to be on the records of the revenue authorities, showing that the land is assessed to land revenue, nevertheless, if once the lands are brought within the jurisdiction of a local authority such as the municipality or corporation, municipal corporation, then the suit have to be valued on the basis of the market value and not as revenue lands. Full stop. Learned counsel would further draw the attention of this court to the photographs produced at Annexure E series and submits that the petitioner defendant has established a diagnostic center on the suit schedule property, and it is contended that the property is situated within the
City municipal.
jurisdiction of the Kollegal City Municipal Council. Full stop. Next paragraph. Consequently, there shall be an addendum order stay of all further proceedings in OS number 110 of 2016 on the file of the principal civil judge and JMXC, Kollegala till the next date of hearing.
Chamble, please.
My lords, I appear for the petitioners in this case. My lords, senior counsel Mr. Vikram Oilgol is leading us in the matter. Positive for dengue fever, just yesterday or 21st. I seek a short accommodation for next week, around 26th or 27th, if it suits you, my lords.
ಅಲ್ಲ ರೀ, ಡೆಂಗ್ಯೂ ಅಂದ್ರೆ ಇನ್ನು ಒಂದ್ ವಾರಕ್ಕೆ ಹೋಗ್ಬಿಡುತ್ತಾ?
On
We'll have to make
instruction-
alternative arrangement, otherwise not possible.
If at all by the next day of hearing it is not done, we'll.
At the request of learned counsel for petitioner, release this matter on 26th of September.
Represent the petitioner. Repetition filed against the allowing of an impleading application. Suit is for partition, madam. Lord, there are broadly two items of properties in the suit. Item number one, Lord, measures 1 acre in extent. Item number two measures 32 guntas. Item number one, as per the plaint averments, my lord, was sold by the first defendant in favor of the third defendant, my lord, way back, my lord, in about 30 years back. Now, my lord, the third defendant, my lord, dies during the pendency of the suit, his LRs are brought on record. My lord, in the year 2010, much before the suit was filed, one of the, my lord, the third defendant and his sons, my lord, they entered into a partition. And one of the eldest son of the third defendant, who is the defendant number 3A, sells a site in my favor in the year 2010. 2017, the suit is filed. My lord, in the year 2021, the LRs of the third defendant and the plaintiffs enter into a compromise. And the item number one is dropped from the suit. Because, my lord, some amounts are paid to the plaintiff. Even despite that, my lord, an impleading application is filed. I am a purchaser from the third defendant. A false averment is made in the affidavit, my lord, which contradicts the averments in the plaint, stating that this site falls in item number 2. My lord, the modus is, my lord, that to bring in as many site owners as possible and to extract money. Now, my lord, although the suit has been, my lord, deleted in respect of item number 1, kindly turn to, my lord, the order passed by the trial court at page 43 on the compromise petition. That is Annexure E, page 43. May I read this? My lord, in the middle portion, matter called out again, heard counsel for LRs of third defendant, defendant number 3. He brings to my notice that in case the compromise petition, in this case, the compromise petition is filed between LRs of defendant number 3 and the plaintiffs, which the plaintiffs have admitted receipt of 1,50,000 each, and acknowledged and admitted defendant number 3 as absolute owner of the suit item number 1, and also stated that in view of the said compromise, plaintiffs will proceed with the suit against the remaining defendants. Records disclose that the said compromise petition was filed on 16/12/21, and on the same day, memo is filed by the plaintiffs to dismiss the suit against the LRs of the defendant as not pressed. The facts in brief are that, my lord, I don't want to read all that. My lord, kindly come to page 44, the last but one paragraph. In view of the said compromise, which is in accordance with law and which is duly accepted, the suit is dismissed against LRs of defendant number 3 in respect of item number 1 of the suit property, and the suit shall continue only in respect of item number 2. My lord, this impleading application, I am a purchaser from the third defendant, defendant number 3. I have enclosed my sale deed at annexure, my lord, H. Defendant number 3 is
Site formed in item number 1.
Item number 1. But mischievously in the may I take my lords to the impleading application?
Yes.
Which is at annexure F at page 55. 56 nal affidavit paragraph 3 nalli.
50?
page 56, my lord, of the affidavit accompanying the impleading application.
ಅಲ್ಲ ಅವ್ರು ಏನಾದ್ರು ಹೇಳಿರ್ಲಿ. Did you not bring it to the notice of
Yes,
the?
I have brought it to the
Ah.
notice, my lord. I have produced the sale deed. In my objections, I have stated that this property was sold by the third defendant, the LR of the third defendant.
ಓದಿ
learned
ಒಂದೇ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ.
Outstanding paragraph.
Let us see.
56 ನಲ್ಲಿ paragraph 3.
ಇಲ್ಲಿ ನಿಮ್ಮ submissions ಅಲ್ಲಿ it has taken note of the fact that item number 1 has been deleted.
Yeah, yes, my lord. My lord,
ಇನ್ನು ನಿಮ್ಮ objections record ಮಾಡುವಾಗ
paragraph.
para 2 or 3.
My lord, para 5 ಅಲ್ಲಿ ಹೇಳಿದೀನಿ.
para 5.
ಹೌದು.
para 5 of?
Para 5 of page 59, my lord, of my objection.
ಅಲ್ರಿ ಇದ್ರಲ್ಲಿ ನಿಮ್ಮ impugned order ಅಲ್ಲಿ.
Impugned order ಅಲ್ಲಿ.
Paragraph 3 is supposed to be your objections?
Yes, ma'am. May I read them?
Yes.
The proposed defendant number 8 has filed objections alleging that he is neither a necessary or the proper party to the suit. There is no subsisting cause of action against the proposed defendant number 8, who is the purchaser of site 19, sold by him by defendant number 3A and his children. The said site was carved out of an acre in survey number 103 of Formau, Agra village. That is suit item number 1, which was originally owned by defendant number 3, Annai Reddy. Annai Reddy and his children partitioned the suit schedule item number 1 under registered partition dated so and so, whereby different portions of suit item number 1 were apportioned by defendant number 3 and his children. Defendant number 3A, Balchandra Reddy, was allotted site number 19 among other sites. The proposed defendant number 8 has purchased site number 19 under registered sale deed dated 26/11/2010, executed by defendant number 3A. The plaintiffs in the above suit and the LRs of the defendant number 3A have entered into a compromise by filing a compromise petition dated 16/12/21, whereby in view of the settlement, the plaintiffs have given up their claims in respect of suit item number 1 and have accepted the lawful ownership of defendant number 3 and LR and his LRs who are in the same in the light of the partition deed dated so and so. In the result, the plaintiffs sought for the dismissal of the suit against the LRs of the defendant number 3, and by order dated 13/2/23, this court was pleased to accept the compromise and dismiss the suit in respect of item number 1. My lord, despite this, my lord,
issue notice to the respondents.
my lord, I am seeking for dispensation, my lord.
ಯಾರು?
Respondents 6 to 17, they are the 4 defendants. They are.
Issue notice to response number 1 to 5.
Please.
The petitioner is also permitted to serve copy of the petition along with annexures on the learned counsel representing the response number 1 to 4.
1 to 5.
1 to 5 before the trial court. Insofar as the other respondents are concerned, learned counsel has filed a memo seeking dispensation of notice to response number 6 to 17 on the ground that the application was filed by the plaintiffs to implead the petitioner hearing, and no relief is sought against the other respondents who are defendants in the suit. Full stop. At the risk of the petitioner, notice to respondents number 6 to 17 is dispensed with. Next para, learned counsel for the petitioner submits that despite the fact that suit item number 1 suit schedule item number 1 being deleted from the suit, and it was brought to the notice of the trial court that the petitioner, proposed defendant, had purchased a suit carved out of survey item number 1, which is no more in the suit, and therefore there was no need for impleadment of the petitioner, the trial court has proceeded to allow the application. Full stop. Learned counsel submits that in paragraph number 3 of the impugned order, the trial court has noticed the objections raised by the petitioner that in view of the compromise petition dated 16/12/2021 between the plaintiff and defendant number 3,
LRs of
defendant number 3, and the suit And the plaintiff gave up all claims in respect of suit item number 1 and the LRs of defendant number 3, comma, the court has further proceeded to pass the impugned order. Full stop. Learned counsel submits that the petitioner is not a necessary party to the proceedings, having regard to the facts narrated herein above. Full stop. Next para. Consequently, there shall be an ad interim order of stay of all further proceedings in OS number
2587. 25870.
so sought only for operation of the stay of the operation of the order,
ಹೌದು.
not for further proceedings.
Okay.
Ad interim order of stay of the impugned order dated 27/2024 on IA number 13 in OS number 25870 of 2017 on the file of the 13th Additional City Civil and Session Judge, comma, Bengaluru, comma, till the next date of hearing.
That's for the petitioner, my lords. The lordships recall, this is the matter, my lords, of the traversal of a tower crane over the plaintiff's
yes.
premises, my lords.
So, I may be permitted, I appear for the respondents, I may be permitted to file objections to the, along with a few documents to the petition that they filed.
Sir, my lords, the matter was listed before the trial court yesterday.
What happened?
My lords, orders have not been passed, my
My
lords.
lords, the
It has been
presiding officer
adjourned
was
to
on
the
leave
30th.
yesterday and it's been posted for orders on 30th of this month.
30th.
Yeah, in fact, my lord, here I'm appearing online, here, applying for advancement of the matter because it is unexpected that it would go on leave and that to postpone it by such a large extent. I have only one practical suggestion, if my learned friends on the other side are agreeable. Last occasion, learned senior counsel appearing for the respondent made a submission that they are prepared to provide an indemnity if there is a damage. Now, in fact, there have been such cranes that have fallen in other cities. We have that my colleague in court has those memos and that can be produced before the court. If that undertaking of an indemnity can be recorded, and then the matter can be had as early as maybe either tomorrow or on Monday, we will anyway have the matter advanced before the trial court and try to seek our orders there. I don't want to press for an order here. I would rather just say that the submission was made, that submission may kindly be recorded, that's all, without prejudice to our rights.
On the previous date of hearing, on the previous date of hearing, this court had recorded the submissions of the learned senior counsel appearing for the respondents and the learned counsel for the petitioner that the trial court has listed the matter for orders on
17/9.
IA for temporary injunction
As well as orders on the Order 7 Rule 11 application that was filed by the.
and an application under Order 7 Rule 11, comma, on 17/9/2024. Full stop. Nevertheless, comma, today it is submitted that the trial court has not passed orders on 17/9/2024. Comma, but, comma, the matter has been listed on 30th of October, 30th of September. Full stop. Next para. Learned counsel for the respondent submits that the statement of objections are ready.
Please.
Full stop. Served a copy. A copy of the same is now served on the learned counsel for petitioner. Full stop. Learned counsel for the respondent is requested to file the same in the office
Please.
during the course of the day. Full stop. Next para. Learned counsel for the petitioner, however, submits that the petitioner will file necessary application for advancement of the matter before the trial court.
Yes, my lord.
And therefore, this matter may be listed next week itself. Full stop. Next para. Release this matter on 26th of September.
Grateful. There was an undertaking made for indemnity that if that can be recorded, I'll be grateful. My learned friend can take
No,
instance.
last time I have not recorded it.
I know, but the submission was in fact made that there would be indemnity. Anyway, I leave it to you. I leave it. I am grateful.
Great.
But defendant's writ petition, my lord,
in the trial court, impugned order, my lord, I filed an written statement, additional written statement, my lord, has been rejected. Lord, the plaintiff, my lord, sued for bare injunction. 7 proceedings, my lord, 7 suits are pending. He has suppressed all the proceedings and he files a suit, my lord. I file an additional written statement when I get the additional information, my lord. My IA is at page annexure D, page 42, my lord.
To permit the second dependent to file additional written
Yes,
statement.
my lord. I filed my additional written statement, my lord. May kindly peruse to my IA, my lord, is at page 42, my lord. Annexure D. In the IA, my lord, affidavit para number 5 and 6, my lord. Till High Court, my lord, RFS, my lord, have been disposed of. All these facts, my lord, in this matter, my lord, the plaintiff, my lord, has lost the battle. Now, in the plaint, my lord, page 31, he makes as averment that no suits are pending, no proceedings are taken place. Page 31, my lord.
Audrey, this suit was filed in the year 2018.
18.
When did you file the written statement?
I have filed my written statement in the year 2018 itself, my lord.
Yes.
At that
Now you are
point-
talking of OS number 5383 of 2009.
Yes, ma'am.
When was it disposed of? 1587 of 2007, RFA 340 of 2011, RFA 730 of 2014, execution cases. When were they disposed of?
Those are disposed even before the filing of the suit itself. my lord.
Then,
This, my lord,
yes.
after the filing of.
Why
the
did
suit,
you not
even today
take up
also-
that contention in the written statement?
Even today also, my lord, certain proceedings are pending. ma'am. Even today,
So what?
certain proceedings are pending. In what?
The requirement is fulfillment of the proviso to Rule 17.
Please, my lord. Now, what has happened, my lord? The suit.
These are all prior events.
My lord, now the suit is in respect of boundary, my lord. Common passage, my lord. In all the 7 proceedings.
In paragraph number 6, you are
Yes,
saying these are all that suits and appeals that were filed.
By the
and
plaintiff.
The matter has reached finality.
Yes, my lord.
And therefore, the plaintiff will be
I
hit
am
by the
not-
principles of res judicata.
I am not party to any of those proceedings, my lord.
Then?
Now what? Now, having shown the schedule therein, my lord, now he has changed the schedule and he has filed a fresh suit, my lord. In all those 7, my lord, proceedings, the schedule was totally different, my lord. Now describing those schedules, my lord, I filed my additional written statement, which is at page number, my lord, 53, my lord. In all these suits, totally schedules were described totally different. Now this fact, my lord, is admitted by the plaintiff, my lord. Page 53 may be seen, my lord, my additional written statement, which he has described in his all earlier proceedings. Page 54, I have shown the schedule, my lord, wherein he had what he has averred in his plaint. Western side common passage anta torsidru swami in one of the suit. In para number 5. Now in para number 7, my lord, in 4 proceedings, he has shown as common passage in the west side. Now cleverly, my lord, in this suit, schedule is at page number 31, my lord.
No, instead of seeking for amending the written statement, you have filed an application for
additional
permitting additional written statement. That is not permissible in accordance with law, is the opinion of the trial court.
Yes, ma'am.
Yes.
My lord, that is correct, my lord. Wherein, my lord, if para number 17 and 18, my lord, 2009. 18 is the relevant para, my lord. It is also well settled that while allowing the additional counter statement or refusing to accept the same, the court should only see that if such additional counter statement is not accepted, the real controversy between the party could not be decided. This is what is my, in all the 7 proceedings.
ಯಾವ್ದ್ರಿ ಪ್ರಾವಿಷನ್ ಯಾವ್ದ್ರಿ?
Order 8 rule 9, my lord. 8 rule 9.
ಎಲ್ಲಿದೆ?
Here itself, my lord, in the starting itself it is shown, my lord. In the head note itself it is shown, my lord, order 8 rule 9, 6 rule 17. D head note, my lord. Head note. D. Head note D, going further in the same paragraphs, my lord, as noted herein earlier, by filing of an additional counter statement in the present case, in our view, could not cause injustice or prejudice to the respondents, but that would help the court to decide the real controversy between the parties. In our view, the High Court was therefore not justified in rejecting the application for the permission to file additional counter statement, as no prejudice would be caused to the respondent, which would be which can be compensated in terms of the cost. In the plaint, he has not described. Now, in the statement of objections, he has admitted, my lord. Page number 46 is the statement of objections, my lord.
But the provision itself says,
Please, my lord.
only in, only by way of defense to set off or counterclaim.
Lord, that is,
Where is the discussion?
now, Lord,
If it is pertaining to that one, yes, it is understandable.
please, my lord, now the.
Otherwise, you'll have to file an application for amendment of the pleading.
That liberty, my lord, my lord.
Question of
End of the
filing
day, my lord.
additional written statement will come only in this circumstance.
Oh, my lord, even if in
Or
other time, my lord, if
in regard set off claimed by the party, other party, or counterclaim.
Oh, my lord, even if the provision could have been taken as an error anta ತಗೊಂಡಿದ್ರು, my lord, amendment of order 6 rule 17 ಅಲ್ಲಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತು, order 8 rule 9, my lord, that technicality, my lord, this application itself could have been treated as a
ಅದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ರೆ ತೋರಿಸಿ.
technicality cannot be taken, my lord.
No, sir.
My lord, I may be given liberty to file amendment application and maybe I
All
file my memo.
Perfect. Matters coming up for preliminary hearing. We'll stop. Having regard to the submission made by the learned counsel for petitioner, this court deems it fit to dispose of the writ petition without notice to the respondents. Full stop. Next paragraph. An application was filed by the petitioner, defendant number 2, in OS number 4226 of 2018, under order 8 rule 9, read with section 151 of CPC, seeking to permit the second defendant to file additional written statement. Full stop. The application has been rejected on the ground that the provision in order 8 rule 9 of CPC enables filing of additional written statement or additional written statement only in cases of a set off or counterclaim made by the other party. Full stop. Admittedly, the application filed by the petitioner does not disclose that the other party had filed any, had sought for any set off or counterclaim. Full stop. Next para. At this juncture, learned counsel for the petitioner seeks leave of this court to withdraw the writ petition, while also seeking liberty to file necessary application, seeking to amend the return statement. Full stop. Next para. The submission of the learned counsel for petitioner is placed on record. Full stop. Accordingly, the writ petition stands dismissed, while reserving liberty to the petitioner to file necessary application to seek amendment of the written statement, comma, if so advised.
Orders. Serial number 16. Suresh P. Pavan Kumar.
Respondent number
ID.
10 to 15.
For the petitioner.
Yes. Notice to respond number 23.
Lordship.
You have to take steps. A week's time is granted.
Further adjournment may be granted.
You know?
Instead of hearing all it really death ಆಗಿದ್ದಾರೆ ಸುಮಾರು ಜನ ಡೆತ್ ಆಗಿದ್ದಾರೆ.
16, 17.
We have reported the death, my lord. We have filed a memo.
Other
1st March.
regarding 16, 17.
19th also death.
When did you report?
1st March, man.
1st March
2024.
2024.
Yes, ma'am.
Finally,
19th also death.
Finally, 2 weeks' time is granted at the request of learned counsel for petitioners to take steps in respect of deceased response number 16, 17, and 19. And at the same time, take steps for service of notice on response number 23. Yes.
I will maybe action.
Interim order granted earlier stands extended till the next date.
Much.
17. Apeksha D. Rectification. Steps in respect of deceased R15 and 2630.
A number 1 of 2024.
We have moved this IA.
Steps to be taken
My lord,
in
in
respect of deceased respond number 15, 26, 30.
My lord, there's no question of bringing anybody's LR because this is a 92 proceeding, section 92 of proceeding. My lord, the contesting respondents are respondent number 2 to 9. They are the trustees. The suit is filed. My lord, there is a large scale mismanagement of the public trust. My lord, under which this Veereshwara temple, which is a historical temple, my lord, is being run. There is a mismanagement of the funds. Therefore, my lord, initially, my lord, a complaint had been given to Tahsildar. Tahsildar, my lord, had conducted inquiry and other things and directed, my lord, not to indulge in these activities.
Idian miscellaneous petition. What was filed?
ಇದು ಏನಾಗಿದೆ ಹೇಳ್ತೀನಿ. Then, my lord, notwithstanding the directions that Tahsildar mismanagement was going on, therefore, the devotees of the temple filed a proceedings under section 92. In 92 proceedings, 2 applications came to be filed. One is, my lord, seeking leave under section 92(1) of the court. Then another application came to be filed for seeking an appointment of receiver in view of the large scale mismanagement. The respondents, my lord, and the defendants in the suit took up the contention that unless leave is granted, my lord, an application under for appointment of receiver, my lord, is not maintainable. We argued the matter on both, holding that appointment of receiver is something different. For grant of leave is not necessary was the contention of the plaintiffs. It's an independent proceeding and it has no bearing on the suit because of the fact that there is this thing for emergent action. Then the trial court appointed, my lord, the receiver. But while for on the application seeking grant of leave, on the same day, the court holds that for the purposes of grant of leave, evidence needs to be adduced, which is against 92. Evidence need not be adduced. My lord, an order, my lord,
granting leave is almost in an administrative nature. Either an advocate general can grant, or if the parties go directly, the court will grant. Without even issuing notice, my lord, leave can be granted. That is the position in law. But curiously, though the trial court held that there is a vast scale mismanagement and directed for appointment of, my lord, the receiver, Tahsildar was appointed as receiver. For the purposes of, my lord, 92(1), grant of leave evidence needs to be. That was a contrary order. We challenge, my lord, that in this. So far as the respondent trustees are concerned, 2 to 9, challenge the order appointing the receiver. Well, this honorable court took a view that before grant of leave, an application for appointing appointment of the receiver, and court will not get jurisdiction to decide that application. That's the view taken, and that was disposed of by a separate judgment, because that came under a miscellaneous first appeal jurisdiction. This is a writ. Well, after that, this petition, my lord, whether evidence needs to be adduced or not before, my lord, the leave could be granted is the issue. The order challenge is Annexure C. At that time, what happened when we filed the writ petition, just before that, the other side, 2 to 9, had challenged the order appointing the receiver. In that, there was a stay of further proceeding. Therefore, in order to avoid duplicacy, no interim order was granted. But that, my lord, was disposed of, my lord, by a judgment, separate judgment. And thereafter, this matter, my lord, be moved, because, my lord, the district court, my lord, is bound by its own order, where the court has directed that evidence needs to be recorded for grant of leave. Therefore, my lord, we moved this application for stay of further proceedings of the honorable proceedings before the district court, because question of leading evidence does not arise. Notice has been given, both of us will be heard, and a decision will be taken by the court. But in view of the order passed, the court, my lord, is little restrained about going over its own order. At that point, some other presiding officer there, now the present presiding officer. That's why we moved this application. Beyond that, there is nothing in this matter. So far as the respondents who are dead, the question of bringing their LRs does not arise, because, my lord, this is a trust matter. There is no independent right of anybody. And in relation to respondent number 30, who is not served, my lord, he is also not a necessary party here. He is an impleading applicant who filed an impleading application supporting the respondents. 2 to 9 are served, who are the trustees, the present office holder, bearers of the trust. Now, the finding with regard to mismanagement, my lord, your lordship will find it at page 40. It starts from page 39. This order has been set aside on the ground that the court has no jurisdiction before, my lord, granting leave. Now the order, my lord, which is impugned before lordship is Annexure C. We start from page 52. The direction, my lord, is at page 64. The petitioners have not adduced, your lordship got 64, my lord. Petitioners have not adduced evidence on IA number 1. IA number 1 is an application seeking leave of the court. Hence, after recording the evidence of respondent, court will pass appropriate order on IA number 1. This is the order. I am challenging this order because at the time of grant of leave, my lord, question of adducing evidence does not arise.
See, but as per your own description,
yes,
only till response number 1 to 10, they are shown as office bearers or trustees.
Correct.
From 11,
correct.
You have not shown any of them as trustees.
No, they are not trustees.
Who are they?
They are the persons, my lord, who filed an impleading application in the proceedings, stating that we are the devotees of the temple. Some persons supported the respondents 2 to 9, the present trustee, some other person stated that we are all devotees and there is mismanagement.
Anyway, you file an application, you file a memo. You don't want to take steps, you file a memo.
I file a memo.
Please file a memo.
They are not necessary party. Their office total no. No, death ಆಗಿದ್ರೆ no need to bring the LRs on record.
ಅದು 15, 26 and 30.
30. No need to bring the LRs on record ಅಂತ ಬರ್ದು. Memo.
You have to say that it is since it's a suit filed under section 92.
Easement.
There is no need to bring the LRs on record.
There is no judgment as such.
It's a suit filed under section 92.
92.
Some of them have thereafter come and impleaded themselves saying they are devotees.
Some of them are devotees, all of them are devotees, some supported the.
Therefore, since it is a suit filed under section 92, there is no need to bring the LRs on record.
Correct.
ಅದನ್ನ ಹೇಳ್ಬಿಡಿ.
ಅದನ್ನ ಬರ್ದ್ಬಿಡಿ.
What about service of notice?
On respondent number 30.
32.
Maybe dispense with my lord. Or I will delay. He is again one of the impeding applicant. My lord, iದೇನಾಗಿದೆ, there are two factions it appears in the village temple. ಅದು ಸೂಟ್ ಹಾಕಿದಾಗ ಎಲ್ಲಾರು they came and they.
Learned counsel for petitioner has filed a memo. Stating that although the respondents number 15, 26 and 30 are said to have died, nevertheless, there is no need to bring the legal representatives on record. Full stop. Learned senior counsel appearing for the petitioner submits that this writ petition arises out of a suit filed under section 92 of the Code of Civil Procedure. And under such circumstances, since respondents number 11 to 26 and some other private defendants. I don't think, see it is, I think who have impleaded are only 30 to 34. Otherwise, you have impleaded them.
Yes.
You have impleaded them.
I will give up, my lord.
Huh?
I have no.
ಏನ್ ಹೇಳಿದೆ? Are either impleaded as devotees or they themselves have come on record as devotees of the temple, and having regard to the fact that the suit is filed under section 92, there is no need to bring the legal representatives on record. Full stop. It is also submitted that notice to respond number 32 may be dispensed for the same reasons. Full stop. Next para. At the risk of the petitioners, notice to respond number 32 is dispensed with. Full stop. The memo filed on behalf of the petitioners as regards deceased, response number 15, 26, and 30 is also taken on record. Full stop. Amala?
Now the order is, impugned order, my lord, starts from 52.
Yes,
I have sought for stay because
you are ready.
Kindly have it tomorrow, my lord.
Huh?
Tomorrow, my lord.
You are ready with some judgments.
my lord, there is a judgment, my lord. which says that
ಏನಾದ್ರು
even
ಇದ್ರೆ ದಯವಿಟ್ಟು
before-
ಅವ್ರಿಗೆ please tell them, because tomorrow they should not come and say ನಾನು ಗೊತ್ತಿರ್ಲಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು. So you please give a copy, let them be prepared. We will have it day after tomorrow.
ಹೌದು.
ಆಗ್ಬೋದಾ?
Next date ಯಾವತ್ತು? day after.
Release this matter on 20th of September. Yes.
Number 18, number Rajkumar.
Yes. Office objections raised on IA number 1 of 2024 by respondent. ಏನು?
I have sought for two prayers in the application. I restrict my prayer as regards vacating of the interim order. Petitioner has deposited about 50,000 pursuant to the interim order passed by this honorable court. And I have sought for permission to withdraw as well as for vacating of the interim order. But I will restrict my prayer for vacating of the interim order. This is arising out of an execution
You are not
proceedings.
pressing?
I am not pressing the permission to withdraw the amount. If the interim order is vacated, I will execute the.
Office objection on IA number 1 of 2024 filed at the hands of the respondent is that there are two prayers made in the application, interlocutory application. Full stop. Next para, learned counsel for the respondent submits that the respondent will restrict the prayer in the application only to vacate the interim order dated 6/7/2023. And the respondent gives up the other prayer regarding permission to withdraw the amount deposited by the petitioners. Full stop. Next para. The submission of the learned counsel for respondent is placed on record. Full stop. IA number 1 of 2024 shall be considered only insofar as the prayer to vacate interim order dated 6/7/2023.
So total decretal amount is 2,92,000. I already filed a 2,25,971.
You know?
Decretal amount is 2,91,000. This is the petition against the execution order. See, execution order, my lordship, kindly see the.
Decree holder is Surabhi Chits Limited.
Please.
Is the respondent hearing? Lordship, kindly see the annexer P. Para 4, my lord.
Award.
Award, ಚೀಟಿ ಬಾಕಿ ಕಂತುಗಳನ್ನು ಪಾವತಿ ವಿಷಯದಲ್ಲಿ ಪ್ರತಿವಾದಿ ಷರತ್ತುಗಳನ್ನು ಉಲ್ಲಂಘನೆ ಮಾಡಿರ್ತಾರೆ. ದಾವಾ ದಿನಾಂಕಕ್ಕೆ ಪ್ರತಿವಾದಿಯಿಂದ ಬರಬೇಕಾದ ಅಸಲು, ಬಡ್ಡಿ, ಇತರ ವೆಚ್ಚ ಎಲ್ಲಾ ಸೇರಿ 2,72,000. That is the.
This is an order passed by the
Against
registrar.
which, yes, against which they have filed a execution. Now, my lordship, I already filed a 2,25,970. Now, my lordship, 60,000 is already deposited here. Now, my lordship, almost only my lordship, I think 36. My lordship, 2,85,000, my lordship already filed. Now, balance is, my lordship, more than nearly 10,000.
Ashte. What do you want? You are questioning what in this writ petition?
That is the warrant order, warrant issue. Arrest warrant.
Annexure A.
Against the petitioner.
Annexure A ಯಾವುದು? ಯಾವ order?
Kindly see, my lordship, annexure A. Page number 26.
heard and perused. On the perusal of the case paper, the JDR 1 and 3 are in more than 2 lakhs of EHR. Therefore, in order of recover balance amount, it is necessary to take steps against the JDR number 1 and 2. Issue arrest warrant against the JDR number 1 through the Chandra layout police. This is my lordship challenge. Your lordship already stated this execution order.
Already execution case was filed in the year 2019.
Yes.
Execution
every hearing date 10,000, 15,000 ಕೊಡ್ಕೊಬರ್ತಾ
But the executing court is of the opinion that you are still due to pay more than 2 lakhs.
That is the wrong. Is the wrong.
Where is your memo of calculation? Where is your memo of calculation?
Page 8, para 16, my lordship.
Page?
Page 8 of the readings, para 16.
Yes.
The execution court, without considering the memo filed by the petitioner dated 12/8/2022, as on the date of petition is due only 1,48,971. Thereafter, respondent received rupees 15,000 on 12/10/22, sum of rupees 10,000, 14/11/22. Total, my lordship, received 2,25,000.
ನೀವು ಇಂಟ್ರೆಸ್ಟ್ ಎಲ್ಲಿ ಬಿಡ್ತೀರಾ?
ಅದೇ ಅವರೆಲ್ಲ ನಾವು ಕೊಡೋದೆಲ್ಲ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
That is the way it is.
Is my lordship.
First it will be taken towards interest.
Is my lordship. This is
thereafter towards principal.
This the expert decree. Any my lordship refer the matter to mediation. My lordship. Refer the matter to mediation.
Mediation ಮಾಡುವಂತದ್ದು ಏನಿಲ್ಲ ಸ್ವಾಮಿ. Kindly similar to annexure R1 which I have produced along with the application for vacating stay.
ಅವ್ರು ಹಾಕೋದೆಲ್ಲ ಬರೀ ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕ್ತಿದ್ದಾರೆ.
The initial decree was passed by the registrar on 9/4/2019. We filed execution petition.
Where is that?
That calculation is at annexure R1, which is produced along with the application.
Page number 40.
No.
Page number 40 is the award.
The award, the first award passed by the court, is page number 40. That is dated 9/4/2019.
ಒಟ್ಟು ಮೊತ್ತ ರೂಪಾಯಿ 2,72,473
plus 18% interest.
18% interest.
Yes, Manoj. To execute this order, Manoj, we filed execution petition 3014 of 2019, page 43. Manoj, the total decretal amount mentioned in the execution petition is 2,92,471. But this was as on 9/8/2019.
Yes.
Challenging the original order passed by the authorities, the petitioner filed appeal before the Joint Register of Cooperative Societies. Annexure E is the order. That is dated 23/4/2021. The order of the original authority has been confirmed.
They filed an appeal.
They filed an appeal. That is confirmed. Now, the execution petition was proceeded further.
Yes.
And before the executing court, they have made certain payments, which has been, the details are in the statement produced along with the application for vacating statements. Page 6. This is the calculation of the amount received and the interest accrued from the date of the decree. Now what they say is the entire amount which they have paid will have to be considered as against the principal amount, and therefore they are liable to pay only about 20 to 30,000 rupees. That is, that kind of a calculation cannot be made insofar as execution proceedings are concerned. The amounts paid during the pendency of the execution petition will have to be first adjusted towards the interest and then towards the principal. On 1/7/2020, they paid rupees 50,000. That was adjusted towards the interest.
60,000 ಕೊಟ್ಟರು ಇಂಟ್ರೆಸ್ಟ್ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ತಾರೆ.
And as and when the amounts are paid, on 25/10/2021, 15,000 rupees was paid, and 26/2022, 10,000 was paid. Now 12/10/2022, another sum of rupees 15,000. Please.
See, please see this column.
Yes.
First column, 31/7/2019.
28 months on the principal amount. 1,94,000.
Interest from April 2017.
Yes.
2019, 28 months. Principal amount of so and so at the rate of 18%.
81,564 my lord is the
It is
interest.
only towards interest.
ಹೌದು. ಅದಾದ ನಂತರ ಪುನಃ 1/8/2019 ಇಂದ 7/1/2020 160 ಡೇಸ್ಗೆ 15,323. Then total interest was 96,887. 50,000 was paid on 7/1/2020. That was
Let us send it to mediation, we'll see.
that's my submission, my lord. This 18% interest is levied. My lord, instead of 18%, if they are ready to pay, let the percentage of interest may be reduced and let them pay it here itself. There is nothing to, my lord, discuss, my lord, before the mediation center. It is arising out of an execution proceeding. Instead of 18%, let them pay at least about 12 to 15%. I will leave it to lord.
See recovery certificate kindly see. Next, sir, see page number 41. Principal amount is only 1,94,000. You are already paid at 2,80,000.
ಹೌದ್ರಿ, ನೀವ್ ಹಂಗ ಹೇಳಕ್ ಆಗೋದಿಲ್ಲ. Now in terms of the award, you are required to pay. You are required to first satisfy the interest.
In COVID period, that is ex parte order. COVID period is ex parte award in the.
You can't say that because you have filed an appeal and you are not successful.
Appeal is also.
How can you now argue about the merits of the matter?
Refer the matter. Refer the matter to mediation. We'll settle.
Allah, again, see, you will only be losing time ಅಷ್ಟೇ.
Interest accrue ಆಗ್ತಿರುತ್ತೆ.
Only interest part ಅಷ್ಟೇ ಇರೋದು. ಅದು we are mediation.
ಅವರೇ ಹೇಳ್ತಿದಾರಲ್ಲ ಈಗ.
18% ಬದಲು 12.
ಮಾಡಿ 12% ಮಾಡಿ.
% ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
No. ಹಂಗಾಗೋದಿಲ್ಲ.
mediation ಮಾಡುತ್ತೆ.
ಬರ್ಕೊಳ್ಳಿ.
Maybe 8% my lord.
Learned counsel for petitioner, Allah, the petitioner as well as the respondents are requested to file a memo of calculation having regard to the award passed by the competent authority, taking the rate of interest at 12% per annum. Full stop. Release this matter on
% per annum.
26th of September.
10%.
You please file memo of
arrears
you first file a memo of calculation, sir. We will see.
29.
Please. Mahabaleshwar Rao ke.
Interim order idea.
Ide.
Interim order granted earlier and extended till next date.
Your lordship, this is also a similar matter where there was a high rate of interest.
Yes, your lordship, last date directed the.
A request had been made to me.
Yes.
I had made a submission to the effect that what they are offering will be lesser than what an FD would yield.
Yes.
I have prepared that memorandum of calculation. I've served my friend a copy.
Where is your memo?
Now memo actually.
There was only a direction to me, your lordship.
Only to the judgment letter.
Yes.
As per the respondent calculation, the total amount he would have had he invested in the bank 2,84,36,352.
That's what I would have got at 8% simple interest from a bank at FD, your lordship.
You have given a copy.
I have given a copy. Now,
Out of 2,84,00,000 he would have get. Now we have paid 1,26,80,000 as of this day. So if that is deducted, it would come to 1,57,00,000 addition. The 24% was the award. The interest awarded in the arbitrator.
You know?
24% interest.
Howದು sir, now they have given a memo of calculation, taking it at 8%.
Yes.
So
2,84,36,352.
Yes, even if it is at 8%.
8%.
Yes.
Now we have paid 1,26,80,000.
ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಡಿ ಈಗ. Have you taken the amount that they have already deposited?
all the amounts that have been deposited have been extracted from.
But no, it is not taken into calculation.
No, your lordship, what has happened is 93 lakhs they have given to me during the during the existence.
In this memo of calculation.
Yes, your lordship.
You have not deducted the amount that was paid.
I have not deducted anything. I have given your lordship
This
just a
only
simple.
shows the amount calculated at 8%.
At 8%, if I had put it in FD in 2009, that's all it
Now,
shows.
it is a fact that he has made payment.
He has made payment of 93
So
lakhs
if
to
you
me.
take that into consideration,
Yes.
what is the balance payable?
According to me, if your lordship were to ask, what is the lowest amount that is recoverable at this stage?
Sir, he has admittedly given some amount.
He has given me 93
Therefore,
lakhs.
if you deduct that amount from this.
Yes, your lordship.
What is the balance?
That would be your lordship. I'll give your lordship a minute.
ನಿಮ್ ಪ್ರಕಾರ ಏನು? ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು ಬರುತ್ತೆ?
1,57,00,000.
171 accordingly payable.
No, 1,26,80,000 according to the.
They have
petition
paid, as per me, they have paid 93 lakhs prior to arbitration being commenced.
1,26,80,000 we have stated before the prayer call. And date of the amount and how it was paid, RTGS and other details were given. And 20 lakhs as per the order of this honorable court, we are.
ಕೊಟ್ಟಿದ್ದೀರಾ?
1
ಇದುವರೆಗೂ ಎಷ್ಟು
crore,
ಕೊಟ್ಟಿದ್ದೀರಾ?
26,80,000.
ಅಲ್ಲ ಇದುವರೆಗೂ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ?
You, up to this date,
26 lakhs?
1,26,80,000.
26 lakhs?
80,000. Which includes 20 lakhs paid pursuant to the order of this honorable court.
ಎಲ್ಲ ಸೇರಿ.
ಎಲ್ಲ ಸೇರಿ.
One crore 57 lakhs 56,352.
I have some dispute with that figure, your lordship.
Yes.
According to me, all that has been paid to me is 93 lakhs, which is a recorded position as well.
He has also included the amount deposited before the.
Yes, your lordship. 93 lakhs plus 20 lakhs. That would be the amount already paid. And if we were to minus the figure that this FT calculation shows, it would yield around 171 that is payable. Now that, your lordship, is a matter of an illustration. At this stage, 2009 money was lent at 24% per annum.
Yes, what do you want to do?
So we will pay the balance amount or some dispute is there about the 9 lakh. We have furnished the details how it was paid, RTGS and court deposit. We will satisfy the respondent about those two payments.
Yes, what
9
about
lakh.
the
If the.
remaining amount?
We will settle it 1,60 lakhs.
Huh?
1,60 lakhs balance paid.
Within what time?
4 installment.
Huh?
4 installment.
4 installments of what time, sir?
4 months. Each month we will pay.
Your lordship, I had made a submission that I would have gotten more from an FD only as a matter of illustration. I am not stating that I want to get my interest to the FD level or somewhere closer at FD level. I have been awarded through an arbitral award at which he was a party, 24% interest. Ideally, I would otherwise recover 24% compounded on monthly rest. The trial court at page 53 has passed an order that you will be given 24% interest, simply calculated. And at the date of that calculation.
According to you, it is 1 crore 70?
According to me, your lordship, if I were to receive money right now at the rate at which the award has been passed, it would be upwards of 3 crores.
No, this one, sir, in terms of the calculation made now.
In terms of the calculation.
1 crore 70?
1 crore 71.
71.
But that, your lordship, is not something I'm ready to accept. If anything, I am ready to accept as on date, after the amount I've already paid, 93 lakhs in trial court and 20 lakhs deposit before your lordship, 268 at the minimum, because that is the calculation that the trial court has bound us to. And at a position 20 years almost after the passing of the arbitral award, without filing an appeal, to now seek umbrage under your lordship's writ jurisdiction would, I think, be unfair on the lender.
At what rate are you asking, sir?
Your lordship, I am asking at the rate that the trial court has fixed.
What?
24%.
20?
24%.
See, it is all good while saying commercial rate 24%. But when it comes to the court, no court will permit you to take it at 24%.
Then may I obtain my instructions and seek if my client will be agreeable to 18%, your lordship? I'll obtain my instructions. If 18% is agreeable simple interest, then your lordship may consider that as a last position.
See, you also have to take into consideration the present position of this person. What are you doing now?
Now he was earlier land development. Now after Corona, he's not doing anything. Now he is in fact bedridden.
You
due to
have
some-
landed property?
The apartment residential house has been mortgaged to this property.
That is what he is trying to prevent attachment of.
Residential apartment. This is the only residential apartment they have got. That is sought to be sold because it is the mortgage to the respondent. To get rid of that is,
You also have to do something.
in fact, last time I submitted your lordship by depositing 1 crore 80 lakhs, addition to the amount 20,000 deposited. We have agreed, but they have not agreed.
I can ask my client
50
to,
lakhs we have deposited.
Ah,
Another 1 crore 80 lakhs we are agreed to pay
ah.
in full and settlement with 5 to 6 or 4 installment which will agree.
I can ask my client to consider an 18% interest, your lordship, but
The learned counsel for respondent has filed a memo of calculation, in compliance with the directions issued by this court on 9/9/2024. Full stop. Copy of the same is served on learned counsel for petitioner. Full stop. Next para. Nevertheless, this court has made some suggestion to the parties. And learned counsel for a respondent seeks for a short accommodation to secure instructions and make submissions. Full stop. The petitioner is also required to submit before this court as to what arrangement he'll make, even if this court were to consider repayment at a reduced rate of interest. Full stop.
as compared to the award.
So that is why I have not said anything.
Very good.
Release this matter on 26th of September.
26th. I'm obliged.
Yes. Interim order
26th,
granted.
25th.
25th.
May I request 27th?
Interim order granted earlier stands extended.
May I make a submission?
25th. Very.
Lordship, may I make a submission, Lordship? Serial number 25, my lord. I'm permitted to withdraw the writ.
Not now. Please wait. 2:30. 2:30.
Okay.
There's an exhibition case which is listed for tomorrow, could be taken at the end of.
ಸರ್ 2:30 ಲಿಸ್ಟ್ಗೆ ತಗೊಳ್ತಾರಾ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ? ಸರ್ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಮುಗಿದ ಮೇಲೆ ಅದಕ್ಕೆ ಹೋಗ್ತಾರಾ?
ಸರ್ ಮಧ್ಯಾಹ್ನ ಫಸ್ಟ್ 2:30 ಅಥವಾ ಸಾಹೇಬ್ರು ಹೇಳ್ಬೇಕಾ? ಈ ಕಡೆ ಬನ್ನಿ ಪ್ಲೀಸ್.
ಸರ್ 10:30 ಯಾವ್ದು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ಲ?
ನಮ್ದು ಸರ್ 40% ನಾಳೆ ಇದೆಯಲ್ಲ? 33. ಹೌದು ಮಧ್ಯಾಹ್ನ.
ಸರ್ ನಿನ್ನೆ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ರಿಟ್ ಪೆಟಿಷನ್ 21049 ಆಫ್ 24 ಅದರಲ್ಲಿ ನಮ್ಗೆ ಅಮೆಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳಿದ್ರು. ಪೆಂಡಿಂಗ್ ಸೆಕ್ಷನ್ಗೆ ಫೈಲ್ ಕಳ್ಸಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು.
ಆಗಿಲ್ಲಮ್ಮ, ಸಿಗ್ನೇಚರ್ ಆಗಿಲ್ಲ, ನೆನ್ನೆ ಸೈನ್ ಆಗಿಲ್ಲ, ಇವತ್ತು ಹೋಗುತ್ತೆ.
ಸರ್ ಸಾಯಂಕಾಲ ಅಷ್ಟೊತ್ತಿಗೆ ಹೋಗುತ್ತಾ ಸರ್?
ಸಾಯಂಕಾಲ ಹೋಗ್ಬೋದು.
ಯಾಕಂದ್ರೆ ನಾವ್ ನೆನ್ನೆನೆ ಅಮೆಂಡ್ ಮಾಡ್ತೀವಿ ಅಂತ.
ಸೈನ್ ಆಗಿಲ್ಲ, ಇವತ್ತು ಆಗುತ್ತೆ, ಸಾಯಂಕಾಲ ಮಧ್ಯಾಹ್ನ ಆಗುತ್ತೆ ಎಲ್ಲ. 2:30 ಮಧ್ಯಾಹ್ನ ಹೇಳ್ತಾರಮ್ಮ, ಮಧ್ಯಾಹ್ನ ಗೊತ್ತಾಗುತ್ತೆ.
ಇವತ್ತು ಸಾಯಂಕಾಲ ಅಷ್ಟೊತ್ತಿಗೆ ಪೆಂಡಿಂಗ್ ಸೆಕ್ಷನ್ ಹೋಗುತ್ತೆ ಅಲ್ವಾ ಸರ್?
ಹೇಳಿದ್ದನಮ್ಮ, ಇನ್ನೊಂದ್ಸಲ
I'm just confirming sir. ಯಾಕಂದ್ರೆ ಒಂದೇ ದಿನ ಅಮೆಂಡ್ಮೆಂಟ್ ಗೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೋಸ್ಕರ.
ಹೋಗುತ್ತಮ್ಮ.
ಥ್ಯಾಂಕ್ ಯು.
ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ.
ಮಂಡಿ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ.
ಸರ್ ಮರಣ್ಣ ಚೇಂಬರ್ ಅಲ್ಲ ಹಾಕಿದಾರಲ್ಲ, ಕಾಸ್ಟ್ ಎಲ್ಲ ಇದೆ ನೋಡಿ ಸರ್. ಮೈಕ್ ಯೂಸ್ ಮಾಡಿ ನಂಗೆ ಕೇಳಿಸ್ತಾರೆ ನೀವು ಮಾತಾಡೋದು ಹೊರಗಡೆನೆ ಮಾತಾಡೋದು. ಯೂಸ್ ಮೈಕ್.
ಇಲ್ಲ ಅದು ಸಿನಾಪ್ಸಿಸ್ ಫೈಲ್ ಮಾಡಕ್ಕೆ ಆತರ ಏನಲ್ಲ ಅದು
ಯಾವ್ದು?
ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ ಮಧ್ಯಾಹ್ನ ಇರೋದು.
ಏನ್ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ನೀವು ಏನು
ಇಲ್ಲ
ಇದಾ
300 ಮ್ಯಾಟರ್ ಇದೆಯಲ್ಲ.
ರೌಂಡ್ ಮ್ಯಾಟ್ರ
ಹಾ
ಏನಾಗ್ಬೇಕಾಯ್ತು ಸರ್ ಅದ್ರಲ್ಲಿ?
ಇಲ್ಲ ಅದು ಮಧ್ಯಾಹ್ನ ಫುಲ್ ಹಿಯರಿಂಗ್ ನಡೆಯುತ್ತಾ ಅಂತ.
ನಮ್ಗೇನ್ ಗೊತ್ತಿದೆ ಸರ್ ಅದು.
ಅದು ಪ್ರತಿದಿನ ಬರ್ತಾ ಇದೆಯಲ್ಲ.
ಡೈಲಿ ಹಿಯರಿಂಗ್ ನಡೀತಾ ಇದೆ.
ನಮಸ್ತೆ ಸರ್.
ಹೇಳಿ ಸರ್, ಕೇಳಿಸ್ಕೊಂತ ಇದ್ದೇನೆ, ಹಂಗೆ ಹೇಳ್ತೀನಿ ಹೇಳಿ ಸರ್.
ಏನೋ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ ಅದಕ್ಕೆ.
ಪರವಾಗಿಲ್ಲ ಹೇಳಿ ಸರ್.
ಅವ್ರು ಕೇಳಿದ್ದೆ ನಾನು ಕೇಳ್ತಿರೋದು ಅಷ್ಟೇ. ಇನ್ನು ಲಿಸ್ಟ್ ಫಸ್ಟ್ 230ನ ಅಥವಾ ಈ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಜನರಲಿ ನಿಮ್ಗೊಂದು
ಅದೆಲ್ಲ ಗೊತ್ತಾಗಲ್ಲ ಸರ್. ನಾನು ಕೇಳ್ತೀನಿ ಸಾಹೇಬ್ರು ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ. ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ನಾವು ತಗೊಂಡು ಅದಕ್ಕೆ ಸಾಹೇಬ್ರು ಕೇಳ್ಬಿಟ್ಟು ತಗೊಂಡ್ತೀನಿ.
ಐ ಆಮ್ ನಾಟ್ ನಾಳೆ ನೀವ್ ಹೇಳಿದ್ರಿ ಅಂತ ಹೇಳ್ದೆ ಅಂತಲ್ಲ, ಜನರಲ್ ಕೇಳಿದೆ ಅಷ್ಟೇ. ನಾವ್ ಇರೋದು ಇರ್ತೀವಿ ಬೇರೆ
collected. In either of the cases, after deficit stamp duty and penalty are paid, impounding effect of section 35 is released and instrument available to the party relying for as evidence. In the event, a party prefers to have the document sent to Deputy Commissioner for collecting the stamp duty and penalty. The court and every person has no option except to send the document to district registrar. The caveat to that is, before the court or every person exercise the jurisdiction of 34, option must be exercised. Section 34, the second 21.2 may not be relevant for the purpose of this case.
Yes.
21.4, Your Lordship.
Yes.
Section 37 of the Act, titled as Instrument Impounded, how to be dealt with. This section arises when a party pays deficit stamp duty and penalty. Court is to impound the instrument under 33 of the Act and has to forward it instrument to the Deputy Commissioner or District Registrar. Subsection 2 of Section 37 deals with the cases not falling under 34 and 36. Person impounding an instrument shall send it to original to the Deputy Commissioner. This includes the exigencies set out in paragraph 21.1. Then 21.8.
Yes.
Scheme does not prohibit a party to the document first invoke directly the jurisdiction of the district registrar. Present the instrument before every person, a court and every person after complaint with the requirement of the duty and penalty. In such an event, an option available objection to under section 33 or 34 of the Act is erased beforehand. Quantum of penalty is primarily between the authority court and opposing party has little role to play. Reverting to the circumstance of the case by keeping in perspective the steps summarized in the preceding paragraph, we notice that before the stage of admission of the instrument in evidence, respondent has raised an objection on the deficit of stamp duty. Therefore, it was the respondent who required suit agreement to be impounded, then send it to the district registrar to be dealt with under section 39 of the Act. In this case, respondent desired the impounding of the suit agreement and collect this deficit stamp duty and penalty. Trial court is yet to exercise its power jurisdiction under 34. On the contrary, trial court called upon a report from the district registrar for all purposes. Suit instrument is still one, and the other steps are summarized in paragraph 21. Therefore, going by the request of the respondent, option is left for the decision of the district registrar. Contrary to these admitted circumstances, though the suit instrument is insufficiently stamped, still penalty of 10 times under 34 of the Act is imposed, though through the impugned orders. Imposition of the 10 times penalty at this juncture in the facts of the case is illegal and contrary to the steps summed in para 21. Instrument is sent to district registrar. Thereafter, district registrar in exercise of jurisdiction of 39 of the Act decides the quantum of stamp duty and penalty payable on the instrument. Appellant is denied this option by the impugned orders. It is right law that appellant must pay what is due, but as decided by the district registrar, not by the court under section 34 of the Act. Then same thing has happened. In this case, the document was impounded by order dated 11/1/2018 by on the objection of defendant while going for evidence. Then, I request the court to examine the stamp duty payable so that it can be sent to the district registrar for payment. Now, by impugned order at page 63, impugned order at page 63. This suit is filed by the plaintiff against the defendant for relief of specific performance of contract and such other reliefs on the basis of the alleged unregistered agreement of sale, suit property dated so and so. Counsel for the defendant has raised an objection for maintainability of the suit on the ground that proper stamp duty and penalty over the suit document is not paid in accordance with law. Plaintiff is ready to pay the required stamp duty and penalty as per law. Sought direction in this regard to specify the quantum over the suit document.
Oh, you made a statement that you are ready to pay the requisite stamp duty.
When the objection is raised, what I meant is I'm willing to pay the stamp duty. Not that I am exposed to 10 times penalty. When I'm willing to pay, the court would have sent it to the district registrar for adjudication of the stamp duty. Instead of that, court would proceed at page 64 to impose a penalty as against 38 lakhs which I'm payable. 10 times penalty comes to 4 crores 18 lakhs. This is a continuous this though the respondent submission is that suit having become dismissed by IA, my petition is not maintainable. I have quoted the apex court judgment If illegality is continuing to haunt me, even for any fresh steps, fresh cause of action, my lords, your lordships have the power under 227 to correct the manifest injustice. I am not trying to say that, my lords, I am not going to pay the stamp duty. All I am requesting is let the document be sent to DR so that, my lords, it will be adjudicated. Whether I go for a restoration of suit subsequent to, my lords, my documents being validated, or as suggested by the learned senior in the last occasion, that there is no bar for a fresh suit. It is left to me. If I have got a financial resource to come back to the court, I will definitely do it. Otherwise, my lords, I'll close it. But this imposition of 4 crores and all, my lords, should not be allowed to be continued to be exist is my humble submission.
Yes, sir.
Not basically two questions I would like to raise. One is, my lord, this chapter 4 consisting of 2 classes or 2 categories. First category is, my lord, impounding process by the court and how it has to see the logical end. That is the first part. Second part is, my lord, after determination of stamp duty and penalty, after its adjudication, when that order becomes final, the party against whom such order was passed, he required to make the payment and stamp duty to the court itself. Then, my lord, under the scheme of the act, I'm explaining. After that, court has to send that instrument along with a certificate saying that this is the impounding process have been seen the logical end. So and so is impounded document. Based on that, he has paid the stamp duty and penalty, and it has to be sent to the deputy commissioner for his certificate. Then, my lord, it has to go to the deputy commissioner. Deputy commissioner there, he have no other business except, my lord, certifying that amount which is sent to the deputy commissioner by the civil court, that has to be acknowledged, that has to be remitted to the credit of the state government. He is certified that what are the amount determined by the civil court is paid, including the stamp duty and penalty. Then it has to send back to the trial court. After this process, then, my lord, the document will be admissible in evidence. This is one process. Second process is, my lord, after he makes the payment, court fees and stamp duty, penalty, everything is paid. Even at that process, Section 39 would come into picture. Deputy Commissioner given discretion under the statute to mitigate the hardship to the payers are concerned. At that stage, my lord, he can exercise the power to refund the penalty amount. He has to determine what quantum of amount to be returned, why that has to be returned, and that amount could be returned. But once, unless and until payment as adjudicated by the civil court is not yet paid, it would not go to the deputy commissioner. There is section 37(2) would not arise. 37 provides in different context. After receipt of that, my lord, the deputy commissioner, either he can seek the refund or he himself can decide that certain portion or part of the amount, he can decide it is hard to him. Instead of 10%, I wanted to reduce it 5%, or 2 times or 3 times, whatever it may be, rest he can refund. This is the later issue. In this matter, my lord, I'm seeing the fact. There is an agreement of sale, a specific performance suit is sought to be filed, and it was filed. Decree is specific performance is sought for. While the suit is in progress, according to fact, an application is moved saying that document requires to be impounded. Then adjudication have taken place, in which 4 crores 20 lakhs was determined as a stamp duty and penalty. Then, my lord, he himself made a statement that I am ready to make this payment. Therefore, half a dozen times matter was urgent from time to time, enable him to make a payment. He has not made the payment. Even to this date, that document is lying with the civil court. It is not yet forwarded to the deputy commissioner. In the meanwhile, suit came to be dismissed. My submission to your lordship is now, there is what would be the manifest illegality in the order of the civil court has to be first determined. My submission, impounding is there. Impounding penalty and stamp duty he requires to pay. he has not yet paid. Suppose, my lord, one contingency is also available in the statute. Suppose if person who suffered such an order, if he has not remitted the amount voluntarily, then, my lord, mechanism is also provided under section 46 of the Stamp Act. May kindly see section 46. Yes. Section 46. All duties, penalties and other sums required to be paid under this chapter. It is also a part of chapter 4 of the Stamp Act. Section 46 is also the chapter 4. May be recovered along with simple interest as such rate as may be specified by the state government by notification, by the deputy commissioner, by distress, sale of movables property of the person from whom same are due, or any other process for the time being in force for the recovery of the arrears. All duties, penalties, and other sum required to be paid under the chapter shall be a charge on the property, which is the subject matter of an instrument, provided that provisions of subsection 2 shall be deemed to apply to all cases which are pending recovery and to proceedings under subsection which have already been initiated. Notwithstanding anything contained in the Registration Act 1908, a note of such charge extinguishment shall be made in the indices described therein, shall be deemed to be the notice under the said act. This is the 46 machinery is there. My lord, no. We are, first stage is completed, determination, adjudication, and that order he has not challenged. Therefore, that order have attained final. So far as that aspect is concerned. Second is now 46 process to be invoked by the civil court. Civil court means they have to send it to the deputy commissioner. Further action to be initiated by the deputy commissioner under section 46. This is, my learned friend, in the present writ petition, my lord, your lordships may kindly see the prayer in the writ petition. They are written in the nature of surety by quashing the impugned order dated 28/2/2019, passed by the learned senior civil judge AMFC Dodballapura in OS number so and so. Annexure D he sought. My lord, no. After that order attained finality and determinations are over, he referring to the latest judgment of the apex court to file the present writ petition. My lord, may kindly see whether the judgment is applicable to my learned friend's case. Shetty's case. My lord, in brief, I wanted to narrate the fact in that particular matter, why section 39(2) was interpreted by the Supreme Court. In that case, what happened was, it was a case of injunction. A relief is sought for based on an unregistered and unstamped agreement. Then an impounding process had taken place there also. Then impounding process had not completed in terms of section 33-34 of the Act, because while court was at the stage of determining the penalty and stamp duty, it had noticed this property would fall in which village. My lord, such an information is very much essential to determine the stamp duty because of SR value and other things. Then, my lord, the civil court thought of that. It is not possible to determine the stamp duty and penalty. Therefore, the civil court, exercising its wisdom, referred the matter to the district registrar to ascertain this property fallen to which village, what is the SR value, what would be the stamp duty payable on the instrument, then penalty, it would be decided by the civil court. That reference was made. When the paper went to the district registrar, he noticed. Then he said, no, I cannot, once the property is, the document is the property of the civil court, I cannot know wisdom in my law to determine all these things. Therefore, he sent it back to the trial. The trial court, my lord, determined the stamp duty and the penalty that was challenged before this honorable court and which went up to Supreme Court. In that context, an argument was advanced before the Supreme Court. The civil court once referred the matter to the deputy commissioner under section 39(2). That civil court should wait till adjudication by the deputy commissioner under section 39(2). Unless and until that adjudication have taken place for determining penalty and stamp duty.
Just pass on this order sheet. Sorry, I didn't notice it earlier. 11(1), there is impounding. Subsequent date, the learned judge would write to the DR asking for calculation of stamp duty and on your lordship's left hand side. 11/1/2018 is impounding. 21/2/2018, write letter to DR for securing the stamp duty details.
Correct. In that matter, it was happened. Then, my lord, when the matter went up to the Supreme Court answered in a very limited context, interpreting section 39. My lord, one thing I would like to make it very clear to our lordships, and it may be very much required to bear in mind. The section 39(2) would applicable. And following the stamp paper sent to the deputy commissioner under section 37. 37 contemplates a provision for remittance and certificate. Thereafter, my lord, all other process. In certain cases, my lord, it happens. Section 34 of the Stamp Act, your lordship see. Even impounding would also be amenable to the discretion and the power of the deputy commissioner in certain cases. Section 34 specified what are those instances. Section 39 is applicable so far as deputy commissioner is concerned when a matter is before him for impounding process under section 34, but not under section 33. 34, there is a two compartments are there. Some documents are concerned. Law itself made it very clear that impounding should be undertaken by the deputy commissioner. So far as the documents which are required to be undertaken by the deputy commissioner under section 34, then 39(2) is applicable to him. He can take a decision imposing the penalty and other things. But once the impounding process have been commenced under section 34, 33 of the Stamp Act, unless and until requirement to payment have been made and the document was certified by the court saying that this is the penalty and stamp duty, we are collected, please acknowledge the receipt, send a certificate of receipt. Then, my lord, the question of exercising any discretion by the deputy commissioner would not arise at all. Therefore, in our case, inviting your lordship's attention to section 39(2) would not applicable, would not arise at all is my submission. May I kindly see the judgment of the Sita Rama Shetty's case for a moment. Milord, in which your submissions, Roman 2 para heading is submissions and type. Paragraph 11, Milord, in my judgment, I had a copy of.
Yes.
Yes. The learned counsel for the appellant firstly contends that suit document conform to the requirement of the act and the suit for conjunction. Considering the total circumstances, it is argued that even if the suit document is not stamped correctly, but having regard to the order dated 12/8/2017 and 10/8/2018, trial court ought not to have decided the deficit stamp duty and penalty under section 34 of the Act. My lord, what is the order of 12A and 10A? Your lordships will get, my lord, at the page, paragraph, first paragraph of the order itself. Restraining the respondent from interfering with the deceased relief. The plain schedule property consists of agricultural and Kavuri village of Mangalore Taluk. Prayer for injunction. Then, my lord, if we entered into an agreement of sale dated 26/1999, the appellant claims to have put in possession of the plain schedule property as part perform agreement of sale. The other clauses covered. Then, my lord, paragraph 6 may kindly be seen. The respondent filed an application before the trial court under section 33 of the Act to impound the suit agreement to collect the sufficient stamp duty and penalty in accordance with Act. By order dated 10/11/2016, trial court sent the agreement of sale dated 29/6 to the district registrar or determination of requisite stamp duty and penalty payable on the agreement of sale. This is the fact. The distinguishable fact is, in the initial stage itself, document is sent to the deputy commissioner for impounding to determine the penalty, stamp duty and penalty. It was not the case, a fact situation in the present case. In the context of this background, Supreme Court said, civil court, once you refer the matter to the deputy commissioner for determination, if he says it is not possible for him, you could have been sent it back and get it done by the deputy commissioner, not by the civil court. Therefore, civil court is wrong. Therefore, the trial court said, Supreme Court said, they set aside the order, directed the civil court to comply with section 39(2). That was the fact situation. In the light of the fact and circumstances of that case, this is the judgment passed by the civil. My lord, this question which you have, my learned friend, argued, that is covered by 2019 judgment of the Supreme Court of Coordinate Bench, my lord. Roasted here. 2019 3 SCC page 7, Gangappa and another versus Pakirappa. Idilwa. Lord, in that your lordship may kindly go to paragraph 2 of the judgment. It is also arising out of Karnataka Stamp Act. Para 2, my lord. The brief facts of the case necessary to be noticed for deciding this appeal are: the appellant plaintiff entered into an agreement to sell with the respondent defendant, earnest money so and so paid. Suit OS paying for specific performance for the contract. Suit filed by the sister of the defendant in so and so. Principal defendant impounded the argument agreement to sell filed by the plaintiff in OS. Direction to the plaintiff to deficit the duty and penalty wide order dated so and so, so and so. This is para material to the facts involved in my learned friend's case. This question was answered. Your lordship may kindly go to para 4 onwards, para 8 onwards. Para 8, my lord, the Supreme Court has taken note of the examination of impounding instrument as per section 33. Then, my lord, section 34, it relevant, it is extracted. Then, my lord, section 38. 38, your lordships may kindly see for a moment, my lord, para 10. Section 38 empowers the deputy commissioner to refund penalty paid under subsection 1. May kindly make a note this language, my lord. Section 38 empowers the deputy commissioner to refund the penalty paid under subsection 1 of section 37. Section 39 relates to the deputy commissioner powers to stamp instrument impounded. Section 38, section 39 are as follows. Deputy commissioner's power. When a copy of an instrument is sent to the deputy commissioner under subsection 1 of section 37, if he may think fit, refund any portion of the penalty in excess of 5 rupees which has been paid in respect of such instrument. May kindly see the language below. Unless and until payment is made as determined by the civil court, deputy commissioner's power in respect of an impounding covered under section 33 does not arise at all. Section 39 confers some independent power to the deputy commissioner, determine the impounding in respect of certain documents. Therefore, 33 to 37 is one aspect of the matter. 38 is another aspect of the matter. 39 is the entirely a different and totally an independent provision under the scheme of the Act. May kindly see me not this. When such an instrument has been impounded, only because it has been written in contravention section so and so, Deputy Commissioner, we refund the whole penalty so paid. This is the scheme. Then Deputy Commissioner powers to stamp instrument impounded. When the Deputy Commissioner impounds, may kindly language may kindly be seen below. When the Deputy Commissioner imports an instrument under section 33, receives an instrument sent to him under subsection 2 of section 37, not being an instrument chargeable with a duty, not exceeding 15 paise only, or a mortgage of crops, etc., etc., then your lordship may go back to section 33 for a moment. What are the documents to be sent to the Deputy Commissioner provided under section 33? Section 34, your lordships may kindly see. Instrument not duly stamped inadmissible evidence. Section 33, examination impounding of instrument. That is civil courts. Then section 34, no instrument chargeable with duty shall be admitted in evidence for any purpose by any person having by law, consent or party's authority receive the evidence, provided that, may kindly see the proviso, any such instrument not being an instrument chargeable with a duty, not exceeding 15 naya paise, only or a mortgage crop chargeable under clause A and B of section 3, with a duty of 25 naya paise shall be subject to all, be admitted in evidence on payment of duty which same is chargeable in the instrument insufficiently stamped. The amount required to make such duty together with penalty 5 rupees then times another proper duty sufficient portion exceeds, where a contract of agreement any kind is effected by correspondence consisting of two. Then, my lord, these are all the documents. Then, clause D may kindly be seen. Nothing herein contained shall prevent the admission of any instrument of any court when such instrument has been executed on behalf of the government, where it bears the certificate of the Deputy Commissioner as provided under section 32 or any other provision, etc. This is the certificate. Then, my lord, your lordship may kindly go to section 35, my lord, for a moment. This is the entire scheme is totally sufficient, different, my lord. Admission of instrument were not to be questioned. Section 35. It is, my lord, once the document is admitted, even by oversight, it could not be revived, but however, division bench reversed this proposition of law. Now it is not prevailing. Then go to section 37, my lord. 36 may kindly. Yes. The state government may make rules providing where an instrument bears a stamp of sufficient amount, but improper description it may on payment of the duty, which may be chargeable, certified to be duty stamped, etc. Then 37. When the person impounding instrument under section 33 has by law or consent or party's authority to receive the evidence, admit such instruments in evidence upon payment of a penalty, may kindly make a note, and provided by section 34 or the duty provided by section 36 shall send to the Deputy Commissioner authenticated copy of such instrument together with a certificate in writing stating the amount of duty and penalty levied in respect of thereof, and shall send such amount, may kindly, to the Deputy Commissioner, such person as he appoint in this behalf. That means Once impound process is completed by the civil court, it would come to an end only by virtue of section 37. If it is not there, then 39 would not come into picture. Then your lordship may kindly go to section 39 for a moment. 38 may kindly be seen. Okay. Two other, the airline is there. Other question, sir. I can read it, sir. Yes, in every other cases, the person so impounding an instrument shall send it to the original to the deputy commissioner. In every other cases, in other cases means covered under subsection 2 of section 34. That is lease and other things are concerned. It is concerned. It is not related to impounded documents. Then, my lord, if it is read in that context, section 37 subsection 1, having an inconsistent effect is subsection 2 of section 37.1. Or in other words, I put it away, section 37.2 in such a way it is interpreted by your lordship, section 37.1 would become redundant. It has nothing to play in the statute book. That would not be the intention. That is the reason your lordship may kindly go to section 38. When a copy of an instrument is sent to the deputy commissioner under subsection 1 of section 37, may kindly they employed only, he may, if he thinks fit, refund any portion of the penalty in excess of 5 rupees, which has been paid in respect of such instrument. My lord, here the discretion is given after make payment of stamp duty and penalty. My lord, scheme is this. Document impounds. It will be, the penalty and stamp duty will be determined. Civil court send it to the deputy commissioner. After collecting the amount, that amount and instrument will go to the deputy commissioner. He will certify. It is received, acknowledge, he send it back. After he send it back, it will be marked as an evidence in the document. This is one process. Second, section 38 empowers the deputy commissioner to refund certain amount exercising its discretion. We have no complaint. A plaintiff in a suit, at his instance, when an impounding process is instituted, he have a role to play up to 38, subsection 1. When 38 comes and refund is ordered, we have no complaint. It is a complaint between the authority and the state government. We have nothing to do with the same. We can make a complaint to your lordship by filing a writ petition. This has been arbitrarily decided. We can make a complaint. Ultimately, the High Court has to decide that. Then your lordship may kindly go to 39.1 minute. Melody, this is language is so clarity, unambiguous, and very, very clear. When the deputy commissioner may kindly see me, when the deputy commissioner impounds any instrument under section 33, Milord may kindly see the language. 39 is not applicable to a deputy commissioner in respect of an impounding process completed by the civil court. It would applicable where deputy commissioner impounds the document. That means under the scheme of the act, there are two agencies are given power to impound the document. One is the civil court, another is the deputy commissioner. In certain cases, civil court is there. In certain cases, deputy commissioner. 39 will comes into picture where an impounding process is undertaken at the instance of the deputy commissioner, but not otherwise.
See the next sentence.
Next sentence, I will read it.
Or receives any instrument sent to him under subsection 2 of section 37.
Correct. 37.2, what I am saying so is, 37.2, I read it. 37.1, he has to comply with that. Thereafter, 37.2 will come into picture. Then he can do it. We have no complaint about section 39 power is concerned. Question is whether 39 could be adjudicated by the deputy commissioner without making actual payment as determined by the civil court or not. That was the question we are raising here. This was answered by 2019 Supreme Court that I wanted to take it to a lot. May kindly go to this 2019 for a moment. Then, my lord, paragraph 11 refers to section 34. Then language and 39 1B is also referred to. From paragraph 14 onwards may kindly be seen. The above provisions indicated that if the deputy commissioner is of opinion that such instrument is chargeable with duty, is not duly stamped, shall require the payment of proper stamp duty with a penalty of 5 rupees. The later part of the provision case states, if he thinks fit an amount of exceeding 10 times of the amount of the proper duty or benefit portion thereof which such amount exceeds falls short 5 rupees. Thus, discretion has been conferred upon the deputy commissioner, which is apparent from the words, if he thinks fit. The deputy commissioner has discretion imposing penalty of 10 times or lesser of the amount of duty of the portion thereof. There is a clear contradiction between power under section 33 and 39, which I address your lordships. The object and purpose of such contradictions in the provision and power is not far to seek. Section 33 applies to every person having by law or consent party's authority to receive the evidence. The every person in charge of a public office. Thus, section 33 covers the host authorities, person before whom instruments are filed. The legislative scheme does not indicate any distinction between a court receiving an insufficiently stamped instrument in evidence and other authorities. All have to impose penalty of 10 times in the duty and deficit portion. If it is exceed rupees 5, the provision is for the purpose of maintaining uniformity in imposing a fixed penalty of 10 times. Adjudicatory process regarding 25. Subsection 2 refer to, then section 37, para 15. The amount and duty and penalty is required to be sent to the deputy commissioner under section 37. 37 quoted as follows. When the person impounding, I read it to your lordship, section 37, 2 is also I read. The deputy commissioner under section 38 is empowered to refund any portion of the penalty in excess of 5 rupees, which has been paid in respect of such instrument. Section 38 subsection 1 again uses expression, if he thinks fit. Thus, in a cases where penalty of 10 times has been imposed, the deputy commissioner has discretion to direct the refund of the penalty in clearly indicate, in fact, particular case. But the legislature has never contemplated in all cases penalty to the 10%, 10 times should be ultimately realized. Although the procedural part of not given discretion under section 33 for imposing any lesser penalty than 10 times. However, when provision of section 38 is read, discretion is given to the deputy commissioner to refund the penalty. This is precisely my argument. My argument is, I have no complaint. Suppose if he paid 4 crores 20 lakhs, tomorrow document is impounded and marked. If it is sent it to the deputy commissioner, if the deputy commissioner wiped out entire penalty, we have no complaint at all. Now my submission is, a power conferred upon the civil court where it's a custodian of a document which is subject matter of an adjudication of impounding process, that has to be completed. Then section 38 comes into picture. Suppose, my lord, if 38 we have not reached, I will put it this way, my lord. But civil court cannot say it has no powers at all. That is the reason I took your lordship to section 46. Suppose, my lord, it will be the question in everybody's mind. Suppose impounding is there. I don't want to prosecute the suit. I washed off my hands. I wanted to keep very peacefully in my home. It is for me, I can peacefully. But the court is concerned. Court has to refer this document to the deputy commissioner under section 46. 46 recovery mechanism is provided. Ultimate object is when an impounding penalty and stamp duty is determined, it cannot be, state should not be made missing of that amount in one way or the other. Lord, may kindly see this judgment in further. Lord, para 17 may kindly be seen. In the division bench judgment of Karnataka High Court, in Digambara Varti's case, after noticing the provision of section 33 and 34, division bench laid down the following para 36. The provision refers to the power of the civil court, which admits the document in evidence. The main section is courteous in negative. Unless the instrument is duly stamped, it is inadmissible in evidence. As an exception, proviso provides for payment of duty and penalty. In matter collection of duty and penalty, no discretion is vested with the authority admitting a such an instrument in evidence. The duty payable on the instrument is prescribed as statute. Therefore, there is no question of any discretion being vested with the authority impounding the document in the matter of collecting the duty. What I am saying is, now that process is completed at attained finality. Now he cannot say, by virtue of so and so, I am entitled to make a bargain with the deputy commissioner. I am not going to pay this. Let the document be sent to the section 39(2). That argument would not be available at all. Once the duty payable is attained from the statute, no discretion is vested with the authority admitting the document in evidence. In the matter of imposition of duty and penalty, the words used in the said proviso is shall. It is mandatory. However, section 35 makes it clear that an instrument has been admitted in evidence without there being objection at the time admitting the said instrument in evidence. Section 58 be called in question at any stage of the same suit or proceedings on the ground that instrument has not been duly stamped. Section 58 deals with power of the appellate court to review the finding recorded by the original court under section 34, either suo motu on application of the deputy commissioner. Section 36 of the Act deals with admission improperly stamped instrument. State government may make the rules, etc. Then para 18. The above view of the Karnataka High Court, there is no discretion vested with the authority impounding the document in the matter of collecting the duty under section 33 is correct. May kindly make a note. The word used para 18, first 3 lines. The word used in the said proviso is shall. Section 34 clearly indicate penalty imposed has to be 10 times. The division bench of Karnataka High Court in so and so rightly interpreted the provision 33 and 34. We thus, after view that High Court on the impugned judgment did not commit any error relying on the judgment of the division verdict. My lord, whole argument I developed before your lordships, it is fully in consonance with Digambara's case. And this judgment of 2019 is not overreached by the later judgment of the Supreme Court. It is referred to also. Then there is one more aspect which needs to be noted. My lord, this is section 37 onwards. There is one more aspect which needs to be noted in the present case. We have seen that even though 10 times penalty has to be collected, imposed by the person, impounding the document under section 37, section 38 empowers the deputy commissioner to refund the duty. The learned trial court, while imposing penalty at the rate of 2 times, has given the following reason. It is in respect of factual aspect. Then go to para 20 minutes. This is important. The order of the trial court was passed on 22/4/2013. That is more than 5 years ago. In view of impounding the document and imposition of penalty, we are sure that suit must not have been proceeded further. It must be at the threshold stage, asking the appellant to deposit 10 times of the penalty and thereafter invoke the judicial deputy commissioner under section 38 to refund the penalty. My lord, there would be no conflict between the Sitaram Shetty's case and this case. In both the matters, my lord, powers of the impounding process have been totally upheld in the light of Digambara's case. But what is further advised in this judgment is, it is your will and wish. If you want to claim any refund, you go and seek refund from the deputy commissioner. Now, my lord, in the context of this legal petition, how my learned friend want to contend that the order of determination of 2019 is manifest arbitrary one. All right, my lord, I agree with you for a moment. Unless and until it is not challenged at the right point of time, after dismissal of the suit, it is the earlier order directing him to pay the penalty and other things is merged with the latest order or dismissal of the suit. When it is dismissed, he filed the CRP before this honorable court. CRP is also dismissed. That order becomes final. Well, I am not going to advise my learned friend, which my experience I would like to say. If at all he wanted to reopen the things, it is for him to reopen from the stage of CRP itself by carrying that order in appeal to the Supreme Court or otherwise. In other words, he has to pay the stamp duty and penalty. He can take the document. However, on that I direct your lordship that Order 7, Rule 11, Order 7, Rule 13, protecting his interest. May I kindly see that provision, my lord? So when interest of a person who is before the court is protected under the law itself, I wanted to show it to your lordships now. Order 13 may kindly be seen. The rejection of the plaint of any of the grounds hereinafter mentioned shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action.
Order 13 rule?
Order 11, Rule 30, Order 7, Rule 11, 30, Order 7, Rule 30.
Yes.
Where a rejection of plaint does not preclude presentation of fresh plaint. The rejection of the plaint on any of the grounds herein before mentioned shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of same cause of action. Lord, what more a statute could protect the interest of a litigant better than this, my lord? I am not able to answer for that question. Only thing is, my lord, at present, he has to invest 4 crores 20 lakhs. Then he has to file a suit. He can go to the deputy commissioner. He appropriated portion of the amount on the deputy commissioner, he will get refund either its entirety or otherwise. Therefore, there would not be any confusion to say section 37, 38 and 39 or section 37 and 39 gives an independent power sitting over an adjudication made by the civil court under section 33 of the Act. This is my substance of argument. The later judgment, what my learned friend refers to it is arising out of a different context. I said, Deputy Commissioner refer the matter for determination of stamp duty by the civil court itself. Then it took back. It itself decided. Therefore, Supreme Court, about 9 paragraphs, Supreme Court clearly said in this case, in this case, in this case, in this case, in that way, law was stated to have been rendered by the Supreme Court in that later judgment of 9. Anyhow, 2000, this later judgment also referred to the judgment of my lord Digambara's case. My lord, I think your lordships may kindly have this ILR 2012 Karnataka, page 2099. Padi. My lord, para 59 may kindly be seen. 58, my lord, at page, my lord, 2160. Can I read 58, my lord? In
Yes.
view of the aforesaid judgment of the apex court, it is clarified that observations made in the judgment of K. Govinda Gowda's case should neither be treated as binding by the learned single benches or subordinate courts, other judicial forums, nor should that order be relied upon for the purpose, any purpose, etc. In that case, my lord, what has happened? I was the advocate appeared for Govinda Gowda in that matter. It had come up before Honorable Justice Sridhar Rao. where, my lord, a question was raised. Under the Stamp Act, if a statute gives a discretion to an executive authority in extending concession, why not for the judiciary? It is in the context of the provisions under section 33 and 37 of the Act. The lordships have taken the view the statute is discriminative in nature because it extends a different treatment between the civil court and the deputy commissioner. Therefore, the lordship said, even the civil court have a jurisdiction to impose a penalty of 5 rupees as it is permissible by the deputy commissioner. While this judgment was not challenged either by the state or anybody else, anyhow, it is my instruction, my client claimed the benefit of judgment in another way. I am not going to comment upon that. I am not going to comment upon that. Now, paragraph 59 may kindly be seen. Section 39 of the Act deals with the power of the Deputy Commissioner to stamp an instrument. When he imports the instrument under Section 33, he receives an instrument sent to him under subsection 2 of Section 37. If he is of the opinion that instrument chargeable with duty or is not duly stamped, he shall record to payment of proper stamp duty amount required to make up same, together with a penalty of ₹5 if he thinks fit, and an amount not exceeding 10 times of the amount of the proper duty and defendant portion if deficient thereof. Where such amount exceeds, falls short 5 rupees. Here again, discretion is conferred upon the deputy commissioner. This is important. Impose a penalty less than 10 times of the duty payable. Therefore, section 38 and 39 of the Act confers powers upon the deputy commissioner levy penalty on an insufficiently stamped instrument, on an instrument which is not stamped at all, less than 10 times the penalty payable thereon under section 34 of the Act. However, such discretion conferred on the deputy commissioner should be exercised in a judicious manner. He will be exercising quasi-judicial power. Therefore, he has to take into consideration the facts of the case and circumstances, etc. The reason given either are not paying the stamp duty, insufficient, etc. The set order reducing the penalty should not be arbitrarily whimsical. Otherwise, it may give scope of abuse of such powers. Very intentional legislature enacting the provision of penalty would be defeated. Therefore, merely because, my lord, this is important, merely because deputy commissioner has been conferred under the statute power to levy the duty less than times, such a power cannot be exercised mechanically without application of mind, without assigning the such reason. What would be serve object which penalty provisions introduced in the Act, which in fact is a nature of terrorism, so the duty payable on the instrument and property paid, attempt to avoid the payment of requisite duty is discouraged. Section 67A he refers. This paragraph 59 is read into by the Supreme Court in 2019 judgment also. They conferred and they distinguished area of operation of section 33, 37, 39 and other things.
Yes.
This is the law, my lord, my submission. Now the question is whether is there any prayer made by my learned friend seeking quashing of that order without making the payment determined in 2019 after a lapse of 5 years, when that order have already been attained finality and merged with CRP order of the learned single district. But one more fact I would like to narrate is, if suppose whether this incident, non-payment of stamp duty and court fee, whether it fallen under 11, Order 7, Rule 11 or not is one of the question I would like to put to your lordship's consideration. Your lordship may kindly go to Order 7, Rule 11, Miller. Rejection of plaintiff, your lordship's may kindly.
Yes.
My lord, plaint shall be rejected and following. A is not necessary for us. Then my lord, the B, where the relief claimant is undervalued. Could you lord, order 7, rule 11,
Yes.
clause A, my lord. It is not necessary, my lord, for our case. Where the relief claimant is undervalued and the plaintiff, on being required by the court, language may kindly be seen, to correct the valuation, which is a time to be fixed by the court, fails to do so, where the relief claimant is improperly valued, but the plaintiff is written upon paper sufficient stamp, on being required by the court to apply, requisite stamp paper within time fixed, where the suit appears from the statement is barred, then plaintiff has to be rejected. Now, a determination for stamp duty is related to undervaluation of the subject matter. It is fallen under Order 7, Rule 11, Clause B and C. After adjudication.
Valuation of the plaint, sir.
Correct, valuation of the plaint. It depends upon the market value of the property. Anyhow, what I would like to submit is
Yes.
the order passed by the trial court. It is in default of non-compliance of Section 33 and other process is one aspect. Whether it could be construed and an order under Order 7, Rule 11 is also one aspect of the matter. This is another aspect of the matter. That is the reason, my lord, my submission to my lord, one more submission is 227, my lord, cannot be equated with power of 226. My lord, in Radhesham's case reported by the Supreme Court in 2015, Supreme Court said it is only a corrective jurisdiction. It is not a jurisdiction which your lordships are exercising under Article 226. It's a power of superintendence. Power of superintendence of the civil court and power of superintendence over the other tribunals, both are different contexts. Your lordship is aware, at one point of time, it appears 9 judges of our High Court sitting in full bench have taken the view that any adjudication under 227, irrespective of the fact whether it is tribunal or a civil court or whatever it may be, intra-court appeal would not provided at all in law. That was the 9 judges judgment. Then it was referred to the 11 judges by the larger bench, where it had distinguished, referring to the later judgment of the Supreme Court, they said, of course, there would be no intra-court appeal as against the order of the civil court. But the intra-court appeal is sanctioned so far as order passed by the other executive or the tribunal, though it is fallen under Article 220 of the Constitution. My submission to your lordship is the corrective measure available to your lordships under Article 227. Normally, my lord, it could be where the suit is pending and the suit is decided and it is merged with CRP's order passed by the learned single judge. Dismissal order is declined to recall by the learned single judge. Suppose, my lord, if a lordship directs the trial court to restore the suit and send the document, it amounts to sitting over the order passed by the coordinate strength of the judge of this honorable court, where it is judicial discipline would not permit to do so, my lord, it's my submission. That is the reason I suggested, if you have any remedy, my lord, it's a remedy to challenge the CRP order, or he can go to the CRP court, not by way of an independent writ petition. There would not be any occasion for your lordships to invoke 227. Nothing is there to supervise now. Nothing is there to supervise or correct it. A correction is sought for in CRP. My lord, your lordship is aware, 115 and 227 both are a corresponding powers is conferred upon the High Court to the extent of certain orders are concerned, subject to provisions employed under Section 115 and 227 of Constitution. Now, no proceedings are there. Superintendence is sought for in exercising civil jurisdiction under 115. That was confirmed. Now, there is nothing is on record to correct it. Therefore, writ petition, my lord, itself is not maintainable to be entertained in my respect. I am grateful and thankful to your lordships. From the fact not pass on one judgment, not delay and taxes. Same thing is not the controlling of the internal. There's no key. Petition, delay and digestion of approaching the court. Petition can be dismissed at initial stage even if the provisions of strictly apply to the petition. That not which is called out not in the but next thing is not the senior counsel already submitted that not the writ petition itself is not maintainable for some from that not since not the order was not the process. Dismissal order was passed on 24/10/2019. OS was dismissed on 24/2019. This order was passed on 28/2019. After a lapse of not 4 to 5 years, not he has come up with. Apart from that, not after this order 28/2019 order, subsequently order was passed, which was challenged before by the not the petitioner hearing. Not same was not the attained finality in share. Again, not one at the most. Not he wanted to not the file a petition, not the only share is maintainable, not the not the. When my learned friend refers to 1.1, clarify me. He said that he has not challenged said order on merit. My submission to section 11, explanation 4 or 5 in CPC. It says, there an occasion for me to challenge a particular order. I ought to or might have been challenged. If I have not challenged, if on that count, since I have not challenged that now I wanted to challenge, it would also attract at section 11 of the CPC. The explanation is very clear. Because when he challenges the order before the civil court, civil division petition, it is open for him to challenge that rejection of plaintiff order also. He has not chosen to do that. It doesn't mean that I keep it alive for time when a time comes to me to revive. Such a revival is not permissible because of 11 of the CPC is my submission. Anyhow, your lordships, in while hearing the matter last occasion, it appears doubted. And a point is taken note of in my lordship's order about maintainability also. I'm grateful.
We have a clarification. Delay, my lords, I have explained in para 10 of our petition as to what caused the delay, and that has not been refuted by lords filing the objections. Para 10 of our petition. Now, my lords, please take the judgment which I quoted 2nd September 2024. Not the in case of Sitaram Shetty versus Monappa Shetty. Page 25, my lords. Page 25. Last page 25. End of para 22. What melee? In this case, lordship sir, melee. Page 25, my lord, stop. In this case, respondent desired the impounding of suit agreement and collects duty and stamp duty, deficit stamp duty and penalty. Trial court is yet to exercise a jurisdiction under section 34 of the Act. On the contrary, trial court called for a report from DR for all the purposes. Suit instrument is still at the one stage or the steps mentioned in para 21. Now, the order sheet which I pointed out would indicate that after impounding, the learned judge would write a letter to DR on 21/2. Lordships at the bottom, 11/1/2018 is the impounding order. On the right hand, left hand side of the lordships, will not see. 11/1/2018 is the impounding order. 23 to 2018, the learned judge would write to the district registrar asking for my lord's adjudication.
Impounding on the basis of the objection raised.
Yes. This is not in dispute that they objected it, then my lord's impounding was done. So therefore, my lords, as held by the Honorable Supreme Court, 23 to 2018, he would send it to the learned judge, seeks a report from the district registrar, as my lords happened in the present case of Honorable Supreme Court in Sitaram Shetty's case. Therefore, my submission is not the latest judgment would applicable in all facts. My submission, therefore, my
Then, copy ಕೊಡಿ.
I will place it along with it.
Yes.
It is in my objection, your lordship.
ಇದೆಯಾ?
ಅದು I think ಆ ಕೇಸಲ್ಲಿ Supreme Court ಅಲ್ಲಿ the entire instrument was sent to the deputy commissioner by the civil court, saying that this property fallen which village is not forthcoming. Therefore, I could not able to lay my hand to determine the stamp duty. You please assist me. And what would be the stamp duty according to SR value? That is, it is only, my lord, what information is sought for is not forthcoming. Therefore, it cannot be said that it is equated with the facts in the later case. It appears it may not be correct. In the absence of any material to in par with the judgment rendered by the Supreme Court in 2024. Grateful.
There's a copy. There's a copy of order sheet in the
ಕೊಡಿ, ನೀವು ಕೊಡಿ, ಅವರು ಹಾಕಿದಾರಂತೆ.
His objections at page 49 and 50.
ಇದೆ.
Correct. Grateful.
Heard, reserved.
Matter was pending. Here in order the matter was already not.
Copy ಕೊಡಕ್ಕಿಲ್ಲ.
Yes.
Xerox ಕೊಡ್ತೀನಿ.
No, 62. Suhas Kriel. B. Santosh, party in person.
May I please, my lord? My lord will recollect that
Yes,
lordship had
I
heard
remember.
this matter in great detail. This is regarding an EP.
You are not a party to the suit.
Precisely, my lord. I was not a
The
party to
amount
the
was
suit or the
deposited
EP.
by the registry in your bank.
Precisely, my lord.
So there is no privity of contract between this person and you.
Precisely.
That
my
is
lord.
your contention.
That is one. The
So
other
he
is
could
on
not have
limitation.
filed any application.
Pardon me, my lord.
He could not have filed any application.
Against
in-
me.
In the said suit,
Against me. That is the first.
the
aspect.
execution case for recovery.
Precisely, my lord. And this most important aspect is on limitation, where it is a 2003 matter. EP was closed in 2003.
Yes.
And now in 2020, an application was filed. In 2023, it was ordered. Grateful, my lord.
Yes.
This amount was paid to the.
You understood what is the objection?
I have understood.
There is no privity of contract between you and this
Understand.
bank.
The, what
In
I'm trying
a
to say,
execution case filed by you, filed by
Filed by somebody else, my lord.
against you,
Canara Bank. No,
No, no,
no,
no.
he's the option purchaser in
option
the
purchaser.
matter.
auction purchaser.
my amount is not returned. Part of the amount only is returned,
Which amount?
auction bid amount.
So therefore, this bank is not a party to the proceedings.
No, but on the amount
Please
was,
understand the objection, sir. This bank is not a party to the proceedings. How could you file an application in that execution case for recovery of your amount, which you had deposited before the court? Your concern or your claim should be against the court. How did you file an application seeking recovery from this bank, which was not a party to the proceedings?
Your Honor, there is an order.
Technical objection.
No, I have deposited the money to the court.
Correct,
Court in turn has deposited the money to the
Correct.
bank and the deposit is in the name of the court.
correct.
The court has ordered for return of the entire
You
amount.
can only claim against
No,
the
they have-
court.
There already an order to return their entire money.
Yes,
In this connection, a police complaint was filed by the Honorable Principal Civil Judge in whose name this deposit was kept.
Yes. So
There was
at best,
misappropriation of money in this
at
case.
best, you could have raised a claim against the court.
No, I have made so many complaints.
It is only against the court
I
that
have-
you can raise a challenge or seek a claim. Where, how is it possible? How is it permissible for you to file an application against a party who is not a person who is not a party to the proceedings?
But they have received this amount.
Huh?
They have received this amount because of the misappropriation, a criminal case had to
Very
be filed.
difficult for me to
No, I will
explain.
just explain my stand.
This is the problem when party in person appears.
Just try to,
Yes.
I'm making an effort to
Yes.
tell you. The,
You could have filed an application. Look here, I have come to know that I have to receive more amount on interest. That has been denied to me. Please give it to me.
I have always asked, requested for return. of
How
the
did
money.
you make this bank a party in the proceedings in the application?
My Honor, sorry, my lordship, the court has ordered to the bank to return back the money to the court. There is an order directing the bank to return the entire amount to the court. The entire amount was not transferred back to the court.
Correct.
Misappropriation has taken place.
Yes.
Now, since the amount has been paid by the court, I have been making so many applications, so many representations, even to the Honorable Chief Justice, I made a representation stating this amount has not been returned.
Yes.
Finally, I made an application on Order 21 Rule 93 seeking for the refund of the bid amount, which is
From
the
whom?
balance amount.
From whom?
But they have to pay.
Misappropriation is by
Misappropriation.
Sheriffadar of the
That is
court.
what I am saying.
No, there
The
is.
contention is you can make any claim
But how can I
against the
file a
court.
case against the court? How can I file a case against the court?
You can. Court means the registry. Because registry has deposited that amount into the bank. It is the duty of the court, if it has received any amount from you, you have a right to seek refund of that amount along with interest.
Now, if the bank doesn't
But
pay, will the court
if
pay?
you don't have any privity of contract with the bank, you have not deposited it.
I have deposited the court.
Correct.
I have made an application to keep the amount in fixed deposit.
Therefore, how can
My
you raise a
application was
claim
allowed.
against this bank?
No, I have made an application to keep the amount in fixed deposit. That was allowed. There is an order to refund money to me.
It is the court, the registry that has kept it in the bank, not you.
No, I admit that. But the money has to be returned to me. Once there is a EP is closed, entire money should be refunded to me.
Correct.
It has not been done.
Even if you want to reopen it, you can only maintain a claim against the court. Because you are saying, according to you, the amount that was deposited by you, which was kept in the bank to earn interest, they have not given you back the full amount and some part of the interest is not paid to you. When there is no privity of contract between you and this bank, how did you file the application against this bank? Is the question.
No, because the amount was kept in this bank.
All right. Barkale. The petitioner, Chief Manager of the Punjab National Bank, is before this court, aggrieved of the impugned order at Annexure A, dated 6th of March 2024. Full stop. Next para. The dispute arises in the background of certain undisputed facts that the respondent herein an auction purchaser in an auction held by the court deposited a sum of rupees 36 lakhs 10,000.
That is in one tranche.
84 lakhs 53,523.
No, that is the claim.
He submitted it in two tranches, my lord. One is 36,10,000.
So total is 8453.
No, 8453 is the amount which is due as on 2020.
No, no, how much did you deposit?
36 lakh 10,000
36 lakhs
10,000
10,000. That's all. Yes.
in 1996.
On 9/7/1995 and 22/9/1996.
No,
My lord.
both are 96.
There are two dates here.
9/7/1996 and
96 are the-
22/7/1996.
96.
22
9/7/1996 and 22/9/1996.
22/7.
22,
7, 1996.
22/7/1996. Bracket ಅಲ್ಲಿ wrongly mentioned as 9/7/1995 and 22/9/1996 in the impugned order. Close bracket. Full stop. Why it had to be repaid to you?
Because the auction was set aside.
The
What
auction,
happened was there was a settlement that was there between both the judgment debtor and the decree holder.
the auction was set aside consequent to the settlement of the dispute between the rival
DHR
parties
DHR and.
to the original suit. So, therefore, the amount had to be refunded to the respondent. Full stop. It is also not disputed that the court had directed the amount deposited by the respondent to be kept in a fixed deposit. And it is also not disputed that the amount deposited by the respondent was kept in a fixed deposit by the registry in the petitioner bank. Full stop. When the amount had to be refunded to the respondent,
My lord, if I may interrupt, I apologize. Prior to that, in 2002 itself, an application was moved by his advocate to transfer the amount from Punjab National Bank to Union Bank of India, which was allowed on 15/3/2002. That is also there in the impugned order, my lord.
yes, yes.
I- My lord, para 2. Para 2 states that we had, para 2 penultimate line, my lord. The Punjab National Bank has released 55 lakhs 27,722 as on 15/4/2002 to the court. Same was deposited in fixed deposit in Union Bank of India, Ashoka Road, as per court order dated 15/3/2002. Page 2, para 2 of impugned order, my lord, which is at page 19 of my typeset.
It is also pointed out that at the request of the respondent,
Yes, my lord.
So the respondents advocate without my knowledge.
and in terms of the directions issued by the executing court, the amount that was lying in the fixed deposit of the petitioner bank, along with interest, was deposited with the Union Bank of India, Ashoka Road branch, Mysuru. Full stop. The amount that was transferred and deposited was rupees 55 lakhs 20,722, in terms of the order of the court dated 15/3/2002. Full stop.
Can I interrupt?
Then you took back the amount from
The entire amount
Union
was,
Bank of India.
entire amount was directed to be deposited to.
All right, sir. I will
It was
come to
not-
you.
That was not done.
My lord, 7/3/2003, the EP was closed.
Page number
And
10.
on 24/3/2003, he received 57,91,464 from Union Bank of India.
How much?
On 7/3/2003, the EP was closed. And on 24/3/2003, he received 57,91,464 from the FD in Union Bank of India, Mysuru.
The amount deposited by the respondent was returned along with interest, and the EP was closed on 24/3/2003,
My lord, EP was closed on 7/3/2003,
7/3/2003.
and he received it on 24.
Stop. The respondent was paid rupees 57 lakhs 91,464 on 24/3/2003. Full stop. When did you file the application?
11th April 2003, there is a complaint filed by the principal
22.
civil judge in the Lakshmipuram police station.
23/12/2020, page 18.
Hmm?
Page 18, my lord, of my typeset, 23/12/2020.
Next para. Long after the respondent received the said amount, he filed an interlocutory application in IA number 53, na?
Yes, ma'am.
53 on 23/12/2020. Under Order 21, Rule 93, read with Section 151 of CPC. Contending that there is deficiency in banking service and the petitioner bank had failed to safeguard the amount in the fixed deposit kept by the court, and that the respondent herein was entitled for a sum of rupees 84 lakhs 53,523 as interest on principal amount, and the respondent also sought for compensation. Full stop. Next para. Learned counsel for the petitioner submits that although it was contended before the executing court that such an application could not have been maintained by the respondent, more particularly as against the petitioner bank, since the petitioner bank was not a party to the proceedings and there was no privity of contract between the petitioner and the respondent. Full stop. Next para. For contra, the respondent, party in person, seeks to contend that he received information that there was a fraud committed in the petitioner bank, and police action was initiated against
April 1990.
the then manager and staff,
Manager and the
staff of the petitioner bank. And it was found that the amounts kept in deposit by the court in various fixed deposits were misused and clandestinely siphoned off only to defraud the persons who had made the deposit in terms of the directions issued by the courts.
My lord, accused number 1 was the Sheristedar. Accused number 2 was the manager who expired since.
the manager was also dismissed from service by the bank.
It is also contended by the respondent that after action was initiated against the petitioner bank,
Bank has dismissed the
the
manager
then manager
of the bank was dismissed.
was dismissed from service.
My lord, I may point out it is not against the bank, it is against that individual, and thereafter it abated when on his death. It has been recorded in that court order.
The respondent, party in person, therefore submits that no infirmity can be found in the impugned order. Since the court has taken into consideration all the relevant aspects, including the contentions sought to be raised by the petitioner before this court. Full stop. Next para. Having heard the learned counsel for petitioner, the respondent party in person, and on perusing the petition papers, this court is of the considered opinion that the basic question that was required to be decided by the executing court on the instant application filed by the respondent party in person was whether such an application could be maintainable against the petitioner bank. Full stop. Admittedly, there is no privity of contract between the respondent and the petitioner bank. Full stop. The amount was admittedly deposited by the court staff into the petitioner bank. Full stop. Without going to the details of the amount that was deposited and the rate of interest and what was actually to be accrued out of the fixed deposit, this court is of the considered opinion that the writ petition has to be decided on the preliminary objections sought to be raised by the petitioner bank. Full stop. This court is therefore of the considered opinion that at best the respondent could have filed such an application as against the court itself, since on the directions of the court, the amount was deposited with the petitioner bank. Full stop. It is therefore the duty of the court to have returned the amount to the respondent after calculating the interest that is accrued in terms of the rate prevailing as on the date when the amount was kept in fixed deposit. Full stop. Therefore, when such application was not filed against the court seeking the refund of the actual amount which had accrued in interest. And since there is no privity of contract between the respondent and the petitioner herein, such an application could not have been filed by the respondent before the executing court. Full stop. Next para. In that view of the matter, this court is of the considered opinion that the impugned order cannot be sustained. Full stop. Accordingly, the petition is allowed. The impugned order dated 6th of March 2024 passed on IA number 53 in execution case number 214 of 1990 is hereby quashed and set aside.
Deeply obliged. My lord, if
Ordered
I
for-
may, interest, if any, may be added, my lord, because on merits also, it is very clear that it is something which he has.
Anyway, we are not going into the minutes. Yes.
Deeply obliged.
Case number 3. Further reading. 230 matter. Yes, Lokesh Ellen.
Mr. Samit has not come. Mr. Samit. Yes, Mr. Huh? Huh. ಇದು ಕೊಟ್ಟಿದ್ದು ಅವರು ಸಮಿತ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ಮೆಮೊ ಇದ್ರದ್ದು ಕ್ಯಾಲ್ಕುಲೇಷನ್. ಈ ತರ ಹಾರಿಜಾಂಟಲ್ ಆಗಿ ಇಟ್ಟಿದ್ದಾರೆ ನೋಡಿ.
ಕರೀತೀನಿ ಇಷ್ಟು
It's
You ask Mr. Amit.
My lords, I apologize, my lords.
ಇಲ್ಲಿ ನೀವು ಕೊಟ್ಟಿರೋ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ
Yes, my
memo,
lords. Yes, my lords.
although in page number 4,
Yes, my lords.
you have shown fees payable for commencement certificate and occupancy certificate.
Yes, my lords.
Page number 4 and 5, you have mentioned occupancy certificate and commencement certificate and occupancy certificate.
Yes, my lords.
Huh?
Yes, my lords.
But in your calculation, after that, you have said total fee to be paid to BBMP during construction.
I apologize, my lords. This would be only at the plan sanction stage because commencement certificate and occupancy certificate we have not computed, my lords.
That is not computed here.
Computed, my lords. Although we have set out what is the value as prescribed in the circular, what has happened, my lords, at the time of computation, we have computed only at the time of plan sanction alone, my lords.
Correct.
Only at the time of plan sanction.
So, because last time when we were reading the provision along with the learned senior counsel,
Yes, my lords.
we saw in the latest amendment for occupancy certificate, you'll have to pay 1%.
1%, my lords, because that is a completely different.
That would double the amount.
Yes, my lords, because this entire computation that has been done, my lords, is only for the plan sanction stage. Although I have set out, my lords, in B and C, the fees to be computed at commencement certificate and occupancy certificate. However, my lords may see that all the computation that I have set out is
So therefore, I would request you to give one more memo of calculation
along with the commencement certificate as well as the
what will be payable by the owner of the land for commencement certificate and occupancy certificate.
Very well, my lords. For the same table, I will add
We
on
have
to
now,
it. and
pursuant
submit.
to your lordship's direction the other day, my lord, yesterday, my lord, we have prepared one. We will give it to your lordship. Yeah, we will explain it.
Yes.
May- Our copy. Our copy. ಕೊಟ್ಟಿದ್ದೀರಾ? You got a copy. My lord, I'll just quickly explain to you, my lord, explain to your lordships, my lord,
Yes.
what we have put in this chart. My lord, let us take the first one, my lord. Once I explain one item, my lord, everything else will be the same. Now, my lord, we are looking at a property dimension of 1,168 square feet, a small property.
Yes.
About, as your lordship indicated, about 30 by 40 approximately. It has got a stilt, a ground floor, 3 upper floors, and it is residential in nature. My lord, total built up area, my lord, will be 247.2.
Ground, 3 upper floors.
Yes, my lord, because it's, yes.
We were giving Banchankri. Banchankri, that's it, we have given. The plan is also enclosed.
All right. Yeah.
And then, ಇದು square feet at
Square feet.
square. ಇಲ್ಲಿ ಮೇಲೆ dimension, square ಇಲ್ಲ, ಇಲ್ಲಿ square meter.
ಇದು ಮೇಲೆ 108.
My lord, 108.58 is square meters, my lord. And 1168 is square feet.
Correct.
My lord, that's how it comes. Yes. Then, my lord, your lordship may kindly see total built up area will be 247.22 square meters on the basis of the FSI and all that.
Yes.
Guidance value, my lord, is 53,000 rupees as per 45B, my lord. Now, my lord, the plinth area would be 46.36. We have calculated everything, my lord, according to the. Then, my lord, the fee for sanction plan is 1,62,000 rupees for that. Then, my lord, kindly see commencement certificate is only 2,703. And the occupation certificate fee will be only 1,179. Of course, if they deviate penalty, that's a different issue.
No.
Yes, my lord, that's how it is. ಅಷ್ಟೇ.
ಹಿಂಗೆ 1% ಇಂದರೆ
ಇಲ್ಲ
No,
ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ it is
ಅವ್ರು
not assessed.
No, my lord,
Not 9%.
my lord, in respect of the fee for sanction plan, we have added everything, my lord. Whatever has to be paid at the time of the sanction plan, ground rent, etc., ಎಲ್ಲ ಸೇರಿಸಿ.
You please see the provision.
Yes, my lord, I mean. My lord, respect.
Huh?
under the amendment.
Yes, that's what we
Yes.
said. Yes.
Under the amendment itself,
Amendment.
what we read was 1%.
No, my lord.
No, one.
TCE,
16A was the amendment.
240A,
It includes everything, sir.
240A,
Security deposit. Yes.
240A,
Yes, my lord. Yes, my lord.
A is for issuance of license.
Yes, my lord.
Rate not exceeding 0.30%.
Correct, my lord. Correct, correct. Yes, my lord. Yes.
Then D is for fee for commencement certificate,
Respectfully, my lord.
0.20%.
Yes, my lord.
Then E, fee for completion certificate at such rate not exceeding 1%.
Yes, my lord. Yes, my lord. Yes.
1% of guidance
Of
value
Guidance value
of the vacant site
multiplied by.
under
proposed
section 45B of the Karnataka Stamp Act,
Where is it?
multiplied by proposed built up area.
Correct, my lord.
ಹೆಂಗ್ ಬರುತ್ತೆ ಅದು?
One minute.
How can
I
we-
just get instruction. No, sir, D is included in which column? Well, I'll just get inside.
Yes,
One.
yes, yes.
ಅದು ಎಲ್ಲಿ ಬರುತ್ತೆ?
ಇಲ್ಲಿ ಏನ್
ಯಾವ
ಮಾಡಿದ್ದಾರೆ,
column?
ಪ್ರಾಬಬ್ಲಿ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್ ದಿ ನ್ಯೂ ಪ್ರಾವಿಷನ್ ಇನ್ ಟು ಅಕೌಂಟ್. ಈ ಹಿಂದೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರು ಅದನ್ನ ಹಾಕಿದ್ದಾರೆ.
ಇದು ಹಳೇದ ಹೊಸ ತಗೊಂಬ.
They have not taken into consideration the new provision.
I'll find out, my lord. I'll find out. If it is so, then I'll not.
I think that is what has
confuse issue,
happened.
ಅಲ್ಲ, ರೂಟ್ನಿ ಫೀ ಗೊತ್ತಾಯ್ತು ಇಲ್ಲಿದೆ. ಇದು 1 lakh.
ಹೆಂಗ್ ಬಂತು?
On the next page.
My lord, how this 1,62,000 has come is in the next page, my lord.
The next page. After this page. The calculation, demand note, challan.
ಅದಲ್ಲ.
The whole calculation is there for 1,60,000.
No, this is for sanctioning of the plan.
Please, Manoj.
In terms of the new amendment that you have brought in,
Please, Manoj.
for commencement certificate,
Please, Manoj.
you will have to pay 0.220%.
Please, Manoj.
I don't think that has also been taken into
No,
consideration.
that is there, my lord. Last but one column.
ನೋಡಿ, commencement certificate ಗೆ you see in the new this one. It is not
Yeah.
in terms of the
Upper limit prescribed.
Upper
by-
limit.
That is the prescribed. What we are doing is as per
0.20, my
this,
lord, is not exceeding.
Not exceeding.
0.20 that your lordships are referring to us, my lord, is upper limit.
We are going by this.
0.11 ಈಗ. We have put it 0.11.
where
ಕೊಡಿ ಅದನ್ನ. ಅವ್ರಿಗೂ ಒಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ. We have fixed at 0.11. My lord, what your lordships are putting to us, my lord, is the upper limit, my lord, in each case.
correct.
This is what.
ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರ ಶುಲ್ಕ.
ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರ ಶುಲ್ಕ ಪ್ಲಿಂತ್ ವಿಸ್ತೀರ್ಣಕ್ಕೆ 0.11%.
So for residential, it will be 0.11%.
Yes, sir.
For
Non-residential,
for commercial,
ವಸತಿ ಏತರ ವಾಣಿಜ್ಯ 0.18%.
now,
ಇದು ನಾನು ರೆಸಿಡೆನ್ಷಿಯಲ್ ಒಂದು ಎಕ್ಸಾಂಪಲ್
but ಇಲ್ಲಿ ನಿಮ್ಮ ಇದರಲ್ಲಿ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಅಲ್ಲಿ you have shown
0.11%.
0.11% is residential ಅಂತ.
Respect.
Now,
0.20 that
what
you are
about commencement certificate?
I'm sorry.
Sorry, occupancy certificate?
occupancy certificate, my lord, it is
Last column.
1179 ಅಷ್ಟೇ.
1,001.
Last column, my lord.
ಅಲ್ಲ, ಇಲ್ಲಿ ನಿಮ್ ನೋಟಿಫಿಕೇಶನ್.
ನೋಟಿಫಿಕೇಶನ್ ಇದೆ. 1179. ಈ 1179 ಹೆಂಗ್ ಬಂತು? ಈ 1179 ಹೆಂಗ್ ಬಂತು?
OCL.
ಅದ್ ಹೆಂಗ್ ಬಂತು? 1179 ಅದ್ ಹೆಂಗ್ ಬಂತು ಅಂದ್ರೆ ಲೆಕ್ಕ ಹೆಂಗ?
That is
ಯಾವ ಸರ್?
0.09% of
ಎಲ್ಲಿದೆ? ಎಲ್ಲಿ ಸರ್?
guidance value into total built up area. That is
My lord,
0.09% of guidance value into.
ಅವ್ರು ಹೇಳ್ತಾರೆ ಪರಿಶೀಲನಾ ಶುಲ್ಕ ಇದೆಯಲ್ಲ 0.009% ಮಾಡಿ ಅದನ್ನ ಲೆಕ್ಕ ಹಾಕಿದ್ರೆ 1179.
1179 ಬರುತ್ತೆ.
My lord, if your lordships are kind enough to see, my lord, on the first page, ಅದು OC fee is equal to scrutiny fee. Scrutiny fee, my lord, is at the first page at the bottom of the circular. ಕಚೇರಿ ಆದೇಶ ಪರಿಶೀಲನಾ ಶುಲ್ಕ 0.009%. ಅಲ್ಲಿ ಕೆಳಗಡೆ ಫಸ್ಟ್ ಪೇಜ್.
The provision says
Yes, my lord.
E.
Yes.
Provision says fee for completion certificate at such rate not exceeding 1%.
Your lordship, sir.
240A
Yes, my lord.
E.
Yes, my lord. That is for completion certificate.
Completion certificate.
Yes, my lord.
1%.
That is also maximum,
Ah.
not exceeding.
Correct.
Yes, my lord.
In your notification, what have they done? What have they done now?
We are not charging as per that, sir. Very minimum is charged.
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅದೇನ್ ಮಾಡಿದ್ದಾರೆ ಈಗ ವಾಟ್ ಅಬೌಟ್ ದಿಸ್ ಕಂಪ್ಲೀಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಷ್ಟು ಚಾರ್ಜ್ ಮಾಡ್ತಾರೆ
0.09% of.
ಈ ಕಂಪ್ಲೀಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲಪ್ಪ ಈ ಕಂಪ್ಲೀಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಚಾರ್ಜ್ ಮಾಡಿಲ್ವ ಇನ್ನು ಮಾಡೇ ಇಲ್ಲ ಏನು ಮಾಡೇ ಇಲ್ಲ ಏನು ಮಾಡೇ ಇಲ್ಲ ಐ ಆಮ್ ಟೋಲ್ಡ್ ಇಸ್ ನಾಟ್ ಬೀಯಿಂಗ್ ಲೆವಿಡ್ ಅಟ್ ಆಲ್
New circular.
ನ್ಯೂ ಸರ್ಕ್ಯುಲರ್ ಇನ್ನು ಲೆವಿನೇ ಮಾಡಿಲ್ಲ ಅಂತ ಅವರು. That is why this in this calculation, my instructions are, my lord, that this completion certificate doesn't find a place at all. Because my lord, this is only enabling. This doesn't say you have to.
But it has fixed a rate which
Maximum.
beyond all. ನೀವು ಲೈಸೆನ್ಸ್ ಗೆ you have said only 0.30%.
Yes, my lord. Fee for completion certificate
0.20%. ಇದು commencement certificate.
Yes, my lord. Yes,
But for completion certificate, it is 1%.
it is not 1%, my lord. It is enabling. I can levy up to. I may not also. Today it has not been done. My instructions are, my lord, that is 1% that for completion certificate.
0.09% of ground of the.
ಇಲ್ಲ ಅದು ಓಸಿಗೆ ಆಕ್ಯುಪೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕಂಪ್ಲೀಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನು ಮಾಡಿಲ್ಲ ಅಂತೆ ಈ ಸರ್ಕ್ಯುಲರ್ ಏನು ಹಾಕೇ ಇಲ್ಲ ಅವರು. ಇಟ್ ಇಸ್ ಎನೇಬ್ಲಿಂಗ್. So today, my lord, as per the calculation that I have, my lord, my instructions are that nothing is being levied.
No. You please see ಅನುಬಂಧ 2 in that notification.
My lord, I will see, madam.
ಕೆಳಗಡೆ.
Yes, my lord.
Second ಅನುಬಂಧ 2 ಸ್ವಾಧೀನಾನುಭವ ಪ್ರಮಾಣ ಪತ್ರ ಹಂತ.
Yes.
ಸ್ವಾಧೀನಾನುಭವ
That is occupation. Occupation
ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ಲಾಸ್ಟ್ ಇಲ್ಲ ಆಕ್ಯುಪೇಷನ್ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನಾಟ್ ಕಮೆನ್ಸ್ಮೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್. what your lordship point out, completion certificate ಇಲ್ಲ. ಕಂಪ್ಲೀಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಲ್ಲ.
ಕಂಪ್ಲೀಷನ್
ಇಲ್ಲ ಆಕ್ಯುಪೇಷನ್ ಬೇರೆ.
ಆಕ್ಯುಪೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ ಬೇರೆ ಯಾವುದು ಇಲ್ಲ ಇಲ್ಲಿ. There is no provision at all. Completion certificate only is occupation certificate.
Yes, they are one and the same.
One and the same, huh?
Yes.
They are one and the same.
Then my lord, it is only the
0.09%.
ಅಷ್ಟೇ. Occupation certificate fee, your lordship may say title on top, my lord.
ಅಲ್ಲ notification ಅಲ್ಲಿ.
Yes, my lord.
In the notification, they have made 2 columns. ನಿವೇಶನ ಸ್ವತ್ತಿಗೆ ಚಾಲ್ತಿಯಲ್ಲಿರುವ ಮಾರ್ಗಸೂಚಿ ದರಗಳಂತೆ ಪಾವತಿಸಿಕೊಳ್ಳಬೇಕಾದ ದಂಡ ಶುಲ್ಕಗಳ ದರ
ಪೆನಲ್ಟಿ
ದಂಡ ಶುಲ್ಕಗಳ ದರ ಪ್ರತಿ ಚದರ ಮೀಟರ್ಗೆ.
ಇದು ದಂಡ ಶುಲ್ಕ.
ಆಮೇಲೆ
ಇದು ಪೆನಲ್ಟೀಸ್. ದಂಡ ಶುಲ್ಕ ಅಂದ್ರೆ ಡಿವಿಯೇಷನ್ ಮಾಡಿದ್ರೆ ಪೆನಲ್ಟಿ ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಅಷ್ಟೇ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಯು ಆರ್ ಕಲೆಕ್ಟಿಂಗ್ ಸೆಕ್ಯೂರಿಟಿ ಫೀ, security deposit in order to ensure there is compliance with the sanction plan.
Yes. Yes.
So you are anticipating that everyone will violate. ಆಯ್ತು, ಅದ್ ಬೇರೆ ಪ್ರಶ್ನೆ. This what is it is referring to is danda, penalty that can be levied, and to what extent.
Yes.
Please see that.
Yes.
ವಲಯ ನಿಯಮಾವಳಿಗಳ ಕಟ್ಟಡ ಉಪನಿಧಿಗಳಲ್ಲಿ ಅನುಮತಿಸಬಹುದಾದ ಮಿತಿಯೊಳಗಿನ ಉಲ್ಲಂಘನೆಗಳು.
Yes, that is my lord, because
ಮಂಜೂರಾತಿ ರಕ್ಷೆಗೆ ಪ್ರತಿ ಚದರ ಮೀಟರ್ಗೆ 0.55%.
Yes.
ಇದು
if there is a violation from 0 to 5%. If it is 5% and above,
this is
the permissible
penalty leviable.
Yes.
But what is the fees that you are going to collect for granting occupancy certificate?
Occupancy ಸರ್ಟಿಫಿಕೇಟ್ ಮಾಡೋದು ಅವರು ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ, ಇಟ್ ಇಸ್ 0.009% ಅಂತ ಆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಕಾಲಮ್ ಅಲ್ಲಿ.
It is not in terms of the notification.
ಇದೆಲ್ಲಿ ಬರುತ್ತೆ? ಈ 0.99% ಸಾರ್ವತ್ರಿಕ ಇದೆಲ್ಲಿ ಬರುತ್ತೆ? ಇದು ಎಲ್ಲಿ ಬರುತ್ತೆ ಹೇಳಿ ನಂಗೆ ಸಾಕು. ಎಲ್ಲಿ ಬರುತ್ತೆ? ಇದೆಲ್ಲಿ ಬರುತ್ತೆ?
Notification ಎಲ್ಲಿದೆ ಅದು?
ಇದೆಲ್ಲಿ ಬರುತ್ತೆ? ಎಲ್ಲಿದೆ? ಒಂದ್ ನಿಮಿಷ, ಐ ಜಸ್ಟ್ ಗೆಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್.
These are all regarding penalty leviable.
ಇದು ಪೆನಲ್ಟಿ ಅದು ಬಿಟ್ಬಿಡಿ. ಇಲ್ಲ ಇದಕ್ಕೆ ಕೇಳಿ ನಂಗೆ ಈ ಸ್ಕ್ರೂಟಿನಿ ಫೀ ಎಲ್ಲಿ ಬಂತು ಅಂತ ಅಷ್ಟೇ. ಎಲ್ಲಿದೆ ಅಂತ ಎಲ್ಲಿದೆ? ಝೀರೋ ಇದು ಹೆಂಗ್ ಬಂತು ಅಂದ್ರೆ 0.009% ಇದೆ. ಇದೆನಾ? 0.009%, my lord, which is found in the last column in the table that we have given to your lordship, is found at the bottom of page number 1 of the circular. ಅನುಬಂಧ 1. ಅದ್ರ ಪ್ರಕಾರ ಇಷ್ಟೇ ಬರೋದು. ಈಗ ಫಾರ್ ಇಫ್ ಇಟ್ ಇಸ್ ಎ ಪರ್ಸನ್ ಹೂ ಇಸ್ ಹ್ಯಾವಿಂಗ್ ಎ ಸೈಟ್, ಮೈ ಲಾರ್ಡ್, ದಿಸ್ ಇಸ್ ವಾಟ್ ಹಿ ವಿಲ್ ಪೇ.
I am not able to find. Where is it?
At the bottom of page 1. I'm sorry, my lord. I'm very sorry. ಈ ಸರ್ಕ್ಯುಲರ್ ಇದೆಯಲ್ಲ ತಮ್ಮ ಕೈಲಿ, ಪೇಜ್ 1 ಅಲ್ಲಿ ಕೆಳಗೆ ಲಾಸ್ಟ್ ಲೈನ್ ಅನ್ನು ಬರೆದಿದೆ. I'm sorry, my lord, I couldn't point out.
That is ಪರಿಶೀಲನಾ.
ಅದೇ ಅಷ್ಟೇ. That is what is mentioned.
That is scrutiny fee.
ಅದೇ ಮೆನ್ಷನ್ ಆಗಿರೋದಿಲ್ಲ.
That is what they are charging, my lord. Whatever we may call it, whatever
scrutiny fee is provided for in ABC ಇದೆಯಲ್ಲ, scrutiny fee.
Yes, my lord. My lord, now I want to make it one thing clear, my lord. Yes. What is being, if a person has a property measuring 1,200 square feet and he wants to construct according to the available FSI, he will pay this much.
But there is nothing regarding commencement occupancy certificate.
Nothing. We don't charge because, my lord, it's not enabling.
Sir, when there is a provision,
This is enabling, my lord.
sir, it is our experience that it is highly impossible to get an occupancy certificate from BBMP. You can ask from any of your clients. It is next to impossible.
I am not disputing.
Next to impossible.
I am not
So
disputing.
therefore, ಅದರಲ್ಲಿ 1% highest fix ಮಾಡೋದ್ರಿಂದ, we cannot simply say nothing is contained in the notifications and therefore you are not going to levy anything. It is impossible.
0.9% of the guidance value.
My instructions are, my lord, that this is the statement that they are going to charge now. If a person
We can go by the provision and the notification.
the only provision, my lord, only thing I wanted to point out, your lord, is
You
it is
are
upper-
saying enabling provision.
enabling act.
For that, you have issued a notification.
How?
Now fixing the
How?
exact rates.
How?
And if nothing is found. in
Nothing is
respect of
chargeable.
Occupancy certificate.
Nothing is chargeable.
No, sir.
But enabling, my lord.
I don't know. If you want to make that statement, you can make it.
My lord,
I will record it.
my instructions are, my lord, I'll do one
Sir,
thing.
it is highly impossible. You can get
check.
back to the court next time. There is no difficulty.
There is no.
But I am very sure
I'll check. I'll check.
it cannot be like this.
No, my lord, I don't want to
Yes,
make
yes.
a irresponsible statement
better,
before your lordships. I will sit with
Yes,
with my learned friend and then
Clarify the whole.
clarify the whole thing to your lord.
Yes.
We'll do it.
Yes.
Your lordships wanted to know, if it is a person who is having a 30/40 site, how much will he
ಎಲ್ಲ
pay?
ಸೇರಿ ಒಟ್ಟು ಎಷ್ಟಾಗುತ್ತೆ?
ಇಲ್ಲಿ
I want-
ಇದ್ರ ಪ್ರಕಾರ he will pay, my lord, 1,62,000 plus about 4,000. He will pay 1,66,000.
ಇವಾಗ ಕೊಟ್ಟಿದ್ನಲ್ರಿ ಅದು ಕೊಟ್ರೆ ಅವ್ರು ಸಮಿತ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು. ಇಲ್ಲಿದೆ.
He will pay, my lord, a total about 1,66,000. Correct?
Now a memo has been filed by one of the learned counsels. You have a copy of that?
No, no, I don't have, I missed out a copy.
We had served it, my lords, on that day itself when it was.
It was served in the court also.
Please.
Anyway, they have also calculated in
Yeah,
terms of the demand that you have raised.
Please.
And in terms of the new provision.
Please.
Now let us.
In terms of the new provisions, my lords, it has been computed in terms of the entirely new provisions, whatever is new provisions, my lords. And if your lordship sees, they mentioned that they have computed for a guidance value of about 53,000. The closest that comes, my lords, is Gunjuru, which is about 50,000. If your lordship sees, Gunjur, the guidance value is 50,000, my lords. For that, the computation as per the new act for a plan sanction itself
Will
comes
be
up
around
to,
2,03,475.
yes, my lords.
Huh?
Yes, my lords.
ನಾವು ಹಾಕಿರೋದು it comes to about 1,66,000.
That is, demand is also enclosed.
I mean, my lord, as I
Because
mentioned,
there,
my lord, with respect to each particular demand, there may be some calculation error. That is that, my lord, your lordships may even direct the BBMP to work it out separately. After your lordships have decided on the question of the constitutional validity of the levy itself, then, my lord, if there is any variation, my lord, they can, corporation will sit up and then work with them and then find out how much is to be paid.
Just please have a glance.
We will.
The first column pertains to Jayanagar, second block.
Ah.
Nan kodtini. You please look at it.
My lord, we
The
will.
last column, Gunjuru, that what the
My lord,
Finance
reference
Council
said.
was mentioning. So you see the difference. In Gunjuru, for the same site, for the same built up area construction, if they are charging 2,03,475, in Jayanagar it will be 4,42,931.
Could be.
Is the difference?
Could be. But that
So
is,
this is
it is because of the guidance value.
huh?
It is because of the, yes,
Correct,
that's
correct.
that, my lord, the correctness of the formula is not dependent upon the result of the formula. Your lordships are now looking only as to whether the formula is right or wrong. If it is excessive, well, my lord, it may be foolish, but it is not illegal.
Insofar as 40-50 site is 40-60 site is concerned,
Yes, ma'am.
the same area,
Yes,
Jayanagar second block will be 8,40,948, whereas in Gunjur it will be 3,61,000.
Because of the guidance value.
Yes,
Yes, it happens.
that is.
Well, as I mentioned, my lord, your lordships today are examining the formula. And I must tell you, lordships, my lord, all those demands that have been issued to the petitioners are based upon the pre-second amendment.
Illa ad bere. I have asked them to calculate this on the basis of the new provision.
My lord, instead of taking.
Adalla, not that old demand that were raised. Adalla.
ಈಗಲೂ ಅಷ್ಟೇ.
In terms of this
In
new
fact,
provision.
my lord, in terms of this, if your lordships agree that the formula and the basis are constitutional and legal, then, my lord, my respectful submission to your lordships would be calculation, leave it to the authorities. My lord, otherwise, your lordships will have to sit down and calculate. That becomes an arduous affair. If we are right in the formula that has been adopted, my lord, what is the guidance value requires no debate because it is there in the as a notification. Then it's a question of arithmetic. Let them work it out. Your lordship's time need not be taken for the purpose of calculating. In fact, as I indicated, my lord, every one of those demands, your lordships may can set it aside. If your lordships are with us on the question of the formula, then as to how if the formula which your lordships, I believe, my lord, will uphold, then how much will it work out in terms of rupees is a matter of working out with the corporation. Because even today, they have to work out separately and issue demand notice separately to each of the petitioners. If your lordships are with me on the constitutional validity, obviously, my lord, the demand notices that have been issued cannot be enforced. Because the whole formula has changed now. I agree, my lord. Therefore, my lord, today, to look at the validity of the provision on the basis of the impact of the provision would be, my lord, I would respectfully say, looking at the problem from the wrong end of the telescope. Legality is what your lordships are looking at. So, my lord, all this calculation, of course, I am not saying your lordships should not look at it. My lord. Your lordships are looking at it to get a broad picture of everything.
All this has been argued because
yes,
they are saying, look at it. See, from the point of view of the subject matter brought before this court, which pertains to an application that can be filed by the owner of the land seeking permission to put up construction.
Correct. Correct.
Having that in mind, how can there be variance between a person who is owning a land in one particular place and another particular place?
Correct.
And even if there is a small difference, it's all right. But if the difference itself is so huge, would it not be arbitrariness?
No, my lord.
No,
The-
that is the-
the-
that
that's
is
a
the argument.
contention. My respectful submission is that just because the difference could be large, it doesn't make it arbitrary. Arbitrariness has to be determined on the basis of whether there is a guidance given, whether there is the legislature has given some indication as to how it is to be done, or is it left to the whims and fancies of the officer? No. In this case, my lord, it is not unguided, it is not uncharted. These are the tests that your lordships have laid down for the purpose of arbitrariness on Article 14. Is it uncharted? You, at such rate as you may deem fit, your lordships will strike it down next day. What do you mean by saying such rate as you deem fit? Today, it can't vary, as they say, my lord, with the foot of with the size of the foot of the chancellor. It can't be that way. Today, it is not that way. There is some indication given. You cannot do according to your whims and fancies. We have linked it to a particular formula, which is a statutory formula, which is not subjective, which is objective. So subjectivity is virtually zero today. If subjectivity is virtually zero, then my lord, my respectful submission is it is not arbitrary. These are the tests for determining arbitrariness. My lord, arbitrariness is not determined, in my respectful and humble submission, my lord, on the basis of the result a particular action will generate. It is dependent upon the process. Is the process arbitrary? If the process is not arbitrary, then the result can never be arbitrary. It may be oppressive, it may be foolish. That is how, my lord, I would, otherwise, my lord, it can't be, well, the court holds 1 lakh is reasonable. If anything is more than 1 lakh, it is unreasonable. My lord, why should it be? What is the reason why 1,50,000 rupees is unreasonable and why 1 lakh is reasonable, my lord? There is no, it's just a feeling in the mind.
Then probably we'll have to look at it from another angle,
Yes,
as to whether the classification.
Those are aspects that your lordship look at. I'm not sparing a moment saying no. Those are aspects that your lordship look at. Of course, my lord, whether the classification is reasonable, whether linking to guidance value is correct, those your lordships will look at. I'm not for a moment saying no. I'm only responding to the contention the petitioner saying, oh, look at this. For somebody who is in Hennur, he is paying X amount of money. Somebody who is in CBD is paying 3x money. Well, that is how it is. That is how it is even when you buy a property. If you buy a property in CBD, you have to pay. The percentage is the same. No distinction is being made with respect to the percentage. But distinction is made on the basis of the value, because property in CBD is more, property in Hennur is less. So I ask myself, my lord, how does that make the law arbitrary? Because the tests laid down by your lordships, my lord, to determine arbitrariness in Article 14 are the following. One is the independent of classification, my lord. That is an independent head. Simply to say it should not be arbitrary, your lordships have said, is the power given unguided? Is it without any indication? These are the crucial factors that your lordships have said. Like I just now mentioned, my lord, if the section simply said, at such rate as the commissioner may think just and proper, your lordships will next day strike it down. What is this? I mean, I can't stand up and justify such a, without any indication. Today, my lord, all that has been taken care of. That was the problem in the earlier, pre-second amendment. Though guidance value was there, percentage was not there. You could levy 100% of the guidance value. I mean, if theoretically speaking, my lord, somebody who is unreasonable case, 100% of the guidance value should be paid for sanction of the plan. Well, law provides for it. Your lordship will strike it down. Because not on the ground that 100% is excessive, your lordship will say this fixation of this 100% of the guidance value is unguided, uncharted, no direction, no parameters indicated, strike it down. Today it is not that way. So therefore, my lord, my respective submission is that the scope now for investigation by your lordships has in fact been reduced. That's mine. My lord, this I will take correct instructions, my
Yes.
lord, and revert back to your lordships, my lord,
Yes.
on the basis of this circular. How we will correlate it and get back to your lordships. Now, my lord, I was pointing out to your lordships, which was my lord, I was pointing out to your lordships, my lord, a judgment of the Honorable Supreme Court in Vivek Narayan Sharma's case, which your lordship gets it in volume 1. And your lordship put to me, my lord, yesterday,
Volume 1.
one point, my lord, which I want to also address and satisfy your lordships, my lord, that we are on a good wicket so far as law is concerned. Namely, how do you charge at different stages? One's at the time of license, another at the time of issuance of commencement certificate, third at the time of occupation certificate. How can you do this? I have two answers for it, my lord. I will, after I have cited Vivek Narayan Sharma, my lord, I'll place those two answers for your lordship's consideration. My lord, may I trouble your lordship to kindly turn to page 170, my lord, of this compilation.
17.
Yes, my lord. My lord, I was pointing out 170, my lord, I'm sorry.
170.
Yes, my lord. Paragraph number 100 and 218 onwards. And I was at pointing out your lordship's R.K. Garg's case
Yes.
at page 172. There are a few passages, my lord, which are relevant, which I shall place for your lordship's consideration. In R.K. Garg versus Union of India, another constitution bench of this court observed thus: another rule of equal importance is that laws relating to economic activity should be viewed with greater latitude than laws touching civil rights such as freedom of speech, religion, etc. It has been said by no less a person than Holmes Justice that the legislature should be allowed some play in the joints because it has to deal with complex problems. We do not admit a solution through any doctrinaire or straitjacket formula, and this is particularly true in case of legislation dealing with economic matters, where having regard to the nature of the problems required to be dealt with, greater play in the joints has to be allowed to the legislature. The court should feel more inclined to give judicial deference to legislative judgment in the field of economic regulation than in other areas where fundamental human rights are involved. Again, the constitution bench of this court in Sitaram Sugar observed, judicial review is not concerned with matters of economic policy. The court does not substitute its judgment for that of the legislature or its agents as to matters within the province of either. The court does not supplant the feel of the experts by its own views. When legislature acts within the sphere of its authority and delegates power to an agent, it may empower the agent to make findings of fact which are conclusive, provided such findings satisfy the test of reasonableness. In all such cases, judicial inquiry is confined to the question whether findings of fact are reasonably based on evidence and whether such findings are consistent with the laws of the land. As stated by Jagannath Shetty J. in Gupta Sugar, the court does not act like a chartered accountant, nor acts like an income tax officer. If I may add, my lord, the court does not act like a chartered accountant, nor act like an income tax officer, nor a revenue officer. I just added it, my lord, with your lordship's permission.
Yes.
The court is not concerned with any individual case or any particular problem. This is a complete answer to the problems that my learned friends are placing for your lordship's consideration. The court only examines whether the price determined was with due regard to the considerations provided by the statute and whether extraneous matters have been excluded from determination. This is a very limited scope. Recently, this court in Small Scale Industries Manufacturers Union of India had an occasion to consider the issue with regard to scope of judicial review of economic and fiscal regulatory measures. This court observed what is best in national economy and in what manner and to what extent the financial relief packages be formulated, offered and implemented is ultimately to be decided by the government and RBI on aid and advice of the experts. The same is a matter for decision exclusively within the province of the central government. Such matters do not ordinarily attract the power of judicial review merely because some class sector may not be agreeable and or satisfied with such packages policy decisions. The courts in exercise the power of judicial review do not ordinarily interfere with policy decisions unless such policy could be faulted on the ground of malafide, arbitrariness, unfairness, etc. There are matters regarding which judges and lawyers of courts can hardly be expected to have much knowledge by reason of their training and expertise. Economic and fiscal regulatory measures are a field where judges should encroach upon very warily, as judges are not experts in these matters. The correctness of the reasons which prompted the government in decision taking one course of action instead of another is not a matter of concern in judicial review, and the court is not the appropriate forum for such investigation. The policy decision must be left to the government, as it alone can adopt which policy should be adopted after considering the points from different angles. In assessing the propriety of a decision of the government, the court cannot interfere, even if a second view is possible from that of the government. These are matters, my lord, I would respectfully place for your lordship's consideration. Legality of the policy and not the wisdom or soundness of the policy is the subject of judicial review. The scope of judicial review of the government policy is now well defined. The courts do not and the court do not and cannot act as an appellate authority, examining the correctness, stability, and appropriateness of a policy, nor are the court's advisors to the executive on matters of policy which the executives are entitled to formulate. This court in small-scale industry manufacturers observed that the court would not interfere with any opinion formed by the government if it is based on the relevant facts and circumstances or based on experts' advice. The court would be entitled to interfere only when it is found that the action of the executive is arbitrary and violative of any constitutional, statutory, or other provisions of law. It has been held that when the government forms a policy, it is based on a number of circumstances. It is also based on experts' opinion, which must not be interfered with, except on grounds of palpable arbitrariness. It is more than settled that courts give a large leeway to the executive and legislature in matters of economic policy. A reference in respect could be made to the judgments of this court in so and so. It is not the function of this court or of any other court to sit in judgment over such matters of economic policy, and they must necessarily be left to the government of the day to decide, since in such matters with regard to prediction of ultimate results, even the experts can seriously err and doubtlessly differ. The courts can certainly not be expected to decide them without even the aid of experts. This is, my lord. And in fact, my lord, your lordship will recall, my lord, when the demonetization was challenged, this is that demonetization, where the Honorable Supreme Court said, well, we are only to find out as whether it is correct, whether it is legal or not, whether it is a good policy, not a good policy. It's left to. Similarly, my lord, my respectful submission is, here is a statute in the Second Amendment, 250. My lord, if I may, just trouble your lordship to kindly see page 181, my lord, para 254 and 255. With that, I'm done with the judgment and I'll go to the next point. The Constitution bench, this is the demonetization. What I'm reading to your lordship, my lord, Vivek Narayan Sharma's case is a demonetization case itself. The Constitution bench in Arkagar holds that the court would not have the necessary competence and expertise to adjudicate upon such an economic issue. The court cannot possibly assess or evaluate what would be the impact of a particular immunity or exemption and whether it will serve the purpose in view or not. It has been held that it would be wise for the court not to hazard an opinion where even economists may differ. It has been held that while examining the constitutionality of such a decision, the court must be resilient, not rigid, forward-looking, not static, liberal, not verbal. Then, my lord, same principle is mentioned, my lord, about demonetization, how you can't go into it. This is the judgment, my lord, in demonetization case. I strongly rely upon it for the purpose of supporting my submission, my lord, that the linking to guidance value cannot be said to be a subjective act. There is objectivity in it. Whether it could have been done in a better way, my lord, that's the second guess. Is this bad is a question. If any other way, like what your lordship put to me yesterday, my lord, use the schedule of rates. You know how much use the SR. But that will lead to each case, my lord, if I may say so, my lord, higgle-haggling on various aspects.
How?
My lord, what happens, my lord, is this.
See,
Whether.
they are going to give you the built-up area.
Yes, my lord.
Proposed built-up area.
Yes, my lord. They also have to tell me.
That is also the basis in your new provision.
Yes, my lord. They also have to tell me what their. They also have to tell me what is going to be that type of construction, because the schedule of rates depends upon the type of construction.
That you have not done even in the new provision.
No, I don't have to, my lord.
You don't have to.
I don't have to.
That is why.
Therefore, that subjectivity is gone. Otherwise, my lord, kindly see what happens. Today, a person who comes and says, no, sir, I'm going to build only putting red oxide flooring. I'm not going to put any exotic flooring. Tomorrow, he puts exotic flooring. So, my lord, I start a fight with him afterwards. But this has become a never-ending process.
But Why
Here,
should,
today I don't have to,
why should it make a difference to you?
because the amount of money I collect.
Why?
Because if his schedule of rates, if I collect on the schedule of rates, if it is red oxide flooring, schedule will be very less. If it is exotic flooring, schedule will be more. Therefore, if it is a percentage of the schedule of rates, then my lord, if it is X amount for under the schedule of rates for cement flooring,
For-
it will be 2X
No,
if it is
for-
exotic flooring.
For you as an authority to ensure that the building is put up in terms of the bylaws.
That is my job. But
That is
to-
your basic function.
Yes,
Here,
but then my lord, how am I? What?
in the present context, that power that is kept only with you. You are the only person who can sanction the building plan.
Correct.
No other authority has that power.
No. Yes.
So therefore, when an application is given to you, you are required to consider whether it will fulfill the requirements of the bylaw.
Yes, my lord.
Otherwise, you will not sanction it.
Yes.
That is the basic function.
Correct, my lord.
Therefore, how is it that you are trying to make a difference between what type of a building you are going to?
No, my lord. I was only reacting to the to one point that your lordships put to me, my lord. I am not saying I agree, my lord. It is I can't do it. That is exactly what I am saying, my lord. I was only reacting to what fell from the honorable court, my lord. Why not schedule of rates?
Yes.
Why do you want to go on the basis of guidance value? Is what your lordships put to me.
Yes.
Well, I was thinking, I said, if it is on the guidance, if it is on the schedule of rates is different for each type of construction. So I have to go into the type of construction also in order to determine whether item number so and so the schedule of rates applies or item number so and so the schedule of rates will apply. Now here, my lord, is a person who wants to construct a house comes and says, sir, I am not building a house with exotic flooring, sir. I am putting only ordinary cement flooring. Therefore, I come under item number 5, sir. I don't come under item number 10. I say, okay, and I sanction it. Tomorrow he puts the exotic flooring.
There is no such difference in the SR rates.
We don't
SR
know. SR rates varies. SR rates is such a fluid thing. It varies so constantly, my lord. It is, and SR rate does not have any statutory backing. I must tell you, lordship, that also. SR rate is only for internal guidance for the purpose of tendering. It has no statutory, it is not framed under any statute. Whereas 45B guidance value has statutory backing. So between what is decided by a few engineers sitting in the four corners of the room and preparing a schedule of rates manual to a exercise of a statutory power under 45B, I ask myself which is better and which is more reliable. Obviously 45B. But a schedule of rates is not enforceable in a court if I come to your lordships.
There has to be a connection between that and this.
Which one?
There has to be a connection
Between, my lord?
between the subject that you are trying to bring in and with what you are concerned.
Yes, my lord, I am concerned only with sanction.
You are only concerned
With
with
sanction.
the construction.
With sanction of the plan, not even what whether you may not even construct tomorrow.
Yes.
The moment you come to me and say, please put your seal on this construction, I am not concerned tomorrow whether you put up the construction, you don't put up the construction, that is entirely left to you. Therefore, my lord, I am now at this, I am only doing exactly what your lordships are saying. You are now concerned only with examination of the application for sanction of a plan. Your role as nothing more. My lord, I bow down. That is why, my lord, I don't worry about what construction you put up, whether or not you put up. You can put any exotic construction. I have no problem. You can spend crore of rupees on a property where 30 by 40 site. Do what you want. I am not concerned. That is why, my lord, this SR rate, what you put to, your lordships put to me, my lord, first has no statutory backing. SR rates have no statutory backing, my lord. In fact, the Honorable Supreme Court has held even a PWD manual, mandamus cannot be issued because PWD manual is only a guidance. It is an internal working. In fact, in G.J. Fernandez case, I think it's 1965 Supreme Court or 69 Supreme Court, question came up as to whether a it went from this Honorable Court, my lord, whether a PWD manual is enforceable as a mandamus. Supreme Court said no. Because it's simply a guidance document. It's a manual. Similarly, SR. SR is used only for the purpose of finding out whether a tender that has been given by a bidder is reasonable or not. If the SR is 10 rupees and your tender is 100 rupees, they may say, sorry, look at the difference. And in fact, even there, my lord, if SR has been fixed for 1 year and you are considering a tender 10 years later and you have not revised the SR, they will say you mark up the SR. All this is some ready-made, if I may say so, Khichdi formula. There are no statutory backing at all. Whereas 45B is not like that. It is a scientific, whether it is scientific or not, it is assumed to be scientific because it is statutorily done. It is upheld by this honorable court. So therefore, my lord, in a situation of this kind, what is the best way? There could be 100 ways of doing it. Your lordships put to me SR, there may be some other way. That's why, my lord, if there are 2 ways of doing it and the law has thought that one way of doing it is all right, can it be said that the court, while looking at the arbitrariness or otherwise of that provision, say, no, I think it is better to do it this way. My lord, that I respectfully submit, my lord, is not the domain of a court examining, my lord, the constitutional validity of a particular statute. That's my submission. My lord, your lordships also asked me yesterday one question, my lord. Why are you charging at different rates? And I told your lordships I have 2 answers for it. Why should you? Now, my lord, in fact, my learned friend suggested it to me, my lord, the other day. He said, suppose instead of multiple stages, multiple stages, I charge only at one stage. And instead of charging 0.0025%, I charge 2% at the first stage.
Yes.
Would it be valid? I asked myself. If multiple stages is wrong, starting at charging at first stage would be quite valid. And if I charge 2%, I asked myself, it will be most unreasonable to do that because a person can get a plan sanctioned. She pays so much of money, but that person may not build. Therefore, if it is split, as a matter of public convenience, your lordships may look at it that also. Look, don't pay everything at one stage. If you are not going to, you have no doubt come to me for a sanction. You pay something at the time of plan sanction. Maybe if you are not abandoning the construction plan for whatever reason, I am not going to ask you for more money. Because there's no question of commencement certificate, there's no question of occupancy certificate. And even if you're doing it, I am asking you in bits and pieces. My lord, I ask myself, is that not conducive to public convenience rather than asking them to pay 2% at the very start? Please look at it that way. So therefore, my lord, if it is a case of paying at different stages, then, my lord, it is, even if all the stages are gone through, it is more convenient to the public to pay rather than pay in one lump sum. Secondly, if you don't come to the second stage or the third stage for whatever reason, you don't pay at all. So therefore, there's so much of option given to the people. Is there a better way of doing it? Maybe there are better ways, my lord. I wouldn't know. The court would not know because we don't have that expertise, my lord, of public administration. Therefore, if it is viewed in that way, my lord, the answer to my lord's query yesterday as to why you are charging at different stages, my respectful submission is that seems to be an appropriate way of doing it. So that's my first answer to your lordships. The second answer, then your lordships put to me yesterday, my lord, what about, does it not amount to double levy? My lord, my respectful answer is, I do not make a distinction between a fee and a tax. I have already shown to your lordship the judgment of the Honorable Supreme Court where this has virtually been obliterated. I am not for a moment saying that for a fee, quid pro quo is not necessary. I am not saying that. For a fee, quid pro quo is necessary. But that type of rigor that was there between relationship between fee and service, or the quid pro quo, which the courts applied, has gradually been blurred. So today, while the concept may be there, it is not a case where your lordships will apply it as a rigid formula. Generally, can it go into the consolidated fund of the state or the consolidated fund of the corporation? Answer is yes. Can it be used for a purpose other than the cost of providing a service to A or B or C? Answer is yes. Can it be used for a purpose independent of the function of sanctioning the plan? Answer is yes. Can I use it for maintenance of road, providing public toilets, providing for water in streets where there are no public facilities? Answer is yes. It is not a watertight compartment. That is how, my lord, it has now been liberalized. As long as you are using it for the purpose for which you are for the purpose of the performing the functions which you are obligated to perform under the statute, that money can be used. At the start, is it being corrected for a service? Yes. After the service is provided, if there is extra money beyond the cost of providing the service, it can be used for any other purpose. Otherwise, my lord, the only provision, only revenue for the corporation would be tax on property and certain taxes on trade and profession, calling. Everything else is a fee. No, it's a question of managing a public institution in a sound economic manner. There are various sources of revenue. Fee is a source of revenue. It is not today to be looked at in isolation and say fee is totally different from tax. You collect, tax is only revenue. Fee is only if you spend 10 rupees, collect 10 rupees. Or if you spend 10 rupees, you can, even if you spend 2 rupees, the remaining 8 rupees can be spent only for the purpose of an office where plans are being sanctioned. You can't use it for providing public toilets or drinking water.
No, see,
that can't be done.
Another angle from which that argument was made,
yes,
that it will be double taxation, was having regard to the primary functions of the corporation.
Right.
Providing infrastructure,
yes,
roads,
yes,
footpaths, everything is the core duty of
absolutely,
the corporation.
Absolutely.
For that purpose, property tax is levied on every property, every building
yes,
in the city,
yes,
every year.
Yes, madam.
So therefore,
but that is not necessarily the only source from which I can collect money. If the
for that purpose, if you are saying you are collecting property tax for the purpose of maintaining infrastructure of the city,
yes, madam.
Can you again levy the same thing in another incident?
Yes, that argument is fallacious for the reason that this is a question of managing my budget. If I say I can maintain the roads, the parks, the public toilets, the water facility, and the lighting on the roads only by property tax, I may have to increase the property tax by 10 times. Instead, what I'm doing is I can't put the burden only on a person who is owning a property. I will also find other ways of collecting revenue. What is wrong about it? That is economic and fiscal management, my lord. How can the court, I ask myself respectfully, my lord, to you and put it to your lordships for consideration. How can the courts go into this question of fiscal management? This is exactly what the court should not do. Otherwise, my lord, tomorrow, are we going to increase the property tax by 100 times in order to ensure that all the money that is, all the expenditure for various infrastructure facilities that are bound to maintain is only from property tax? I can't distribute it equally among, I can't put so much of burden on a house owner. My lord, kindly see what's going to happen.
No.
But this is a question of managing, my lord.
You can make use of the funds.
Even for earning, my lord, even for charging, I must have a income and expenditure. Can I say that the income must only be from one source? It cannot be from multiple sources. That is what will happen if the petitioner's argument is accepted. But that will really result, my lord, in property tax being increased by 100 times. Should I not distribute the burden in a somewhat equitable manner so that one section is not unduly burdened? That is how it is, my lord. And this is clearly a case of fiscal management. Please don't interfere with that. Otherwise, my lord, independent of this case, my lord, if the court goes into the question, that will be question of making a budget. It will be undertaking a budget exercise, which is a very complicated exercise, my lord, as we all know.
On the question of double taxation,
I will come to double. It is permissible. Law is that in the constitution, there is no prohibition against double taxation. My lord, I'll give you a lot. This is the one. My lord, please look at one judgment. Exactly, my lord, on this point. Yes. His lordship. 1979, 1 SCC 137. Avinder Singh. My lord, exactly, my lord, on double taxation. The question was as to whether there is any prohibition under the constitution to levy double taxation. The Supreme Court said no, there is none. Para? Naka. Yeah. Yes. And
He
very good.
only discusses the branch.
No, no, then it's discussed in this case. very good.
This is only the-
Oh, yeah, I'm sorry. Sit down. Sit down. ಇದೆಯಾ ಅವಿಂದರ್ ಸಿಂಗ್ ಇಲ್ಲ ಸರ್ ಅವಿಂದರ್ ಸಿಂಗ್ ಇದೆ ಅವಿಂದರ್ ಸಿಂಗ್ ಗೋವಿಂದ್ ಸರ್ ನೀವು
This now you gave it.
Huh?
This now I gave it.
ಯು ಗೇವ್ ವಾಟ್
This is all these cases.
ಇದು ಕೊಟ್ಟಿರ್ತಾರೆ ಈಗ ತಾನೆ
Even.
ಐ ಆಮ್ ಸಾರಿ ಮೇಡಮ್
That's all right. You please tell me the
Yes,
name of the parties.
My lord, it is 1979 1 SCC 137. It is.
Sorry.
Six, I'm sorry, my lord, there are some picks up the papers. I apologize. ಎಲ್ಲಿದೆ ಇದು ಬೇರೆ ಪ್ರಿಯಾಂಕಾ which paragraph? Yes. My lord, may I trouble your lordship to kindly see page, my lord, it is report, my lord, is 1979 1 SCC 137. Our copy kotra?
Yes.
My lord, kindly see paragraph number 4. My lord, his lordship, Justice Krishna Iyer, my lord, in his inimitable style, has started this paragraph.
Yes.
The immediate facts which have launched the litigative rocket. That is his lordship's brand, my lord, of the immediate facts which have launched the litigative rocket need to be narrated now to get a hang of the core questions in the correct perspective. The state of Punjab in April 1977 under statutory power required the various municipal bodies in the state to impose a tax on the sale at all of foreign liquor at the rate of ₹1 per bottle with effect from 20th of May 1977. The municipal authorities having tarried too long or totally failed to take action pursuant to the directive, the state directly entered the fiscal arena and issued a notification under section 90 subsection 5 dated so and so, which read thus. I'm going to skip that, my lord. The notification issued under 95 read with section 92B of the Act was later modified marginally but survived substantially. The petitioner's licensees challenged its writers both as a contrary to statutory provision and as violating the Constitution. The triple shapes of the fatal constitutional pathology are: A. Section 92B of the Act suffers from the vice of excessive delegation or legislative abdication. B. There is no guidelines for the exercise of the vigariously wide fiscal power of the corporation or the government, which make it too unreasonable to be salvaged by Article 19(5) and too arbitrary to be equal under Article 14. And see, the order itself is vitiated by multiple infirmities. The principal invalidatory charge based on the Act is that 94 interdicts any tax already imposed. The present tax is on sales, and there is under the general sales tax law already a like levy on sales of foreign liquor in the state, and so the second fiscal venture is beyond government's power. We have to consider these grounds of attack on the notification, which are the emphatic submissions of Sri So-and-so who led the arguments. There are more subsidiary submissions urged by other counsel on a lower key, though, but we have to deal with them too in due course. Briefly, they are that in picking out for taxation from the broad spectrum of luxury goods or intoxicate foreign liquor alone, discrimination has been practiced. B. That even assuming that the government can exercise the power of municipal body, it may not do so without adhering to the procedural fairness implied in the explanation to section 92 applicable to municipal bodies, etc. A feeble plea that the tax is bad because of the vice of double taxation and is unreasonable because they are heavy prior levies was also voiced. Some of these contentions hardly merit consideration, but have been mentioned out of courtesy to counsel. The last one, for instance, deserved the least attention. Last one, my lord, that is double taxation. Least attention. There is nothing in Article 265 of the Constitution from which one can spin out the constitutional vice called double taxation. So this double taxation, my lord, if I may say so, is a red herring. There is nothing in the 265 doesn't say you can't double tax. It may be unwise. That's a totally different matter. Bad economics may be good law. This is a beautiful way of putting it, my lord. Bad economics may be good law and vice versa. Dealing with a somewhat similar argument, the Bombay High Court gave a short shrift to it in Western India theatres. Some undeserving comments, contentions die hard, rather survive after death. The only epitaph we inscribe is rest in peace and don't be reborn. My lord, this is typical of his lordship, my lord.
It has been used in many places.
Yes, my lord. So, my lord, let us stop this double taxation argument. Let it not be reborn again in this case. Rest in peace and don't be reborn. If on the same subject matter, legislature chooses to levy tax twice over, there is no inherent invalidity in the fiscal adventure, save where other prohibitions exist. Unless there is a law which says you can't, you can. Wisdom? Bad economics? Maybe, my lord, I don't know. But let it rest at that. This is a complete answer to this question of double taxation. You're collecting property tax. Why are you collecting here for the same purpose? I can. But in fact, my lord, this is not even a case of double taxation. The purpose for which the money which is collected may go into the common pool, which will be used for the same purpose. But the taxable events are different. The taxable event for house property is that you are the owner of a house. The taxable event here, or the fee that is collected here, is because of the fact that you come to me for a sanction. The two are independent, different taxable events. The money may be put in a common pot and used for the same purpose, but that doesn't mean it is double taxation. Even if it is double taxation, it is constitutionally not found.
So this different taxable events. Now you'll have to answer to these three stages where you are.
Yes, correct. There are three different taxable events.
No,
One
here,
is
here it is understandable. One is in a different context, property tax.
Yes.
On the owner of the property.
Correct.
Here it is for a person who approaches.
Correct.
With an application
Correct.
for
Correct.
Permission.
Yes.
There.
The first answer I gave to your lordships would be very material. If I had charged 5% at the time when you came in for application, this argument would not be available to the petitioners, that you're charging in different stages. Merely because I split it and say, look, I don't want to collect so much of money at the very start. I will collect it in stages. It becomes foul, my lord, I ask myself. How? Under what principle of law? In fact, it is public welfare that I'm collecting small amounts of money at different stages. In fact, it is said, my lord, that a good king must collect tax the way, my lord, a honey is collected by a bee, which will not destroy the flower. That is supposed to be the best principle, my lord, for fiscal management in Dharma.
But you should see the demands raised by them.
That is a different matter, my lord. Maybe bad economics. I am not
bad economics alla. ನೀವು ಹೇಳಿದ್ರಲ್ಲ ಈಗ.
ಹೌದು.
It should be as if honey, bee connecting.
Honey from a flower.
We have seen demands raised for more than 1 crore.
I agree, my lord.
1 crore for sanctioning of a plan.
I agree, my lord. It has to be possibly relooked. I am not for a moment saying no, but I am now arguing on law.
And that issuance of occupancy certificate again 1% andre.
ಇಲ್ಲ 1% ಅಲ್ಲ ಅದು.
Yes, it is so.
Provision
says so.
Up to 1% ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ. ಅದು 1% ಅಂತ ಎಲ್ಲಾನು ಅಪ್ಪರ್ ಲಿಮಿಟ್.
It doesn't say up.
ಎಲ್ಲಾನು ಅಪ್ಪರ್ ಲಿಮಿಟ್ ಸ್ವಾಮಿ. ನಾವು ನೋಡಿ.
It commences with that ಇದಂತ ಹೇಳ್ತೀರಾ ನೀವು ಸೆಂಟೆನ್ಸ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಎಲ್ಲಾನು ಅಪ್ಪರ್ ಲಿಮಿಟ್ ಅಂತ ನನ್ನ ಇಂಪ್ರೆಷನ್. ನಾನು ನೋಡ್ತೀನಿ, ತಪ್ಪಿದ್ರೆ ಐ ಅಪಾಲಜೈಸ್. ಮೈಲಾಡ್ ಎಲ್ಲಾನು 1% ಅಂತ ಅಪ್ಪರ್ ಲಿಮಿಟ್. ಈ ನೋಡಿ ತಾವು, fee for completion certificate at such rate not exceeding 1%. ಈ ತಾವು ನೋಡಿದ್ರು ಅದು ಅಪ್ಪರ್ ಲಿಮಿಟ್, ಎಲ್ಲಾನು ಅಪ್ಪರ್ ಲಿಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಮೇ ಬಿ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ವಾಟ್ ಎವರ್ ಎಕನಾಮಿಕ್ ಪಾಲಿಸಿ, ಬಡ್ಜೆಟಿಂಗ್, ದೇ ಡಿಸೈಡ್ ದಿಸ್ ಆಲ್ಸೋ. ಸೊ ಇಟ್ ಇಸ್ ಅಪ್ಪರ್ ಲಿಮಿಟ್ ಮಾಡೋದು, 1% ಅಂತ ಇಲ್ಲ. It is not exceeding 1%.
Now at least You have shown us a copy of the notification
House one.
fixing the rates.
Yes, it is all within the much less than the upper limit.
That difference also probably is because of this. Our model calculation is on the base of this upper limit. And what you have given is in terms of this notification.
My lord, that's
Probably
why,
that is the difference.
that is why I'm saying, my lord, the figures have to be reworked.
Ah.
My lord, I don't think the
But
demand
if there
notices.
is nothing given in the notification in respect of occupancy.
They can't charge.
No. ಹಂಗ್ ಹೇಳಕ್ ಬರೋದೇ ಇಲ್ಲ.
That's what I'll take instructions for.
Yes.
That's where I'll take instructions.
Yes.
Whether you, in spite of the fact that the notification is silent about occupancy certificate, whether they're still charging and I'll make a submission. Otherwise, it will be, my lord, irresponsible
Yes,
submission on my part. I
Yes.
won't do it. So all that I was at pains to point out, your lordship, my lord, that all that is provided for in A to G is all upper limit. Even H, your lordship, may kindly see, my lord. Even the penalty imposed for not obtaining commencement certificate, the commencement gets.
ಅದನ್ನ ಹಾಕಿದ್ದಾರೆ ಇವಾಗ.
ಎಲ್ಲಾನು
In the notification it is there.
ಎಲ್ಲ ಇದ್ದಾರೆ.
It is
ಎಲ್ಲಾನು
there.
ಮಾಡಿ. So everything is upper limit and the notification provides how much it is. That it has to be reworked. There is no dispute, my lord. You can't, because this notification has come now, it has to be done properly.
Yes.
So, but therefore, my lord, double taxation, no, it's not constitutionally foul. Point number one. Point number two, are these independent taxable events? Yes, they are independent taxable events. One is license, the other is commencement certificate, third is occupation certificate. They are all independent taxable events. Third, even if they are not, can it not be viewed as charging at levy at different stages?
I don't know. You are making a submission.
Yes, ma'am, I'm making a submission.
That I don't know how they will. react to that.
That's my submission, ma'am. That's my submission. That is my submission in answer to their contention. How do you charge at, if I charge at 5%, right, it is so unreasonable to say, give me 5% at the time when I'm sanctioning the plan. I will not charge you anything for commencement. I will not charge you for anything for occupancy. Right? Suppose a person abandons a building plan, the idea of building a house, still he is out by 5%. Why should it be that?
No. You have to levy fee. No, not that you don't have to levy. You have to levy. ಆದ್ರೆ ಏನಾಗಿದೆ ಇಲ್ಲಿ ಎಲ್ಲಾನು ಸೇರಿ ಅಗೇನ್ ಯು ಆರ್
ನೋ ಎಲ್ಲಾನು ಸೇರಲ್ಲ.
ಹೌದು.
ನಾವು ಎಲ್ಲಾನು ಸೇರಿದ 5% ಆಗ್ತಾ ಇದೆ. ಎಲ್ಲಾನು ಸೇರಿಸಿ if I had done it at the time of plan sanction itself, I would have charged a higher percentage. I don't want to do it. I have split it. I have spread it.
No.
Kindly see the notice. Kindly see the section, my lord.
A, B,
Yes,
C. A is for issuance of license.
Yes, my lord.
B,
Maintenance of roads, ground rent.
C, security deposit.
That will be returned, my lord. That's refundable. That is refundable. That's
G, scrutiny
the
fee.
commencement. D is
ಅಲ್ಲ, G, scrutiny fee.
scrutiny fee. Yes, my lord. Yes, my lord.
ಇದು
These will
ಎಲ್ಲ
be charged.
ಸೇರಿಸಿದ್ರೆ it will not be beyond 1%.
It won't be.
ಇದೆಲ್ಲ ಸೇರಿಸಿದ್ರೆ
ಸಾಲಲ್ಲ.
it will not be beyond
Yes, my lord.
1%.
The 1% at the top.
Huh?
1%
ಅದೇ
at the maximum.
It will not be beyond 1%.
Yes, my lord. Yes, my
Even the maximum limit.
Yes, my lord.
But while giving occupancy certificate, 1%.
That is also highest, upper limit.
So if you don't
Now,
mention-
suppose, my lord, I charged 2% at the time when the application for sanction of plan had been given. Then the legal attack will go, I ask myself.
Not that you should not charge. See how it looks. ಎಲ್ಲ ಸೇರಿ 1% you're collecting in the beginning.
Yes.
Commencement certificate 0.20%, all right, no
Correct.
problem.
Correct, man.
Similarly, when issuing occupancy certificate,
Yes.
if you had charged same something like 0.20 or 0.30,
Yes, madam.
understandable.
Yes, madam.
ಎಲ್ಲ ಸೇರಿಸಿ ಮತ್ತೆ double it becomes 1%.
Yes, madam. Completion is 1%. Yes, madam. Now, suppose I had added this 1%. Now, let us, just for sake of finding out the.
Ultimately, it boils down to how much are you going to collect in all?
In all, exactly. Ultimately, therefore, merely because it is split up, it does not make it illegal. How much we are collecting in all is not a matter for judicial scrutiny. how much in all is being collected? Suppose, my lord, at all, at this 2 or 3 different stages above the completion certificate, it is say 1%. Now it is 1% for completion certificate, that's the upper limit. It becomes 2%. Suppose I had taken 2% at the time of plan sanction. Then, my lord, this grievance would not be there?
No, it will be there. It will be there. That is what they are complaining
No, my
of.
lord, that it is being charged at different stages, that grievance will not be there.
It's also there.
No, my lord, that won't be there because I am charging only at one stage.
That's all right. Yes.
Instead of charging 2%, I am distributing that in different stages, making it easier for the citizen. Instead of parting with so much of money once, I am saying, okay, give it to me in installments. My lord, that is one way of ensuring, my lord, public convenience and not burdening the citizen. I ask myself, my lord, is that not the way of fiscal management? Because I have to earn money, plus I also have to ensure that citizens are not troubled. It is like the bee, my lord. Bee has to collect my honey, but the flower should not die. That's the way, my lord. And in this process, the question that I place for your lordship's consideration is, what's the role of the court? Minimum. That's the submission, my lord, I'm making in answer to all that has been said. Now, my lord, there's one other judgment. My lord, this is what His Lordship Justice Krishna Iyer said, my lord, in 1979 Supreme Court. There's one other judgment, my lord, that I want to place for your lordship's consideration. My lord, that is a judgment, my lord, dated 4th of January 2022. I believe it is reported, my lord, but I'm not able to get the report, but I'm giving your lordship a copy of the judgment. Your lordship may kindly turn to page 44, my lord. I know. I Would your lordship be kind enough to turn to page 43 of this judgment, my lord? My lord, I want to place for your lordship's consideration as one very significant, I would say, my lord, characteristic of taxation law, namely what is called as an aspect theory. Aspect theory has been explained by the Honorable Supreme Court and also by this Honorable Court. And I would say, my lord, that applies clearly. I will read that, my lord, that portion. Whether it is tax or whether it is fee, these principles are applicable. My lord, para 43, page 43, my lord.
Yes.
Even though the petitioner would contend that what is being taxed is the aspect of manufacture under the Central Excise Act, and the same taxable event of manufacture as subsumed in GST, even if such contention were to be accepted, it would amount to taxing of the taxable event of manufacture on 2 occasions, and unless there is any prohibition in law, such a levy would still be permissible. But what happened, as your lordships are aware, my lord, with the coming into GST, a host of taxes were subsumed into one. Today, my lord, we don't have central excise duty, we don't have customs duty, we don't have VAT, we don't have any of that. We have only one, there is GST. Now, my lord, in addition to GST, there was a tax that was levied with respect to tobacco products. The question was, if you are levying GST, which subsumes into it excise duty, why are you levying separate excise duty on tobacco? Was the contention. This was the contention. Now, my lord, can you see how the Honorable Court meets it, my lord? It must be noted that taxing statutes are revenue generation statutes. And in that context, levy, even if once the same taxable event, which may also amount to double taxation, is per se not prohibited, unless prohibition can be read into on the basis of any other constitutional available principle. The aspect as to whether the levy of excise duty, when considered along with other excise existing duties, including NCCD, has the effect of falling foul of constitutional guarantee, may be a different ground of attack. The observation of the apex court in Avinder Singh, that's what I place for your lordship's consideration, my lord, the judgment of His Lordship Justice Krishna Iyer, my lord, to the effect that if on the same subject matter, legislature chooses to levy tax twice over, there is no inherent invalidity in the fiscal adventure unless there are some other prohibitions is to be noted as laying down the correct position in law. The relevant extract is follows, my lord. I've already read, I'm going to skip it, my lord. Now, please be kind enough, my lord, to turn to page 45. Aspect theory. Another aspect that would require consideration is aspect theory. as referred to by both the petitioner and the respondent. The respondent, relying on the aspect theory, has contended that the aspect of supply as defined in GST Act, Article 246A and the GST Act would be distinct from the aspect of manufacture which is sought to be taxed by virtue of levy of excise, Article 246, Entry 84, List 1, and accordingly looked at from the subjective point of view of the legislature, a single subject from different aspects could be subject matter of different taxes. Same thing, looked at it from different way, different taxes. The petitioners have specifically contended that the aspect theory would not be applicable, as it would be applicable only where there is a dispute related to the field of distribution of legislative power between federal and provincial governments. In fact, in the case of Federation Hotel of Restaurant versus Union of India reported in so-and-so, the question that was considered was whether expenditure tax was in pith and substance actually a tax on luxuries, which was squarely covered under Entry 62, List 2, or it could be construed as a tax on consideration paid on the purchase of goods, which would fall under Entry 54 of List 2, and accordingly, the question of legislative competence of the Parliament was in question. The then Attorney General Parasaran had invoked the aspect theory by contending that there could be different aspects of the same matter constituting distinct fields of legislation. In effect, it was submitted that hotels may be taxed in their expenditure aspect by the union and the luxury aspect by the states. There, my lord, even if it was two different authorities, they said, yes, here it is the same authority who is levying a fee on different aspects of the same transaction. There, my lord, even where one levy was being levied by the central government, on the same, another levy was being the state government, the courts have upheld it. Here is the same authority who is saying, I will levy at stage 1, stage 2, stage 3. It's different aspects of the same transaction. That's why my aspect theory applies here with greater vigor than in the case where there are two different taxing authorities. That's how, my lord, even with the two different taxing authorities were upheld. In effect, it was submitted that hotels may be taxed in the expenditure aspect by the union and in the luxury aspect by the states. The Apex Court was essentially considering legislative competence of the Union Parliament, and it is in that context that the principle of aspect doctrine appears to have been considered and eventually held as follows. In the light of the above entries and decisions, I think that the learned attorney is right in urging that merely because 1987 Act as well as state acts levy taxes which have ultimate impact on the persons who enjoy certain luxuries, the pith and substance of both cannot be considered to be the same. The object of a tax on luxury is to impose a tax on the enjoyment of certain types of benefits, facilities and advantages on which legislature wishes to impose a curb. The idea is to encourage society to cater better to the needs of those who cannot afford them. For instance, luxury tax may, to cite a catchy example, encourage construction of Janta hotels rather than 5-star hotels. Such a tax may be on the person offering the luxury or the person enjoying it. It may be levied on the basis of the amount received for providing or the amount paid for or expended for enjoying the luxury. Conceivably, it could be on different basis altogether. The object of an expenditure tax, and that conceptually there can be an expenditure tax is borne out by Assamja, is to discourage expenditure which the legislature considers lavish or ostentatious. The object of the first would be to discourage certain types of living or enjoyment, while that of the second would be to discourage people from encouraging expenditure in unproductive or undesirable channels. If a general expenditure tax like that of 1957 had been enacted, no challenge to its validity could have been raised because it incidentally levied the tax on expenditure incurred on luxuries. The fact that there will be some overlapping then, or that here there is a good deal of such overlapping, because the states have chosen to tax only some types of luxuries as a center to tax, at least for the time being, only expenditure which results in such luxuries should not be allowed to draw a curtain over the basic difference between the two categories of imposts.
I think in the previous page,
My lord, yes, madam.
I think this becomes more important. See, the fact that two separate governments have been levying taxes.
Yes.
And it is permissible.
Yes.
Because there are under two separate entries.
Correct.
Here,
yes,
you see this sentence.
Yes.
The pith and substance of both cannot be considered to be the same.
Yes. Yes.
What happens in this context?
In this context, my lord, this concept of pith and substance is applicable when there are two different entities who are levying tax.
No.
There are two aspects, my lord. Pith and substance is a concept that is applicable when your lordships are looking at the entries in list 1 and list 2. that is the only place where, my lord, this concept of pith and substance becomes relevant. Now, in the present context, this pith and substance concept will not be applicable. I agree, my lord. In fact, that is why I said I am on a better footing, because it's the same authority who is levying a impost.
It will be another angle in which they can argue. It becomes even more difficult for you, because whether the same authority can levy taxes
Yes.
on the same subject in different stages.
In different stages.
They can-
Yes, exactly.
They can argue that.
In different stages. It can be on the same, like in this case.
Then
On the same transaction, two different authorities are levying. If two different authorities are levying on the
there is no
same,
difficulty, because they have the power to do that.
here, my lord, I'm only distributing it.
So that
I'm only
argument,
distributing it.
that argument or the reasoning is not found in these judgments.
Well, this is the extract, but the earlier case, my lord, was a case, this judgment related to the same central government levying tax, excise duty and GST. They applied this theory. My lord, this is a case, in fact, I argued this case, my lord. This is a case where central government is levying excise duty and was also levying GST. The argument that we advanced was, excise duty is subsumed in GST. How can you levy on excise duty and GST? Court said, yes, it can be possible, because aspects theory. In that context, they cited this judgment.
Let us see.
I understand, my lord. I'll just finish this, my lord. And
Yes, yes.
and then, my lord, I only have to answer one point that your lordships have put to us, my lord, on how can the commissioner do it.
Correct.
If it, that,
Yes.
that's the only point I have to answer, my lord, and I will.
Yes.
Kindly see page 49, my lord, after the quotation. Clearly, in the present case, the question is legislative competence of the union versus the state is not in question. The question is as to whether power under Article 246A, which is a tax on goods and services, if levied on a product, could also be subject of levy of an indirect tax on the same product in excess of the power under Article 246. While the power under 246A provides for a simultaneous levy by Parliament and subject to 246A to legislature of every state, on the other hand, power under 246 is with the union. The question of legislative competence under 246 with the 246A would not strictly fall within the ambit of the applicability of the aspects theory. Even otherwise, while it is the aspect of only supply which is a consideration by levying tax under GST, it is the aspect of manufacture that is the consideration by levying excise duty. That is the crux of this judgment. I would say that this applies on all fours in my humble and respectful submission for your lordship, my lord. It applies here. The crux, my lord, is I want to charge you a fee or an impost for enabling you to construct. I do it at different stages. It is one levy. It is for ease that I have spread it. It provides an exit for a person saying, I don't want to construct after I got a sanction plan, don't pay. Otherwise, my lord, kindly see the anomaly. Even if a person doesn't want to construct after having got a sanction plan, it could be any reasons. He has to pay. Why that much? Even otherwise, I'll just read this paragraph, my lord, and conclude. Even otherwise, while it is the aspect of supply which is the consideration by levying tax under GST, it is the aspect of manufacture that is the consideration by levying excise duty. Though it is contended by the petitioners that the aspect of supply was subsumed manufacture, and accordingly levy of tax would in effect be on the same taxable event of manufacture in the present case. However, a closer scrutiny would reveal that the legal taxable event under GST would be on supply, while on excise would be on manufacture, which are two different legally recognized aspects. And even if the incidence is on a single subject, the different legal aspect would not lead to an overlapping and would result in treating the levy of tax as on different aspects. This is what I'm saying, my lord. Sanctioning plan is one aspect. Commencement certificate is another aspect. Occupation certificate is a third aspect. It may be one single subject, but they are different aspects. Therefore, aspects theory will happen. And aspects theory, my lord, is now accepted law in taxation field in this country. And then, my lord, last portion, last 4 lines on the next page, 51. Even otherwise, even if it is considered to be a tax on the same aspect, unless such levy of tax falls foul of other constitutional safeguards, it would per se not vitiate levy of tax. Same principles would apply to fee, is a submission. I just have to deal with that particular point, my lord, and then explain this chart. With that, my lord, I would have answered all the legal issues, my lord. Again, on factual issues, my lord, whether it is, of course it has to be redone now. There's no question. The demand notices necessarily today will have to be revised having regard to the second amendment. No question about it. If your lordships come to a conclusion that the second amendment, everything is valid, you can proceed on the basis of 45B, then we will have to redo it. We'll do it.
There is another
My lord.
problem
My lord.
having regard to the fact that the judgment rendered earlier was not questioned either by the state or the BBM.
Yes, my lord.
There is a direction given to refund the amounts.
No, my lord. There is no direction given.
Huh?
No, my lord. There is no direction. Kindly see
The
that. No, my
direction.
lord. No, my lord. Please look at the direction given. Kindly see. There is no direction given. Please see, my lord, what has been done. Please be kind enough to turn to
What is it?
H.
He's 166.
Insofar as refund, in fact, earlier paragraphs are there, my lord, when I'm reading the conclusion. Insofar as refund in other petitioners in all these petitions who have deposited certain amount in terms of the interim order passed by this court before this court are entitled to refund. Whatever is deposited in the honorable court. Next, my lord. Insofar as refund in other cases who have paid to the corporation under protest, they shall be entitled to such refund only if the same is not collected from the consumers of the apartments, businesses, as the case may be. That is, my lord, there should not be unjust enrichment. There is no absolute direction to refund. And then, my lord, insofar as all other payments made, they would all be at liberty to give representation to the BBMP, and the BBMP would consider the refund of the amounts in accordance with law and the findings of this court. Ashte. There is no direction to refund.
No blanket.
There is no blanket order saying I must refund the money. That is why, my lord, this is a validation act. In the act that has been passed after this judgment, it is validating, which is permissible. Validating is a well-accepted exercise done by the legislature. There are so many validating acts are there, and it has been upheld a number of times, my lord. Legislature has the power to validate. And that goes back to the first question.
Tomorrow there's a
Well, I can do it on Saturday, man. Saturday.
Ah, Saturday.
Saturday is the working
Yes.
day. I'll finish
All
it, my lord, on
right.
Saturday.
My lords, I have just one minor point.
Huh?
My lord, if your lordship
Come on.
see the demand that was given today, there's one demand for road cutting fee.
That was always there.
My lords, that there's no.
That was always there.
Basis in 265. In the demands in my matter, that is zero. That's why I've not challenged. it, but
Because
here they're challenging.
For every new house that is constructed, new construction that is made, you need water connection.
My lords, but 240A does not support it.
No, that.
Article 265 violation, because 240A does not permit collection of road cutting fee unless they can point out the legislative basis for this.
Now the legislative basis is the second amendment, which
There's no
says
road
for
cutting fee.
maintenance of roads, etc., etc. Well, you cut the road, I got to maintain it.
But I think that provision that we were discussing, that nenne ಹೇಳದ್ನಲ್ಲ ನಾನು 223.
The constitution.
ಅಲ್ಲಲ್ಲ.
My lords, 229 and 231, my lords.
229 and 231.
Yes.
It makes, you please see, there is a provision for cutting the road.
Please
There itself there is a provision.
But under 240.
231, my lord. Your lordship point out 231 to us.
My lords, under 240A, this is not a levy that can be imposed at the time of plan sanction.
See, 231 talks of open breakup. See, this is all because every new construction, they cut open the road to have the connection.
Maybe.
One for water, another one for BWSSB.
Swage.
My lords,
Sewage.
Yes. Very well, but 240A does not permit this. There's no levy here. There's no levy in 231, there's no levy in 240A.
That is why, my lord, we go back to the definition of ground rent as per the second
Ground rent,
amendment,
Then ground rent
which
and.
provides for maintenance. My lord, if they cut it, should I not maintain it?
Then ground rent and lay.
That is why, my lord, there are two aspects to the second amendment. One is
charged.
One is,
Allah, no, please take instructions.
yes, ma'am.
They are going to charge separately for that.
Yes, under this demand they produced.
ನೀವು ಹಂಗೆ ಹೇಳಿದ್ರೆ they will not be able to levy again.
No, but they can. I am saying they can.
No, sir.
Because double taxation is permitted.
Allah, there is no substantial provision. That is what they are
265
pointing out.
violation. Nowhere.
There
in
is
the
no substantial provision now, as of now, even now.
Yes.
For road cutting charges.
Ah,
Without the second amendment.
ಹೌದು.
I'll check that.
You please
I'll-
clarify that.
I'll check it out.
Your lordship's kindly,
Yes.
but serial number 31 in the order is first list, my lord.
Ah.
Lordship may kindly have it tomorrow.
I can't give dates to any of these matters.
Naale that is, there is some.
Serial number 47, my lord. Serial number,
The Saturday, 2:30.
serial number 47, my lord.
No dates to any.
No, serial number 47, my lord, there is some urgency.
Wherever stay, if the stay may be extended, my lord.
There is no need, sir. If the matter is not reached, the order sheet will remain as it is, isn't it? Then
one submission, serial number 23, madam.
2:30 ಅಲ್ಲ? 2:30 ಗಾ?
Saturday 2:30.
2:30 ಅಲ್ಲ? Your question is answered.
First lead serial number 20.
Sir, ಎಲ್ಲ next week ಬರುತ್ತೆ sir. All matters next
First
week.
lead serial number.
Please, all matters next week.
Date fix ಮಾಡಿ.
Remand will be as it is. That date ಯಾವ್ದು?
The date fix ಮಾಡಿ next week ಬರೋದಿಲ್ಲ.
Next week ಅಂದ್ರೆ next Thursday na Friday ಅಥವಾ ಇದು Tuesday na? Just.
I think 2 weeks.
Sir, next week.
Sir, not, sir, reach ಆಗದೆ ಇರೋದು ಯಾವ ಡೇಟ್ಗೆ?
ಸರ್ ಯಾವ್ದು ಮೇಡಮ್ ಯಾವ್ದು ಡೇಟ್ ಕೊಡಕ್ ಬರೋದಿಲ್ಲ ಕೇಳಕ್ ಬರ್ಬೇಡಿ. It will be listed next week.